Just before we gavel in here today, just a little PSA. We are working on the temperature in here. We're going to keep the doors open until the temperature drops to an appropriate or comfortable level, but we are working on it. Our apologies. All right, let me gavel in. Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Thursday, January 22nd, 2026. We have 9 bills on the docket. We're going to start off with Senator Hester with Senate Bill 8. Then we're going to go to 171, 180, 64, 66, 131, 221, Senate Bill 1, and then we'll round out the day with Senate Bill 245. Senator Hester, welcome. The floor is yours.
Thank you very much for your consideration of Senate Bill 8. Chair Smith, Vice Chair Waldstraker, and members of the Judicial Proceedings Committee. I'd also like to thank Senator Love and Senator Hedeman and Committee Counsel for their help on this bill last year. This committee did hear this bill last year, and it's in the same form. And it is absolutely essential that we pass it this year to strengthen Maryland's ability to combat identity fraud by addressing the rapidly evolving threats posed by artificial intelligence and deepfake technology. Just to refresh your memory, the rapid advancement of AI has made it easier than ever to create highly realistic synthetic media, including altered images, videos, and audio recordings. Now, while those tools have legitimate uses, they can also present serious risks when misused for fraud, harassment, or deception. The malicious use of AI-generated content to impersonate individuals threatens personal privacy, financial security, and public trust in our digital systems. The consequences of this misuse are very real. They can include financial harm, as victims suffer economic losses from unauthorized transactions and identity theft, sometimes made significantly easier by AI-generated voice cloning used to defeat voice identification systems. They can also include criminal activity, as AI-generated content can be used to create counterfeit identification documents, including fake driver's license, fraudulent credentials for law enforcement, government, and banking institutions. And unfortunately, they also include emotional and physiological distress, as individuals experience severe personal and reputational harm due to manipulated or falsified content. As this committee will remember, in 2024, there was a troubling incident at Pikesville High School that underscored the urgency of this issue. The school's athletic director used deepfake technology to create a false audio recording of the school's principal, leading the public to believe the principal had made racist and anti-Semitic remarks. While the technology used was not particularly advanced, in fact, it cost less than $5 a month, This incident was a clear warning. Anyone with minimal resources can now use AI to commit identity fraud. As we look towards the 2026 election, artificial intelligence creates a real risk of identity fraud against candidates, threatening the integrity of our electoral process. A bad actor could create a convincing deepfake of you or of me or anyone using hate speech and spread it online to manipulate voters. Without this bill, colleagues, there is little or no legal recourse to stop the harm or hold anybody accountable. Other states have already acted. In 2024, New Jersey introduced bipartisan legislation extending identity theft laws to include fraudulent impersonation through AI and deepfake technology. Arizona, North Dakota, Hawaii, and Washington have also taken action in this space. Maryland must do the same thing to protect its residents from this growing threat. I want to be clear about one thing. We are not criminalizing AI, right? It holds enormous promise and opportunity. What we are criminalizing is the intent to defraud. At its core, presenting false representation of someone using AI is a form of identity theft. Senate Bill 8 ensures Marylanders are protected from this identity fraud by criminalizing AI-based deception, prohibiting the use of AI deepfakes to impersonate or falsely depict individuals with the intent to defraud, mislead, or cause harm, including physical injury, serious emotional distress, or economic damages. This bill also creates a clear path to justice by establishing a victim's right to bring civil action and authorizing courts to order restitution for the cost of identity theft, including reasonable attorney's fees. It modernizes Maryland's law by expanding the definition of personally identifiable information to include biometric data such as voice prints, iris images, and digital signatures, while also providing clear carve-outs for artistic expression, including drawings, cartoons, sculptures, and paintings. SB 8 also strengthens the penalties by tying the penalties to the value of benefits obtained or the harm caused, and by imposing stricter consequences for crimes involving multiple victims. It enhances enforcement by granting law enforcement broader authority to investigate and prosecute identity fraud across jurisdictions. Maryland must act now, this year, to address the dangers posed by AI-driven identity fraud. Senate Bill 8 provides the necessary legal tools to respond to these emerging threats and to safeguard our communities. Thank you for your consideration, and I respectfully urge a favorable report of Senate Bill 8.
Excellent. Thank you very much, Senator. We will now turn it to the committee for questions, or actually, let me see if anyone else is. Sorry, I'm going to bring up your panel, Ms. David and Mr. Cox. Come on up.
I've been chosen to go first. Thank you, Mr. Chair, Mr. Vice Chair, members of this committee. I'm John Cox. I'm Deputy State's Attorney for Baltimore County. Also here speaking on behalf of the Maryland State's Attorneys Association. I want to thank Senator Hester, Senator Love, and Senator Hedelman for the sponsorship of this bill. It's something that's very important by personal experience. I come here as the case study that was mentioned by Senator Hester during her presentation. I was one of the assigned prosecutors in the case involving the Pikesville principal. It's a very compelling story and something that I have vivid memories of just going through the criminal law article trying to find a crime for what he did. We got lucky because it happened inside a school, so I had a very minimal crime that I could deal with. But this is a circumstance in which this principal, I remember hearing it when it first went viral. The audio of him appearing to say very racist and anti-Semitic comments about his students. And action was immediate. He was pulled from the school. The reaction was incredible in terms of all the calls that were coming in, the threats that were being directed. This was a circumstance where none of us would ever want to have imagined to have gone through this. We got lucky in that the officer who was then sent to us to protect him picked up on this and then starting to investigate it. And it was discovered, obviously, that this was all manufactured. What we ended up finding out was that the athletic director had secretly recorded a meeting with the principal and then took that recording and sent it off to a company and sent a script with it, and back came this recording. When I was preparing for trial, I met with the people that helped us to discover all this and said, I want to do a little demonstration in the courtroom. So they went online and they found me speaking about another case in some media broadcast. They took that voice and they sent it off to this company. and within 10 minutes, they had back me doing an unusual rendition of Rapper's Delight. That was how easy it was to do. This is something that must be addressed, and we ask for your support.
Now, you know we're going to ask to hear the recording of Rapper's Delight. All right. Thank you very much, Ms. David. We'll now turn to the committee for questions. Senator West.
Thank you, Mr. Chair. So, Ms. David, nice to have you questioning. The committee probably doesn't know Ms. David's parents and my wife and I are very good friends. And so I consider Ms. David a very good friend. But
not the two of us, our parents.
Yeah. But as I read this and start to think about it, I think about pranks, malicious pranks sometimes perpetrated, certainly at the high school level, college level, and even beyond, by people who think things are funny, but of course the person who the prank is pulled on frequently doesn't think they're funny. And the bill provides that if you engage in this conduct, you could be convicted of a felony and put in jail for 5 years. So how do we, or should we, try to distinguish, on the one hand, a stupid prank which someone finds highly offensive and maybe hurts that person's reputation on the one hand, and somebody who does what was done in Pikesville, where you're really trying to hurt and cause a person to lose his job on the other? Is there a dividing line? Does this bill find a dividing line which would separate the one from the other? I wonder if you could help us on that.
Yeah, great question, Senator. And I think that actually what's important to highlight is that this is in our existing identity fraud statute. So in our identity fraud statute now, right, the use of personal information with the intent to defraud is a crime. That would include your name, that would include your address, et cetera. So we are already, what we're doing here is adding AI to sort of the mechanisms of a way that somebody can commit identity fraud. But we are not changing the fact that that already is a crime. And so we are already under this statute making that assessment, right? Because of the use of someone's name, if someone were to create a cartoon about me and use Sarah David, right? that would probably be as applied, First Amendment issues, all of those types of things. So we are already making that assessment. So the reason we put it in the identity fraud statute, as opposed to some of the other mechanisms that we had thought about, or that, is that we're already in that criminal space. So just as all the prosecutors are assessing that when it comes to the use of our names, when it comes to the use of our addresses, we're going to now make that assessment with that use of AI as well. So that delineation hasn't changed. This is merely adding artificial intelligence to a mechanism that people can commit identity fraud.
Okay. Well, let me then ask Mr. Cox. You're a prosecutor, a line prosecutor. So let's assume, I think you have to stand up at the podium, I'm afraid. So let's assume that somebody has used AI to create something which that person felt was a harmless prank, but it turns out that the person who was pranked feels that it really is hurtful. And the case is referred to you as a prosecutor. How is a prosecutor going to deal with the fact that the person who you bring in as the defendant is going to probably start crying and say, I didn't mean to, I had no idea what I was doing, that it was that I didn't know it was a crime. Please don't put me in jail. Under those circumstances, how does a prosecutor handle the situation?
Well, obviously, we're vested with the discretion. There are certain times when maybe if something very technically fits a law, we decide that it's not appropriate to criminally prosecute. So that can happen. In addition, though, the way this is worded, the sections referred to as the felony, it says that a person may not knowingly, willfully, and with fraudulent intent take these actions and also cause harm. And then harm is defined as either physical injury, serious emotional distress, or economic damages. So there are lines drawn within this that take you away from just your prank type situation.
Okay, I'm looking at subpart 2, little I. It says to impersonate, falsely depict, or claim to represent another person with the intent to defraud, mislead, or cause harm. So I get the cause harm part. The person's going to tell you, I didn't mean to cause harm. I just was pulling a prank. But certainly mislead would fall into that category, would it not? Couldn't the prosecutor have said, well, maybe you didn't mean to cause harm, but you sure meant to mislead, and therefore you've committed a crime, and we could prosecute you to the full extent of the law?
Well, Senator, if you step back up to the beginning of that in 2, that's where it has may not knowingly, willfully, and with fraudulent intent. That applies to that also.
Right. Okay. I think your answers are pretty good. I'll have to think about it more, but thank you for giving me your answers. Sure. Appreciate it.
Thank you very much. I'd like to just push a little bit on what Senator West was talking about in terms of, I guess, the discretion. What is, Mr. David, you had talked about some sort of an analysis that one does in order to determine the distinction between someone who's trying to cause harm versus a prank. Could you walk us through that analysis?
So what I was explaining is that, so we have to make that analysis, that part of this law is not being changed.
Right, so what's the analysis?
So the analysis is sort of whether to, to come back to the language of the statute, what was the intent? And if an intent is satirical or to cause humor, that's protected under the First Amendment. And so when people are doing things, and that's really why we designed this way, by putting it in the identity fraud statute, we're taking it out of the space where somebody who is designing something to be funny, where somebody is designing something and that is, by the way, a defense essentially that someone can raise to a case brought against them. And this happens in all of our statutes where we're navigating this type of intent. So I'll use a different example because it might be clearer. When we talk about cases involving like revenge pornography, right, it has the same intent element, right, to cause harm. But somebody could say that their intent, in fact, was not to cause harm. Their intent was for personal pleasure purposes and not to cause harm to the person, right? That's a defense somebody can raise, but we use the facts surrounding the circumstances to determine the intent. So what are the clues we would use? The context of what was done. sometimes text messages or communications about it before and after, conversations, witnesses. That's where the investigation takes place. And so that's how we determine what the intent was and whether we can prove intent.
And I'm glad you brought that up as an example, because I can think of times when this body is given discretion to state's attorneys, like, for instance, sexting. And we've been trying to deal with this issue about what happens when juveniles are sending naked pictures of one another back and forth. And we know that there have been some prosecutors who have used it in the way to prosecute juveniles, when I think a number of us didn't. Certainly the statute wasn't made or intended to be used for that purpose. So that's helpful. The next question that I have is as I'm looking at the definition of personal identifying information. So in the example, in the Pikesville example, I guess using the voice falls under the term voice print, and that's on page 4, line 4.
Page 4. Yes, so that's already in the statute. Yes.
Right. So if Pikesville were to happen, this were to pass, Pikesville were to happen, the person's voice would be deemed a voice print, and therefore personal identifying information.
So let's sort of divide. So what we're doing here with this statute is we're criminalizing it when it's the use of essentially AI or the synthetic media. This is sort of taking my voice from me speaking here and taking that actual voice and applying it to something that would give you access to something you wouldn't have in another space. So what is existing in the statute is not the use of AI, right? And that was the difference in Mr. Cox's case, because it was not, they used the person's voice to change what the person was saying. What this voice print is alluding to is somebody taking my words from this hearing and using it to open a secure, use it for my bank security or something like that. Okay. So that would be the enhancement that we would be using, is that if somebody were to take this hearing and use my voice to say something completely different, right? That would be what we're criminalizing now.
Okay. And I guess the question that I have is, we're all focusing on Pikesville, but I guess what I'm wondering is, what else is this going to be used for?
So we're focusing on Pikesville, but actually I bring up the revenge pornography case because that is an area where this is quite rampant. Okay. And I see Senator Folden nodding because there was a case actually out of Frederick, and my colleague isn't here to talk about that case, but where young girls' images were created in this space. And again, to actually your point, the defense was, my intent was not to cause them harm, right? My intent was for to have these images for myself and enjoy them. And that's a litigation issue that we have to deal with. But this will also deal with sort of what could be mass misinformation. And so the challenge that, Senator Hester alluded to when she talked about campaigns is that, of course, you can lie in campaigns. Everybody here knows that. Everybody here is comfortable with or maybe uncomfortable with that fact. But the issue is that there is a difference when it is fraudulent using AI. There's a difference between, and this is an actual example that happened not in the United States but in another country, there's a difference between me putting out a message that says Sarah David was arrested versus creating an AI image of me being taken out of my house in handcuffs. That was done to a candidate. Totally false. And so
that could be prosecuted under this?
Yes. And again, potentially, right? Because there's all these other factors related to intent. If it was Sarah David is being arrested for a humorous purpose, right? Or something that wasn't intended for people to believe it to be true, right? That would not be prosecuted. But the way that it was used was in an election in the other country to imply that that candidate had in fact been hauled off in handcuffs. And so these are the types of things we want the tools to prosecute. And I want to be clear that it's tough to take these hypotheticals without the investigative context and say this will be prosecuted, this won't. We want the tools to be able to investigate these things and make sure that we're not having the level of misinformation that AI allows sort of be an exemption to something that people's identifying information is already at risk for.
So the creation, using personal identifying information in a political context that's meant to be harmful could be prosecuted then?
Well, you would have to prove the intent to harm, right? And that's the important part. It can't just be a satirical intent, political intent, all of those other things are still protected.
And harming meaning, okay, so let's talk about harm. What is harm?
So harm is defined in the statute. I'm defined. Hold on, and we'll go to it together. It's on page 2 and line 14. So physical injury, serious emotional distress, or economic damages. And that's, again, borrowed from where we've seen a lot. This is from the same sort of language that is in the other sort of sextortion, revenge porn. Actually, we just did it for threats to election judges last year as well. And the reason is because this sort of encompasses what we're seeing in the digital world, seriously harming people. And so that's the definition of harm. And that's an element that we have to prove.
And I could see, if it's the political context, it would probably be some sort of serious emotional distress. I mean, if somebody's putting a video out of one of us being arrested a few days or a few weeks prior to an election, I could imagine that would cause emotional distress. So again, I'm just trying to push and see where this is.
And it's a good back and forth, because these are the back and forth that we're having on these cases. You know, like Mr. Cox, I'm also a prosecutor. I had an identity fraud case in trial last week, in fact. These defenses are always something that we have to navigate, because people are saying, you know, my intent was not to defraud, right? My intent was, you know, it was a mistake, or I was trying to do X. So we always have to have an investigation to prove the intent. And to your point, yes, someone could be upset by something. Is that serious emotional distress? That's the question we have to evaluate in each case individually.
Thank you very much. Thanks.
Thank you, Mr. Chairman. You can just, I was going to ask the senator, but I don't want to, no, I'm just kidding. We had a discussion earlier. She loves coming back to this committee, so I just wanted to, for that moment, just, so, look, I just want to be very clear. This is the first thing I thought of when I saw this and when I'm reading this is it's like any other element of the law. You must always show the intent. It doesn't matter if it's this law, it doesn't matter if it's, you know, a theft of property. You must always show the intent, which would be in the theft to deprive of their property or something to that effect. So it's an important component in any facet of law, the intent. And it's always something that the prosecution must look at and take into consideration. Is that fair?
Yes.
Okay. And then the other part is that it's really, this is pretty simplistic in its approach, in my opinion, because it looks at it as knowingly, willfully, and, not or, knowingly, willfully, and with fraudulent intent. So again, that falls in line with that malicious misconduct that we would be able, or that you would be able as prosecutors, that you would have to prove to get any type of conviction on this. Fair?
Absolutely.
Okay. And the harm part, we beat it to death. I just wanted to say thank you for bringing the bill. I think it's a necessary and good bill. Thank you, Mr. Chair.
Thank you. And I apologize for being out of the room, and thank you, Senator Hester. Yeah, you know, I totally support what you're doing here. But I just want to have a technical question on intent. It's been a while since I've been in law school, but it's not so much that I don't understand intent. I just want to know, are there any nuances or complexities when you're in this space of identity, you know, fraud or imposters? In other words, I think in some cases of elsewhere, intent can be kind of prima facie because of certain things that have been done. Does that work there? Can you speak to it very briefly about any complexities or differences, or that everything is copacetic? But I do want to kind of understand, I think there are prima facie or things that get done that are self-evidently considered intentional, that I just want to make sure we're all aware of.
So if I were to categorize some of the things that are pretty clear in identity fraud context as intent, it would be like an application for health benefits in somebody's name with their social security number, right? Where you would obtain those types of benefits to go, you know, these types of, those things are pretty clear. Or to the example that I gave to Senator Sidnor of somebody taking my voice to open my bank account, right? You know, I mean, those types of things, again, people can always argue accident, et cetera, but those are more straightforward. Where it becomes complicated, again, is in these contextual situations where we're dealing with something that has, you know, that could have different types of intent. And that's where our investigation, as I've alluded to in these cases with like revenge porn and other things, you know, we have to do an investigation to make sure that we can prove the intent.
So with those, just like any other case, you would just do cumulative evidence that, you know, in beyond a reasonable doubt, jury can sort of see the 20 things that you pieced together that this actor did that wasn't so obvious, and you can just cumulatively say, okay, this is an intentional act to harm.
Right. Well, and prepare to litigate it.
And
right. That's what we have to.
right,
we can't say this is.
Okay.
We can get the evidence together to prepare to litigate it.
So, and the last short question, you can get back to me on this. Have you seen a consistent defense to those more complex cases that you hope this bill addresses, or that maybe we'll have to deal with down the road? Some things that you're like, okay, this is a space where we keep stumbling, or there's pretty good opposition, but it's not the kind we want because it's not helping us solve the problem.
So when it comes to identity fraud, generally there are many. The issue, though, here is that we don't have anything right now. Nothing.
Well, that's true.
Criminalizing this sort of AI. So when this happens, right, we're outside of our statutory scheme. And so the important thing is this is new. This aspect is new.
Right.
We haven't been, when we have gotten cases, as Mr. Cox alluded to, you know, he had to go through the law book to try to fit the square peg in the round hole. What we're doing here is, and we're still behind, but we're trying to keep up with the technology in addressing how identity fraud is manifesting itself now, right? Which is different than it was, you know, 20 years ago, and frankly will be different than it is in 2 months, 5 years, et cetera. So this is a really important
so
tool.
this law has to be drafted in a way that it can keep pace.
Yes.
So it's not so definitive. Keep pace with what's to come.
Yes.
All right, thank you, Mr. Chairman.
Thank you, Mr. Chair. Sorry to have a second bite at the apple, but as I listened to the colloquy between, I think, Ms. David, largely you, and Senator Sidner, and then Senator Folden, I realized that maybe we could solve this problem. You talked about if something fell under the grounds of satire or parody or spoof or something like that it wouldn't be prosecutable. But there's no language like that in the bill. Would you be willing to work with us on an amendment to the bill which would have a carve-out or an exception in the event that someone is able to say that what I did was intended to be a parody or a satire or something along those lines?
So here's the issue with that. And again, it's not an issue with the fact that that is the law. It is an issue with sort of creating that type of list in a statute that has a broader purpose. So the issue right now is, as I described in the case that I had last week, right, that's an identity fraud case that was not related to AI. Okay, so that's somebody, and let's use the example I was using here, somebody obtaining benefits, right? The defenses to that are very, very different. They're not going to defend it with satire. They're not going to defend it with parody. They're not going to do those things, right? So you've created an exhaustive list of defenses related to sort of one very narrow aspect of the bill that already exist as applied. So we're not really concerned with a First Amendment challenge facially to this bill because of the intent elements and because it's an identity fraud. The exhaustive list of things that you're referencing are already defenses. To put them in here would make it seem like the other ones were not. And I think that we have to be very cautious about creating these lists in a statute, because then sort of a different defense would seem, that it couldn't be raised here. And so this bill isn't sort of a bill that implicates the same First Amendment issues where we have to use the satire and everything else in it. An example would be in our election law statutes, we often get First Amendment as applied challenges to those statutes when we bring criminal charges. I wanted to remain anonymous. I wanted to whatever. None of that language is in our election law listed because they vary. So when we talk about something that's not a facial concern but is an as-applied concern, listing things tends to create complexities with it. Happy to sort of defer to the senator about working with the committee, but I think that that's sort of why this isn't here, because this isn't a facial First Amendment challenge. This would be an as-applied to a myriad of different examples in different cases.
Mm-hmm. Thank you for your answer.
All right, further questions from the committee? All right, seeing none, thank you all very much. Thank you, Senator. Thank you all. With that, that'll conclude the hearing for Senate Bill 8. We'll now move on to Vice Chair Wallstreicher with Senate Bill 171.
Thank you, Mr. Chairman. We have heard and passed this bill previously, so I will be brief. But if you recall from previous sessions, our mail theft statute in Maryland dates to 1713. In other words, the statute predates our country, predates this legislature, predates the establishment of the state of Maryland. In my legislative district, we've had a huge problem with mail theft. Now, that includes a number of different aspects. It includes standard stealing from people's mailboxes, but in my legislative district, it's also included two things that are much more serious, which is robbing mail carriers at gunpoint or knife point and stealing the mail that way, as well as the stealing of the skeleton keys that those mail carriers use to open up the blue boxes, and then theft from the blue boxes themselves. And so the theft of mail, of U.S. mail, is a federal offense. But what we found from the U.S. Attorney's Office is that they generally reserve those prosecutions for theft of mail upwards of $1 million. And we now know under the current federal administration, even that type of prosecution has been de-emphasized in favor of what this federal administration is focused on. And so what we need to do is to have a tool for our state's attorneys at the local level to prosecute what the federal government does not have the resources to prosecute. So this bill modernizes our 1713 mail theft statute and addresses the concerns that I've seen in my legislative district and that many of you have seen in your legislative district. Let me tell you why we're back, because I thought it would be useful to be candid about what's happening between the House and the Senate regarding this legislation. The House has taken a strong concern with porch piracy. Porch piracy is a real thing that is happening in all of our legislative districts and usually involves packages that are delivered by private operators, by folks driving for Amazon, UPS, and the like. And there's a member on the Judiciary Committee who has been a victim of this and rightly so wants to address porch piracy. And so the reason these bills have gotten held up is because there's been an emphasis in our chamber on addressing the U.S. mail issues and an issue in the other chamber about addressing porch piracy. To my recollection, I think we actually passed the House's porch piracy bill last year. We'll check on that. But I think during this session, we're all going to get on the same page. These issues are not in competition with each other. Porch piracy is an issue. We need to address it. It is separate statutorily from mail theft because the mail is the U.S. mail, and we need to address the U.S. mail as well as protect our mail carriers as well. So with that, Mr. Chairman, I will ask for a favorable report on Senate Bill 171.
Mr. Chairman, members of the committee, nice to see you. And I want to thank Senator Wallstreicher for his leadership on this bill. It's important because before I came in today, I decided to see how much of an increase there has been of mail theft in the last 3 or 4 years. And WBAL reported that in 2019, there were 2,474 reports of thefts from mailboxes. To 2023, 5,242. So it's doubled. I haven't seen the figures from 2024 and 2025, but I'm guessing they're probably as high, if not higher. The tool that prosecutors in Montgomery County in Maryland need is, I had a case literally finished yesterday. It was a mail fraud, mailbox theft case. 2 women had somehow gotten an arrow key, which an arrow key is used to open mailboxes on the street. They got a hold of a USPS cap and a USPS carrier bag. And they were seen on video removing mail, opening the box and removing mail from the mailboxes. They were stopped a couple of days later for a traffic stop. And the car was searched and they found in there over 350 letters that had been stolen, along with the USPS bag and the hat. In those letters were thousands and thousands of dollars of checks. One of the checks was from the American Oncology Association to another medical group for $197,000. Now, this is important. Because the theft statute allows me to prosecute on the face value of an instrument, a negotiable instrument, I was able to charge theft over $100,000. If all of that mail had been blank checks or just simply letters, and I'll finish, just simply letters, we would have been able to determine that the value of this paper is essentially nil. And so we would not have been able to prosecute. This helps us with that, and I'll be glad to answer questions specifically related to the theft thresholds. Okay?
Good afternoon. Thank you, Chairman and members. I'm Stephen Sultan. I'm a United States Postal Inspector and the Acting Chief Counsel for the U.S. Postal Inspection Service. The Postal Inspection Service is the federal law enforcement and security arm of the United States Postal Service. Our agency works diligently to enforce criminal laws to protect the U.S. Postal Service employees, customers, and our nation's mail stream. Unfortunately, over the past few years, mail theft and robberies of letter carriers has risen dramatically. In the past, this criminal activity was predominantly committed by lone actors and small informal groups. Now it's become common for large, organized criminal groups to become involved with these crimes. Many of the robberies of carriers are now for their postal keys, sometimes also called arrow keys, as you heard. These keys permit access to collection boxes, outdoor parcel lockers, cluster box units, and apartment panels in a given geographic area. Once in possession of these keys, these criminals are able to steal U.S. mail from these receptacles. This mail is then used to commit financial crimes with often devastating financial effects to the victim. This includes to elderly and other vulnerable populations. The Postal Service has taken significant efforts to address this increase in postal crime. We're upgrading collection boxes, high security features, including electronic components. We're raising awareness through public education messaging and training our employees and law enforcement partners. We've stepped up our enforcement of the laws that protect our employees and the nation's mail, and we're collaborating with prosecutors and other law enforcement agencies at the federal, state, and local levels. This legislation would enhance that enforcement effort. It would supplement and not replace or usurp federal laws and would further the collaboration that's already occurring. While federal charges may be appropriate in some cases, or for some members of a criminal enterprise, state charges may be more appropriate in others. Postal inspectors are proud to work diligently alongside local Maryland law enforcement and prosecutors to protect Maryland Postal Service employees and customers, and to keep Maryland Postal customers' mail safe. I recognize that your constituents depend on the Postal Service for safe and reliable transmittal of mail, and this bill would enhance our ability to carry out this mission. Thank you.
Thank you all very much. Senator.
I have a question for the sponsor. Thank you, Senator, for bringing this. You said what year that we haven't, how old has this been going on? How long does this date back?
So
changing the...
Yeah, so the statute originally, it dates from 1713. And I thank counsel for pointing this out
1713.
to us.
So
Yeah.
you've had probably a hard time researching. I mean, things have changed, right? We've gone from zip drives to flash drives, microfiche, parchment paper, stone tablets. And I'm just offering some help here. We happen to have a senator who's retiring from this committee, and I have been doing some research. And while he was not an attorney, but I did see on a stone tablet that he was a law clerk. And he may be able to help us if we want to fix this, if there's any kind of issues that somebody may have for this. And so I tend to believe that this may help with the passage of this bill. Isn't it so?
Yeah, absolutely.
Thank you.
Thank you. Thank you for bringing the bill back. Thank you for explaining where we've been stumbling and possibly move forward. And I appreciate the bill, and I fully want to support it. I just need to understand one small part of this. Getting these keys, right? That's part of this. Is it your understanding that the criminals that are doing this have any kind of inside information about what is in the
Yeah, I'm going to defer
boxes
to the
for
postal
keys,
inspector.
so that it would be more fruitful than just, something else? Or are all of these storage places from keys always have quite a lot of money and other valuables in them? So I just want to kind of understand this.
Yeah, I'm going to defer
All
to
right.
the postal inspector, but I'll just give you what I understand it to be.
Yeah.
The skeleton keys are obtained, so I don't think anyone has inside information as to what is into the particular box.
Okay.
But I think they obtain the key probably in 3 different ways. So there's postal workers who are being assaulted for their keys. And so that's just basic, strong arm robbery.
Right.
There are postal inspectors who are postal workers who are in on the theft,
Right.
who provide the key. And then there's just basic life. You lose something, you put it down, and someone else picks it up. So
You just, Senator,
Yeah.
you just made me think of one quick thing. When we had so many robberies, if you will, many places started to keep no cash, and do other things in addition to surveillance. Has anybody considered having these postal workers truly not have access to them in a way a thief could take them from them? Is there a more modern approach to that? I'm still all supporting the bill. I'm just wondering about that.
yeah.
Oh, thank you for your question. So as far as knowing what's in there,
Yeah.
We don't even know what's in any of these boxes. However, what they do, it's called a volume attack. You hit enough boxes, you're going to get something
Right.
of value.
Got it. All right.
So that's what they're doing as far as that's concerned.
Right.
As far as keeping control of the keys,
Yeah.
we do have a process of this called accountable property. They take the key out, they check it out, and they're supposed to bring it back and check it in. We're also enhancing our system so that these blue boxes or these boxes that are out there are going to be locked electronically, so that you'll be able to do it with your device.
So I'm getting too speculative, but I imagine that there will be a time when facial recognition, eyes, biomarkers or something could then replace keys, but that would benefit so many different circumstances. But for now, we have keys, and that's what we got to do. All right, thank you all.
Thank you.
All right, thank you very much. Further questions from the committee? All right, with that, that'll conclude the hearing and the testimony for Senate Bill 171. Thank you very much. We'll now move on to Senator Sidnor with Senate Bill 180.
Good afternoon, Senator Charles Sidnor for the record, speaking on behalf of Senate Bill 180. Because I know that we're going to have an extended evening, we've heard this bill numerous times. The Senate has passed this bill a few times, and it ends up just not being able to get voted out of the House. What the bill does is it allows fair housing testers to use their phones to make audio recordings of their fair housing testing that is going on in order to ensure that the Fair Housing Act is being properly followed. That is the gist of it. Again, we've passed this, not unanimously, but we have passed this out of the House, and I won't want to prolong this any longer than necessary, but I am here and have our Attorney General's office to speak about more technical aspects of the bill. Thank you.
Good afternoon, Mr. Chairman, members of the committee. It's good to be back again on this bill and to see the committee again in this session. My name is Jonathan Smith. I'm Chief of the Civil Rights Division of the Office of the Attorney General of Maryland. Senate Bill 180 creates a very limited exception to the two-party consent rule for recording conversations for the sole purpose of testing in aid of enforcement of our fair housing laws. In many cases, the recording of a fair housing test will be the best evidence that's available in court that discrimination is occurring and will facilitate effective remediation. On behalf of the Civil Rights Division, we support this legislation and urge a favorable report. I think it's important to note what the bill does and doesn't do. What the bill does is, if it's enacted, trained fair housing testers will be permitted to record a conversation with a housing provider. Only a trained tester working for an authorized program will be able to make a recording, and the recording can only be used for the purposes of enforcing the fair housing laws. The bill does not authorize the recording of a conversation to which the tester is not a party, excuse me, the use of the recording or the use of the recording for any other purpose other than for fair housing testing. Fair housing testing has long been used to root out discrimination in housing. Testing was a strategy that was first pioneered by Dr. King in Chicago when he used black testers to document racial steering in housing prior to the enactment of the Fair Housing Act. More than 40 years ago, in the case Havens Corporation versus Coleman, the United States Supreme Court recognized that the value of fair housing testing in establishing discrimination in the housing context. Since then, testing evidence has been routinely used in both state and federal courts by government agencies and others. It is the best evidence. It will resolve disputes between what was and was not said. House testing is currently taking place throughout the state of Maryland. We engage in testing at the Office of the Attorney General. We use the testimony of the tester to prove our cases. This would allow you to actually put the recording in front of the judge so the judge could hear what was said and what wasn't said, and it would be the most effective way to resolve disputes. We urge a favorable report. Thank you.
Excellent. All right. Thanks. Ms. White, you're up next. Welcome.
All right. Good afternoon, Chair, members of the committee. My name is Marceline White, for the record, and I am with Economic Action Maryland Fund, which is a statewide organization advancing economic rights, housing justice, and equity. We're here in strong support of Senate Bill 180, and I want to thank Senator Sidner for introducing the bill. I just want to make three main points. This bill is identical to legislation this committee and the Senate has passed in 2024 and in 2025. We believe that this bill will get over the threshold in the House now, and there will be an opportunity with changes in the House leadership to have this bill have a fresh look on that side. And the need to pass this legislation is greater than ever. At the federal level, staffing and funding of the Department of Housing and Urban Development has been slashed. As a result, federal investigation and enforcement of fair housing complaints have been harmed. They haven't been able to investigate or enforce. A recent national report found that complaints of housing discrimination have mounted, with disability discrimination being the most reported, followed by discrimination based on race and national origin. So against this backdrop, it's more important than ever that Maryland strengthen its ability to detect, deter, and enforce fair housing laws and follow the example of 39 states that already do that. So for these reasons, we support Senate Bill 180 and ask for a favorable report. Thank you.
Excellent. Thank you very much, Ms. White. Questions for the proponents of the bill? Well, Mr. Smith, could you just remind us, for the nonprofits that qualify, the people that go in to do these investigations or these inspections, just remind the committee what the qualifications are for training and what are the standards for training?
Sure. The bill sets out a range of organizations that are qualified. It would be nonprofit organizations. The federal, so it would be a range of things. The federal government could, the state could, my office, for example, could engage in testing. A local government, a local human rights agency, and home agencies currently engage in testing. And then nonprofit organizations that are certified by the Office of the Department of Housing and Urban Development. There's a whole regime that goes back decades of certification of testing programs by HUD. And those testers, those programs go through a testing training program, and then the people who supervise the tests go through training. So what that does is it ensures that you're getting tests that are legitimate and consistent in how you go about the process of identifying what your matched pairs might be. So for example, a lot of tests that will be performed, you'll have persons of basically identical backgrounds with the exception of the tested demographics. So whether it be disability or race or gender or sexual orientation, et cetera. How you actually develop those matched pairs is a pretty complicated process, and you need training for that. How you keep evidence of the test and how that evidence is reported, all of that is part of a regime that people are trained on and will be certified to be able to provide those tests.
Thank you, Mr. Chair. Senator Sidner, this bill, we've heard this bill in prior years, and I remember there was a concern. At one point, you suggested that the bill would have allowed the fair testing organizations to wiretap phones or place bugs.
That wasn't me.
What's that?
That wasn't me that said that.
I'm sorry?
That was not me that said that. I know you had a concern about the wiretap statute, and we addressed those concerns.
Right. I was concerned that the bill would allow wiretapping,
right,
or bugging, and I think at the time we agreed that the bill would be modified as necessary to make sure that couldn't occur. Are you confident that this bill is so modified so that the bill does not permit wiretapping or bugging, but rather
yes,
microphone to be implanted or hidden in the pocket of the person physically present in the room?
I am.
Okay, thank you.
You're welcome.
Further questions from the committee for the proponents of the bill? All right. Seeing none, thank you very much.
Thank you.
And that concludes the testimony for the proponents of the bill. We'll now switch to the opposition panel. Mr. Greenfield and Mr. Johnson. James Johnson, Aaron Greenfield.
Thank you, Mr. Chairman, Mr. Vice Chairman, members of the committee. Aaron Greenfield here on behalf of the Maryland Multi-Housing Association. We are again in opposition to this bill. You have our written testimony, and I appreciate, and I should mention Jim Johnson, the former Baltimore County Police Chief, is here at my request. As Ms. White said, 39 other states do this, but they don't have two-party consent. Maryland has two-party consent, and this bill is really unprecedented in that it creates a civil exception in the statute for the first issue ever. We're not talking about domestic violence. We're talking about fair housing calls that someone will cold call a leasing office and ask a question of a 22-year-old leasing agent and glean whatever information they can without any probable cause, without any mere suspicion. None of that is included in this bill. And it undermines the fundamental privacy rights guaranteed by two-party consent laws included in this state. Allowing an exception like this erodes these protections and sets a troubling precedent for future exceptions. As I've said in previous years, who's next? Bankers, journalists, elected officials, CPAs. Come to think of it, we'll come back next year for an exception on code enforcement officers. We'd like to record those conversations. So this sets a really dangerous precedent. And two-party consent laws have been long recognized as an essential safeguard for personal and business communications. This bill would weaken the very foundation of these privacy protections. In fact, in 2023, California, a two-party consent state, rejected this. The sponsor ended up withdrawing the bill. Fair housing violations can often be documented through non-intrusive methods, such as written communications, publicly accessible information, or direct observation. For this reason and for many others contained in my written testimony, I respectfully request an unfavorable report.
Good afternoon, Chairman, members of the committee. My name is Jim Johnson with Maryland Multi-Housing Association. I'm also an executive fellow for the National Police Institute with over 45 years of law enforcement public safety experience. I request an unfavorable vote for SB 180. As you've already heard, this bill would not require probable cause. It doesn't even require mere suspicion. It does not require independent judicial review. In fact, an investigation to gather evidence to be used in an enforcement action is a serious matter. Unlike law enforcement that conducts these recordings for various reasons, there's no chain of custody of evidence, which is a very, very serious matter. there are no standards. There are no equipment requirements. There's no safekeeping policy. In public safety, evidence is put in secure vaults. Any movement of people or hands that touch any piece of evidence is strictly prohibited and recorded. Again, there's no equipment standard. Did I hear this correctly? Their cell phone? So their personal cell phone filled with all sorts of other information that's not protected, it's not guarded. When one considers this bill, you need to consider the environment of these leasing centers. Multiple potential tenants and leasing agents are seated as close as they are to you. So you are recording conversations that you're not a party of. You may be, as a tester, talking to a leasing agent, but right next to you is a mother with 2 children talking to another leasing agent. So you are, in fact, recording the conversations of another person. Consider that. Also consider this. Oftentimes, 18 and 19-year-old leasing agents are dealing with the potential tenant. They may misspeak. They may not know the rules. Of course, they're trained. But they may have just misspoke. Thank you.
I appreciate both sides of this argument, and I'm well acquainted with the bill, and because I think this is the day when we're listening to bills we all have tried very hard to get past both chambers. But I do have a couple of questions for you all, which you can certainly get back to later. You know, Maryland's policy and values of the two-party consent is broad and deep. And without getting into that, I would think you'd have to have overwhelming and compelling reasons about which there is no other way for the state to accomplish the goal of a particular matter, but for changing how we do this. So I don't know just how successful Maryland is at going after discrimination, but what little I know is that while it's an endless battle like everything else, we have been pretty darn successful, and law enforcement, others have been, working at this, understanding all the other challenges. But I have not heard an overwhelming, compelling reason to change this foundational policy and or that could not be better accomplished in some other way. So my question to you is, in the other states that have looked at this, not gone forward with it, have you, or could you get back to me as to what other efforts they may have gone forward with to improve, not allowing discrimination in housing?
Yeah, no, and it's an important topic. It's an important concern. I'll have to get back to you on what other states are doing, because the majority of states, Ms. White said, are not two-party consent states, right? But I will say that Maryland Commission on Civil Rights issues an annual report. And last year, only 212 of these cases were cases that they enforced. Only 212 statewide. So is this a fishing expedition? Does Ms. White's organization profit off this? Again, there are a lot of questions here.
And that report does not say, gosh, if we only had, 1,000 more people, $1 million more dollars, we would, do far more. Does the report say we have been aggressive and dedicated and, and do not have obstacles that are completely, significantly undermining our efforts in some way?
Yeah, I don't want to speak for the Maryland Commission on Civil Rights. I know they've testified in support of this bill in the past.
They came out with a report every year, did they?
But they do come out with a report, and I will say that in full disclosure, the numbers did go up from their enforcement from 2023 to from 167 cases statewide to 212 last year. So the numbers have gone up.
I'll look at the report, but do you remember whether there was a concentration? Is this a, equally spread out proportionate to the population of jurisdictions, or is it concentrated? And look, I think it's concentrated perhaps in Baltimore City and maybe some other urban areas, but I don't know that.
Yeah, I don't have an answer for you right now.
All right, I'll take a look at that.
Thank you.
And if you can get back to me, if you find anything about what the few two-party states did, if they rejecting this, but maybe perhaps addressing or in some way, claims that, the discrimination is not being rooted out.
Okay,
Thank you.
Thank you, Mr. Chair. Thanks for coming out today. I don't know if you or the retired chief there want to answer this, but for criminal law, for when police officers or law enforcement are looking for a warrant for wiretap, does it require reasonable or RAS or reasonable articulable suspicion or probable cause?
It does. There are exceptions, though, sex crimes, for example, investigation, where there's some expedient time issue.
Okay, so sex crimes. So that would put it into the realm of where there's a fear of imminent bodily harm or injury, correct?
That's correct.
And under the domestic violence laws right now, if a domestic violence event is occurring and a woman is in fear, for example, of her imminent harm to herself for bodily injury or harm, and she turns her cell phone on to record such an act, even in her own home, is she committing a felony?
It's not allowed.
It'd be a felony. It's an act, right? If she turns it over to, it's not allowed, but if she turns it over to the prosecutor for evidence, which would support her case, she would be committing a felony.
At this time.
Okay, thank you.
I see what you did there. Yeah, that was good. That was good. All right, Senator Sidnor.
And I apologize. I told the chair I was going to try to be quiet because I know we're going to have a long evening, but I just want to make certain that we're not conflating things. Mr. Johnson, your testimony, when I listened to it, it sounded to me as if you were talking about things in the criminal context. Am I correct?
This bill specifically states that the evidence will be used in an enforcement action.
And we're talking, if we're talking fair housing, we're talking in a civil context, correct?
That's correct, but it still could bring discredit to a owner, operator, management company.
That's discriminating?
I'm sorry?
That's discriminating? I mean,
Well,
that's the only.
Your evidence is gathered to try to support that.
Right.
But I can't even challenge the chain of custody of that evidence. How do I know it wasn't manipulated? It's your cell phone.
Who said that you couldn't challenge the chain of custody? Is it prohibited under the statute that it can't be challenged? Evidence can't be challenged in a civil context?
There are no rules, there's no regulations, there's no policy, unlike law enforcement, to safe keep evidence. I come from a background, that's a very, very serious
Right, which is why I was asking, because everything, when I was listening, it seemed you were talking in a criminal context, and we're talking in a civil context here.
We gather evidence that may or may not be used for a criminal action, found property, for example.
But fair housing testing is done in a civil context, all right?
I'm sorry, sir?
I said fair housing testing is a civil context.
That is correct.
Okay, thank you.
Yeah. All right, further questions from the committee? All right, seeing none, thank you all very much. Thank you. With that, that'll conclude the hearing for Senate Bill 180. We'll now move on to Senator West with Senate Bill 64.
Thank you, Mr. Chair, and it's a pleasure to be here once again to present Senate Bill 64. This legislation would extend the current law to allow for the publication by attorneys and counties and municipalities of required legal notices in digital media, recognizing that much of local news is now accessed online. Under the current law, print media is the only media format designated to publish legal notices. Senate Bill 64 updates the law to reflect our current way of life. Nationally, 148 local newspapers have closed in the last 12 months. Furthermore, the Merrill School of Journalism at the University of Maryland recently conducted a comprehensive study that provides a snapshot of the current local media landscape here in Maryland. The Merrill study found that there are 176 local media outlets in Maryland. 156 of which are focused on news and journalistically supplied content. 78 of those are print-based newspapers that also publish websites. 53 are digital-only publications, including the Baltimore Banner and Maryland Matters, both of which I think are probably read by most of the people in this room, certainly most of the legislators. It's no longer practical or economic feasible to limit the publication of legal news notices to print media, which is slowly going out of business and being replaced by digital media. This legislation is intended to help the situation. Senate Bill 64 authorizes local digital media outlets to publish legal notices, but requires that digital publications meet criteria which guarantee that they're actual news organizations covering local communities before they're able to accept legal notices. For example, for legal notices to be published in a digital publication, the publication must employ one or more persons to create original content concerning matters of public interest through various forms of reporting, such as interviews, document review, and the like. In addition, the digital publication must employ at least one individual full-time, working at least 30 hours a week, and must publish at least one article per week concerning matters of public interest for the county or municipality. Digress for a moment. I can remember back in the 1970s when I was in college, I worked for 2 consecutive summers in Towson for a Towson lawyer. We had a publication of those days called the Jeffersonian. The Jeffersonian was perhaps the most boring publication I have ever looked at. It consisted of nothing but legal notices except for one article on the front page, which purported to be local news. So for a long time, some of the print media has only had a smattering of news, and most of what's in the publication are legal notices. Because attorneys and counties and municipalities will have more publication options once this bill is passed, it's likely that greater competition will drive down the cost of running these legal notices. Importantly, Senate Bill 64 also mandates that any digital publication running the legal notices must have an archive accessible to the public. I should also note that this bill is sponsored in the House by Delegate Linda Foley, a former national president of the News Guild Union, which represents journalists and other media workers. Delegate Foley spent decades working in the newspaper industry. Delegate Foley and I believe this legislation accurately speaks for the needs of the industry. It also addresses the needs for our constituents to use 21st century technology to access priority information. I appreciate the committee's consideration of the bill, and I believe Sarah Walton is here from the Banner to testify, and once she's finished, the two of us will be happy to answer your questions. Thank you.
Good afternoon. Thank you. I am Sarah Walton, the Chief Philanthropy Officer at the Baltimore Banner, and I am here to testify in favor of SB 64. At its core, the purpose of public notice laws is simple: to ensure that citizens are informed about government actions that affect their lives. The spirit of public notice is not about format, it's about reach, accessibility, and trust. This bill recognizes a reality that Marylanders already live every day. People increasingly get local information online. This bill modernizes in law to reflect how the public actually accesses local information, while still maintaining strong safeguards defining who is authorized to publish legal notices. Importantly, SB 64 does not place any restrictions on print newspapers, nor does it weaken standards. Instead, it expands eligibility to digital-only news organizations like the Banner that meet rigorous requirements, including producing original reporting, employing full-time journalists, publishing consistently, and maintaining public archives of legal notices. These are serious guardrails that protect the integrity of public notice. Digital publications like the banner can dramatically expand the reach of local notices, which is essentially important at a time when print outlets are losing readership statewide. Digital-first news organizations like the banner are growing, not shrinking, and that growth directly serves the public purpose of notice laws. Today, our website serves 75,000 paying subscribers in all 24 counties, over 200,000 free newsletter subscribers, more than 1.5 million monthly visitors. Making public notices available to readers of the banner will ensure that they are seen by far more Marylanders than legacy distribution methods alone can reach. That is a level of reach that ensures legal notices are not buried, but seen by residents across age groups, income levels, and communities. Public notice works best when it meets people where they are. Thank you very much. We encourage a favorable report.
Excellent, thanks, Senators. Because we have 2 signed up in favor, so you and the sponsor, and then 2 favorable with amendments, we're going to take the favorables, questions for the favorables, and then we'll go to the favorable with amendments. So Senator McKay.
Yes, sure.
Thank you for bringing this bill. So I'm just trying to figure out the mechanics of it and how it works. So traditional in your hand newsprint is something that gets printed. There is possibility somebody subscribed to it at their home or they bought it or whatever. But that lays around and people are able to then look at that. I've not found any digital where I'm not able to just look at it without having to pay for it. So will these legal notices, will you have to pay for them to see the legal notices?
I believe, well, to answer your question directly, I believe most paper newspapers you subscribe to, or you buy it at the newsstand. I'm not aware of many of those which are simply handed out free. So you said you'd be sitting around, you wouldn't have to pay for it.
Yeah, there are things, Pennywise, different things like that. But I'm talking about just general information that people can just pick up. To me, in the digital world, we are forcing people to actually buy something. And I understand it.
Well, I get the Baltimore Sun, and I think have my entire adult life, and I've always paid for it. I don't get it for free.
Right, but you've never seen that in a Bob Evans, or you've never seen it where you can pick up a copy and read it, or anything like that?
Oh, sure. I can go into a farm store each morning and buy a Sun.
Right.
But again, I'm paying for it. I'm not getting it for free.
Right, but my hope, I guess my premise of my statement is legal notices are to inform the public.
Right.
So to get legal notices, we now have to pay for them?
Well, my point is we always have. If you go to a farm store, you're paying for it. If I subscribe, I'm paying for the subscription.
Right, I disagree.
Okay.
If you look at the digital platforms that are out there, you have to pay to click on to figure out anything.
Right,
so
but I need to pay for the Baltimore Sun too, whether at the farm store or through a subscription.
Right, but there isn't a way for the public to pick up a digital ad and not pay for it. In where you have an actual piece of paper being printed, you can't.
Oh, you mean if I pay for it and then leave it sitting on a desk in my law office in the lobby, somebody could come in the lobby and could flip through it and could see the legal ad. I guess that's correct.
So,
but let me counter with that by saying once upon a time the subscription list of the Baltimore Sun was enormous. Virtually everybody I knew in Greater Baltimore got the Sun or the Evening Sun, one or the other.
Right.
These days, that's just not the case. There's so many people I run into that don't subscribe to the Sun, but they do. Many of them do get the banner. So if you're talking about penetration, in the old days, everybody got the Sun. These days, that's not the case. And if you want to reach, perhaps, I don't know, as many people as read the Sun, probably read the banner. Or it's close. At least it's a comparative publication. And I'll tell you, a whole lot more people read the banner than ever read the Jeffersonian when I was a young lawyer.
Right. And so my question is, as this goes forward, and because there are so many opportunities for digital, because there's many, many platforms, not just the banner, who does a very good job, but not because of the banner.
Yeah.
How does the public, know exactly where you're supposed to go to if there is a plethora, more than there ever was, of opportunities to find out where public notice is.
And the simple is they have to inform themselves. Back when I was working for the law office in Towson in the 1970s, you needed to inform yourself that the Jeffersonian is where you'd go to find the legal ads. In those days, you did not find them in the Baltimore Sun. You found them in the Jeffersonian. How would you know where to look? Because you need to find out where to look. And that's equally the case today.
Could that be the statement in opposition of said legislation, that if you want to know about your public notifications, you need to go to standard print?
Well,
I mean, I hear what you're saying. The argument that you need to inform yourself, you need to have knowledge of where you're going to be looking for these places.
but I don't think it's our function as a General Assembly to limit where legal ads are paid to standard print. So, for example, in Allegheny County, there probably is a newspaper that publishes weekly, I'm guessing, in Cumberland, maybe daily. I'm not familiar with Cumberland.
So
I wouldn't want to limit where legal ads could be placed only to the, quote, standard print newspaper in Cumberland.
Right.
If there's a digital newspaper in Cumberland, which people are subscribing to, people should be able to put the legal advertisements in the digital publication so that people have a choice.
Right. So two different things. One of the things that standard print newspaper does, I'm a firm believer that's one of the pillars that a community has. As we get a larger worldwide view, whether it be digital or anything like that, smaller communities, rural communities are suffering from that.
I'm afraid it's the
Cumberland,
state of the world.
I understand that.
Throughout the country,
Right.
these old weekly local newspapers are going under. There used to be several in Towson. They're all gone.
Right. And I understand that. But at what point, government is not supposed to operate as a business. I learned that when I was a county commissioner. I ran on government's supposed to run like a business. But there were things that government did that if business ran, wouldn't get done.
I'm sure that's correct.
And I tend to believe that passage of this bill is going to be the death of those small newspapers. You're right, we shouldn't pass things that are going to put the thumb on the scales and pick winners and losers. But coming from a small community, that paper is what we have. That paper is the revenue that we have. In Cumberland, it's now a 5-day-a-week, used to be a 7-day-a-week. But I'll use the Hancock News, 1 day a week.
And I will tell you, some years ago, I was exactly where you are. But the world has changed. And I'm watching small print newspapers all over the place go out of business and cease publication. And unless we allow these legal ads to be placed in the new form of media, digital newspapers, where are the legal ads going to appear? I think it's a fair question. I think there are some counties these days which no longer have a print newspaper. But people in those counties can subscribe digitally to the Sun or digitally to the Banner and get their news that way rather than in hard copy each day.
Well, I can go into different avenues where the rural communities are slowly dying, whether it be busing our kids an hour and a half to get to schools that we can't go anymore, whether it be small town who can't afford all of the regulations that the state of Maryland passes on to them. We're not going to solve that here.
No.
But maybe in the spirit of trying to fix a bill, you might be interested in talking to me about an amendment that maybe where there is a place
well, this
that doesn't have a print, and we can address.
I would love to sit down and talk with you, as that's my way of dealing with legislation. Let's talk. I would say, though, that this does not say that the ads have to be in digital publications, merely that they can be in digital publications.
Right, and therefore, it then gives the opportunity, and I say that it's going to hurt those small town papers that are one of the pillars that I have of small town rural life. And we'll continue. It's not fair for the rest of them here. But I think unintended consequences is putting Appalachia, Maryland at a disadvantage because from the digital world, We have a plethora. How do you determine that that's where you're going to go look? That that's where if you don't educate yourself. So, thank you, sir.
I thank you, and thank you for your questions. They're very thoughtful and well phrased, and I'll be happy to come sit down with you, and let's see if we can come up with some language which would make the bill acceptable.
Thank you, sir.
Thank you. And listening to your response to the senator, I was curious because you didn't respond the way I thought you were going to respond.
How did you think I was going to respond?
Well, no, it's and maybe it's a misreading on my part, but when you look at page 3, lines 13 through 15, when it talks about the responsibility to maintain an archive of all published legal advertisements and legal notices that shall be available to the public, I read that and I assumed if it's available to the public, it would likely be for free. But from listening to your conversation, it sounds like this isn't going to be free to the public.
No, there's nothing in there that, the reason I didn't respond with that is because the bill provides that the archive must be acceptable in the county or municipal corporation that's required to publish. So my reading of that is there has to be an archive which you can access if you were to go to the office of the publication and ask to and most people don't do that.
So this isn't an online archive?
Ms. Walton may disagree with that.
No, but you're the sponsor, so I mean, what is your intent?
Well, again, if you want to work with me, I'll be happy to craft some language which would make it clear that this archive has to be available not merely if you go to a particular location to walk into a building, a brick and mortar building, and ask to take a look at the archive, but which would be made available online with the rest of the publication.
Right, that was my assumption. I mean, I'm looking at the Daily Record right now and their public notices, and they have it all kind of laid out, and you can look at things going back in the past. So, I mean, this is what I kind of thought of an online archive. Yeah, but again, when I started listening, I'm like, maybe that's not what he was intending.
Let's talk. I think we can come up with an amendment. Would the banner have a problem making, okay, I'm getting a nod here, no problem. So we can amend this bill to make sure that the archive is available equally online with the online daily publication.
So this archive, I'm curious, how long is the archive supposed to be for? And how, I mean, is it a forever archive?
That was my assumption. If you want, look at the Sun archive.
I'm just trying to get you on record. If you say that's what I mean, that's how I read it. But
that's would be how I read it too. But if we want to make it clearer, we can do that. And the Sun archive goes way back into the 1800s. I know because my brother was looking up family history, and he retrieved stuff from the 1850s online.
And
not online, excuse me, in the archive, in the Sun archive.
So. One other thing that I'd have to think about when you're talking of moving from paper to digital is what happens if these organizations go out of business? What happens to that archive?
That's a good question. Suppose the Sun went out of business. What would we do?
Right.
This bill doesn't purport to cover what happens.
I mean, the paper, you got the paper, and we know that the paper is going to be saved somewhere.
Well, maybe not. If the Sun goes out of business, the papers, their archives are gone.
But we have libraries that archive these things. So, but digital is pretty much proprietary, and they kind of control. So it's just something to think about.
Yeah. No, I think good questions all. Let's sit down and talk. A few other questions. I'm curious on page 2, line 22, how did you come up with the 50 miles? Page 2, line 22.
Mm-hmm. You have to have an employee that resides within 50 miles of the county or municipal corporation with a legal advertisement.
Right. Well, this bill is Linda Foley's bill. I have the cross file. So I did not draft the bill myself. I'm the cross file sponsor.
All right.
I could ask Linda how she came up with 50 miles.
Yeah, I was just curious where the magic number came from. additionally, in speaking about these, the tax exempt organizations, so they're public charities, you have a certain kind of things set out as to, I guess, where revenue can be derived if they're a 501c3. And I'm curious.
I think that's there I believe that's there to make sure that we're not talking about some political publication.
Which goes to my question, because on page 3, lines 6 and 7, it says, it's essentially, my read is, it's all right if you receive 50% of your gross revenue from a PAC, then you could fall under this. And I'm curious, and again, I think an organization like the banner's a C3.
That's correct.
And if you're receiving that kind of revenue from a PAC, I don't even know how you would continue to qualify as a public charity. That's a lot of political money.
I think that this language here was intended to exclude political action committees that publish periodic publications during the course of a political year from qualifying.
Right, so has not received more than 50%, which means I can receive 49%.
Right.
That's a lot of money from a PAC.
Well, again, if we want to reduce that, we can sit down and talk.
All right,
You and I will have a nice conference.
Yes, sir.
Thank you. Sarah, did you want to add anything to what I said?
Okay. All right. Seeing no further questions, thank you all very much. We're now switched to the favorable with amendments. So Justin Fiore, is Justin here? Yeah, what's going on? And then Sarah Walton, you already testified. And yep, Rebecca Schneider, you're unfavorable, so we'll get you in next.
All right. Good afternoon, Mr. Chair, members of the committee. Justin Fiore here on behalf of the Maryland Municipal League. Favorable with amendment on Senate Bill 64. I kind of wanted to lead with the uncomfortable part, but we've already gotten there. The changing media landscape and the decline of local papers is palpable. But local government notices aren't going to be the thing that saves small papers, nor are we going to change the public consumption habits where people get their news today. This is just the reality we have to face. And at a time when state and local budgets are so tight, I believe that public notice modernization provides two big opportunities. One's in cost saving and the other is in accessibility. So on costs, several municipalities are spending tens of thousands of dollars every year just to put public notices into newspapers that oftentimes aren't even covering local politics or local issues. The Washington Post may be an example of this. And there are many requirements in state law that require multiple public notices for a certain change. Municipal charter changes are a great example. 4 public notices are required anytime you change your charter. In the Washington Post, those can be $500 a piece. So these can add up very quickly. Then you throw on top of the fact that you have to have a subscription to access it in the first place, and that's all taxpayer money just going into these public notices. Regarding accessibility, we believe that free access should be the standard for public notices and not putting them behind a subscription wall. Online postings also have the benefit of being more accessible to those with visual impairments and language barriers. So this is why MML is favorable with amendments. While Senate Bill 64 is a step in the right direction, both acknowledging digital publications as well as creating competition, we believe it doesn't go far enough. As introduced, the digital option here would not serve the entire state. It would guarantee no fiscal relief, and it relies on the continuance of a business model that's brand new. I'd be happy to talk about my amendments if I get a question.
Excellent. All right. Seeing no questions, thank you very much. All right, that'll conclude the testimony for the favorable with amendments. We'll now switch to the opposition panel. Rebecca, welcome. Good to see you.
Okay, so I'm the panel. Thank you, Chair and Committee. I'm Rebecca Snyder. I'm the Executive Director of the Maryland-Delaware DC Press Association. So we represent all of the news, legacy news and digital news outlets, including the Banner, which is a wonderful publication. I wanted to clear up just a couple things. We're having a larger public policy issue. It really felt like we were talking, is the Banner going to take notice? And public notice, I want to clear up a couple things that came up. First, Notice is in print publications that also publish digitally. Every jurisdiction in Maryland has a print publication. Every publication also publishes their notices online. MDDC aggregates at no charge all of those notices and publishes them on our website, and we have an archive as well. So I wanted to share that. The important things about notice, accessibility, archivability, immutability, and broad distribution are all critical pieces, and I want to share why print publication is different than digital. Print publication relies on a statement of ownership. I think I heard questions about, well, who do we know who's funding? How do we know where publications are going or where the notice is going? That's why print publications are limited to those who carry a second-class periodicals permit, which is a USPS determination that is neutral, that is clear, that is enforceable and traceable, that says you must declare, I think it's roundabout November, every year, and publish it, who owns you, what your circulation is, where it goes. Digital publications, and we struggle with this as a membership organization, we shifted how we do our dues a couple years ago. We shifted it from print circ to digital, and we struggled because there's no standard measurement for digital circulation. So this bill is much broader than the one last year. It is not the same bill. It would cover all aspects of notice, and I strongly urge you to look deep and not hasten the demise of your local newspapers. We urge an unfavorable report.
All right, thank you very much. Questions from the committee? All right, seeing none, thank you.
Thank you.
With that, that'll end the hearing for Senate Bill 64. We'll now move on to Senator West with Senate Bill 66.
Thank you, Mr. Chair. This is Senate Bill 66, and it's a distinct pleasure to be here to present it. I have with me the state's attorney for St. Mary's County, and also John Duckett, who is the father of a young man who was brutally murdered. I'm here to introduce this bill because the legislation would raise the maximum penalties for causing the death of another as a result of the person's driving, operating, or controlling a vehicle or a vessel in a grossly negligent manner under Section 2209 of the Criminal Law Article. Now, under current law, a first offense under Section 2209 is a felony and carries a maximum penalty of 10 years, while a subsequent offense carries a maximum penalty of 15 years. This bill is very simple. If you look at the bill itself, all it does is it increases the penalties for 20 years for a first offense and 30 years for a subsequent offense. So why do we need this bill? The legislation is named Jamari's Law for Jamari Duckett, who is a resident of St. Mary's County. In 2022, Jamari was the victim of a car accident caused by a driver who was drunk and was traveling between 76 and 91 miles an hour on a rural road where the speed limit was 40 miles an hour. That's the very definition of gross negligence. Jamari tragically died as a result of the injuries he sustained in this accident. He was only 18 years old. The person who killed him had to have known that he was taking someone else's life in his hands when he got drunk, hopped in the car, and took off driving up to 91 miles an hour on that rural road, over 50 miles over the speed limit. And as it turned out, he did take someone else's life in his hand, and that person's life was snuffed out. The St. Mary's County State's Attorney's Office successfully prosecuted the drunk driver in this case, who was sentenced to the maximum penalty of 10 years. As this is considered a non-violent offense, it's possible for this individual to serve about a quarter of his sentence in prison. This means that when considering the diminution credits and the possibility of parole, the offender could be released in as little as 2.5 years. I believe this is far too short of time for the crime of manslaughter by vehicle or vessel due to gross negligence. It's important to note that this bill does not impose any minimum sentences. It only gives our judges further discretion in their sentencing of those who are found guilty of violating the law. This committee is aware of the threat that drunk and negligent driving poses to our state's citizens. I believe this legislation will continue the work that we have done in this committee to combat drunk driving in Maryland. I appreciate the committee's consideration of the bill. As I say, Jamie Sterling, who's the state's attorney for St. Mary's County, and John Duckett, the father of Jamari Duckett, are here to testify. And I give the proceedings over to them right now.
All right. How y'all doing? Good afternoon. I'm John Duckett, Jamari Duckett dad. Like Senator West said, Jamari was 18 when he passed, was killed by a drunk driver, and it changed our life forever. And last week, well, not last week, this week, I went to help to promote, to get people to involved with the law. I went on the radio, the local radio station, and told everyone about the law, got everybody, and Jamie as well. We got together and got on the internet and sent out flyers and let everyone know where we're going to be at to help, to get the law going, to promote it. And I seen a comment from a attorney from Frederick County, and he said that was a good guy, said that this was a bad law, and said that this was a good guy crime. And a good guy crime, it's like, what is a good guy crime? I didn't understand it. I didn't comment. I didn't want to understand it. I graduated from the University of Virginia, so I'm educated and I knew what he meant. But the thing is, when he said a good guy crime, it baffled me because, like, how can that be a good guy crime? And then he gave an example of, like, he said that he helped like 13,700 defendants. He helped 3 judges, local judges in Maryland. And he said that's a good guy crime. And he said you need to put other bad criminals away. But what he didn't know is that he was defending all of those good guys, but he never said that he put a good guy in the ground. And that I got to go see my good guy every Christmas, every New Year's, and the day that he passed away. And his birthday is like, my son's birthday is like a couple of days after Christmas. So just think about the holidays. There's no holidays. It's just, you got to go and visit your child in the grave. And so a good guy crime, I don't get it. A good guy put another good guy in the ground. So how does that equal out? So I ask you to find Jamari's law in favor. And I thank you for your time.
Mr. Chairman, distinguished members of the committee, my name is Jamie Sterling. I'm the elected state's attorney, and I proudly serve my county. I'm also here on behalf of the Maryland State's Attorneys Association. I'm here to ask for your help. I want to pose this question that I'm asked by victims and victims' families. What is a life worth? What is the value of my mom, my dad, my siblings, my child? What's that life worth? How would you answer that question? Because I'm left with explaining to them that the penalty for vehicular homicide is 10 years. That is the same for someone who slaps someone, a second-degree assault. That is the same for the bad check that bought the car that killed Jamari, the same penalty. And in fact, I have to explain to them that if instead of getting drunk and driving double the speed limit and killing Jamari, if that person simply snatched his wallet, that would have been a 15-year penalty. But if that same person went to Jamari and took a knife or a gun and said, "Give me your wallet," that would be a 20-year penalty. This is not justice. We all know that first-degree intentional homicide carries a maximum penalty of life. We all agree that in those cases, it rises to the level of life, first-degree murder. But the penalty should still match the crime. In all these cases, defendants will only serve a quarter of the time. That's these gross negligent homicides, because they're considered nonviolent. How do you tell a family that the brutal murder of their child is a nonviolent crime? But that's the state of the law, and that's what I have to explain. A 10-year sentence for prosecutors and judges are left with having to choose what we strive to do. We have to choose between rehabilitation, deterrence, and punishment. And with 10 years, where you get the maximum penalty and you're only serving 2.5, how do you do that? How do you accomplish punishment, deterrence, and rehabilitation? It's impossible. So by raising the penalty to 20 years, you will allow prosecutors and judges to carefully craft a sentence, achieving all of the goals of sentencing: appropriate punishment for the crime committed, necessary rehabilitation for drunk and drug drivers, because guess what? They're coming back. They're going to be back on our roads. But it also provides specific deterrence for that offender and general deterrence for the community and those who think that things like this are socially acceptable. Gross negligent homicide or drunk driving homicide has become the most socially acceptable form of homicide. So when Mr. Duckett says that he read something that upset him, that this is a good guy crime, it's because it has become so socially acceptable that if you kill someone by being drunk, that it's a good guy crime. And we need to change that narrative. So I started today by asking you for your help. As a prosecutor who was served on the front lines prosecuting these cases, I'm asking you to provide me and us the tools to create fair and just results, not only for the victims and their grieving families, but for the drivers who are the offenders. And I want to make sure that the same roads that you and I and our families drive on are safe. What is a life worth? That's the question I ask you. Please vote favorably.
Excellent. Thank you very much. And Mr. Duckett, I just want to say, obviously, every year you come down here, I just want to thank you for your presence. Sorry for your loss. Obviously, I extend our condolences from the committee, but also to say it takes a lot to turn the tragedy in your life to continue to advocate and come up to Annapolis. So I just really appreciate you taking that step and leaning forward to improve the lives of people that you'll never meet, and based on something terrible that happened to you. So I just want to send that out to you and your family. Just thank you. All right, we'll start off with Senator James.
Thank you. I mean, it's good to see you again, but not for the reason you're here. And as you might recall, I lost my daughter too. So we're in that same place that changes your life, for which there's no recovery, and you are the walking wounded in a way that cannot be necessarily visible. Christmases, holidays, everything is lost and changed, and there's no end to that. And so I know how hard it is to come down here and try to do something for justice in this circumstance. And so I appreciate it. I don't know how you do it sometimes. Most times I just devolve into tears and have to leave this room. But I've gotten a little bit better. But it's not something I want to be good at. All right, but here's something I just wanted to remark on and then also get some feedback. This bill kind of exposes a problem or perception problem that the lay public and anybody who is not steeped in criminal law would not know about, which is that you get a sentence, but it's not your sentence, right? You can, I think, as you, the sponsor, said, even with whatever the years are, is it 15 years or something like that?
10 years.
10 years, right? You can get out with
2.5.
Yeah, 25%. So that in itself is a fundamental problem and a way in which I think the public has done a disservice, that we are not truthful in what a sentence is and how it will play out, right? So it's even more shocking that it would be only 10 for an intentional killing, and even it's so almost incomprehensible and deeply insulting that it's then also, guess what, 2.5 years, right? So you don't have, I'm offended and deeply disturbed by that for you and many other people. But what I'm wondering about also, Senator West, is there have been bills, I think some successfully passed recently, where we are giving defendants an enormous ability on top of all the other existing opportunities to petition, to be released early, have their sentences reduced, looked at, right? So does this particular offense now, and or even if we amend it, are these defendants allowed to partake in the benefits of all those other laws we've done to allow people to have second, third, fourth, fifth, sixth chances at reducing their sentences? And without trying to, I'm not trying to change your bill at all, but it begs the point about whether there should be some more exceptions to that approach, which I didn't support to begin with because it was, to me, too broad and too numerous. But
I think you're probably adverting to the Juvenile Restoration Act,
no,
which I was instrumental in
we
passing.
Passed something called second chance.
Yeah, that was like an add-on.
That was adult.
So juvenile restoration only applied to juveniles 18 years and
no,
younger.
I understand that.
Who were sentenced to periods in jail of over 20 years, and provided that after 20 years, they could go back to the court.
Were they under 18? I thought
it was under 18.
Yeah,
the juvenile restoration that I sponsored and we passed about 4 years ago only applies to youth under 18 years old, and says after 20 years in jail, you can go back to the court that sentenced you, and you can throw yourself on the court's mercy and say, and the court would have to find. But it was not a get out of jail free card. You had to find that you were no longer a threat to society.
I remember all that, but what I believe is that there's a new movement,
yes.
whether we
Last
pass
year,
it or not, people that are considered youths, which is not under 18, but under perhaps 30.
Last year we passed the what's called the Second Look Act.
Second Look.
Which extended the 18-year-old limit of the Juvenile Restoration Act to 25. So now if you're 25 or under and you commit a crime, and you're sentenced to jail for over 20 years. Again, at the end of 20 years in jail,
I understand.
a full 20 years, no diminution credits, you can
Senator,
go back to the
I'm
court.
asking a very simple question.
Yeah.
Would the bill fall under that?
Yes, everything would fall under that. There's no exception.
And so the fathers of all these children would have to, as every other family, go to court over and over again to, if you can or want to.
If I can interject, remember, you have to have been in jail for 20 years, not
Senator,
the 2.5 years we're talking here.
I've heard that so many times, and I've seen you with people testifying, constantly telling them, I've heard you say that 10 times. Please listen to me. I'm so respectful of you, and I treat you with great regard. So please just don't get animated about this. I'm just trying to get to some, I just wanted to understand that. I also want this gentleman to understand it and the viewing public to understand it, because it begs an issue that I'm not going to say we should address in this bill. But if we feel that there are egregious situations allowed for in the criminal law, then I think we should, at some point, take a look at situations where it's exacerbated or perpetuated with other bills we pass. But I just want to make sure I knew that. And of course, it would only apply because you would change the law to increase the penalty here, not to the 10, but to the, what was it?
This is 20 for first offense and 30 for second.
So if you were in that 30.
So the first offense really wouldn't be covered by juvenile restoration because you have to be in jail 20 years. It would only be the second offense, and that's 30 years. But if you, because of time, because of the parole and the diminution credits, you could be, again, a quarter of that. So that would be less than 20 years. So under juvenile restoration, you'd have to be in jail for at least 20 years, even under the 30 years.
Most of those are very old sentences where I think understanding of people, rehabilitation, and other things were different and not as modern and fair as they are today. But I still think some of this movement has captured some people that I don't think are deserving. I'm sorry we're having this, but you should know that if we increase these penalties to that high, it will come under another law that would allow the defendant to, not your defendant, but other defendants, to petition to get out at an earlier date. And that's just about the public not understanding these sentences and how hard it is for victims and loved ones. All right, so I want you to know that deeply respect you being here. I deeply respect you. I just wanted some understanding of
Let me
that.
say, I agree with you. The system of sentencing and
Yeah.
time served is so opaque that very few members of the public understand it.
I don't either, and that might be something where we want to get a bill on some more transparency of how that works. All right, thank you, Mr. Chair. I didn't mean to go off on that, but you didn't seem to understand where it was going.
Sure.
Thank you, Mr. Chair. First, let me say, so sorry for your loss. Unfortunately, as someone that's done fatal crash reconstruction for 24 years, I've had to make those notifications far too often than I like to acknowledge. So I do completely, so sorry for your loss. If I could have the, Madam State's Attorney, do you mind coming up for a quick question real quick? And I'll make this as quickly as can, just because of the background that I understand with this. I just want to be very clear. So currently, are there different levels of culpability or differing degrees of vehicular homicide?
That is an excellent question. And so this is gross negligence homicide. It would only affect gross negligence, which is what I would say the closest thing to intentional murder. But before that, if it was a collision or what people call an accident, that would be a payable citation. That'd be like speeding.
Correct.
Then there's the next degreeing level, which is reckless driving. And then you have negligent driving and criminal negligent driving. And this is all the way here at gross negligence. So when we talk about gross negligence, we're not talking about just someone who got behind the wheel and just, got into a quote accident. And so this is the highest level.
So that would be inclusive of kind of like we were talking about, unfortunately, at great length earlier, but like intent, like how did you knowingly, intentionally get in behind the vehicle, knowing you were impaired or knowing that there was other factors that you should have known better than to drive the vehicle?
That's correct. And the grossly negligent standard is like a willful and wanton disregard of human life. So it's the highest. If someone were to get in the car and say, I'm getting in the car, I'm getting drunk, and I'm purposely going to kill so-and-so, that would be first-degree murder. So it's short of that.
Correct. So willful and wanton, not careless or imprudent.
That's right. You got it.
Thank you.
Getting your law degree, it's good. All right. Sure, did you want to say something, Mr. Dyke? Of course, yeah, come up to the podium.
I've been coming up here for a while, and only thing that I ever hear is, is most people talking about like the defendant, like how they're going to get out of jail, how can we rehabilitate them? No one never talks about how they can rehabilitate us. That's all I wanted to say, was like no one ever. Anywhere I go and everywhere I go, only thing I get is I'm sorry, and we pray for you and all this and that. But they never say how they can help us. It's always the defendant, always. You get them on probation, when they get off on probation, like the guy's home now. He is out. He already did his time, he's out. And it's not about me, it's just about the people that's behind me. And that's what I had to say. I just wanted y'all to know that. It's always about the defendant, and it's never about the victim. And you can look at it because you go back to all of your statements. Thank you. Yeah.
No, thank you very much, Mr. Duckett. Appreciate that. Further
opposition.
Actually, I don't see any opposition signed up to this bill.
Good.
All right. Well, thank you, Mr. Duckett. Thank you, Senator. Thank you, Member State's Attorney. With that, that'll conclude the hearing for Senate Bill 66. We'll now move on to Senator West with Senate Bill 131.
Thank you, Mr. President. Mr. President, Mr. Chair. Maybe one of these days. You may wonder why I'm by myself up here, and that's because this bill, Senate Bill 131, is identical to last year's Bill 135. We passed that bill unanimously in this committee. It went onto the Senate floor, passed unanimously on the Senate floor. The bill was never taken up by the House last year. So the purpose of this bill is to give the House another shot at doing the right thing in passing this bill. Maryland defines attorney-client privilege, for those of you who are not lawyers, in 7 ways, or with 7 elements. Number 1, where legal advice of any kind is sought. Number 2, from a professional legal advisor in his or her capacity as such. Number 3, the communications relating to that purpose. 4, which are made in confidence. 5, between the attorney and the client. 6, are at the client's insistence permanently protected. 7, from disclosure by the client or by the legal advisor. That's the definition of attorney-client privilege. Maryland recognizes some limited exceptions to attorney-client privilege. However, there is no fiduciary exception to attorney-client privilege among the exceptions that are recognized. On the other hand, Maryland court decisions do not explicitly establish that there is no such exception to the attorney-client privilege. So the law in Maryland in this area is currently gray. In the context of a state administration, the attorney-client privilege protects communications between the fiduciary, who's administering the estate, and the fiduciary's legal counsel, communications which occur in the course of administering the estate. If beneficiaries or others were able to require the disclosure of such communications, the result would be a breakdown in the attorney-client relationship. No longer could a fiduciary communicate with his or her legal counsel without worrying that whatever was said might be discoverable and might be the subject of litigation by a disappointed beneficiary or by someone else. Because neither Maryland case law nor our statutes currently clearly state that Maryland either recognizes or does not recognize a fiduciary exception to the attorney-client privilege, parties often raise this issue in litigation, resulting in increased costs and delayed adjudication of the pending matter. So this bill, which again this committee passed unanimously last year in the same form, will add a section to the Estates and Trusts Code that makes it clear that, like many other states, Maryland does not recognize a fiduciary exception to the attorney-client privileges. In other words, fiduciaries and their lawyers will be protected by the attorney-client privilege, just as it applies in so many other cases involving the law. I appreciate the committee's consideration for the bill. I don't believe there's any opposition to the bill. There are no other witnesses, so I'm prepared to accept your questions now. Thank you.
Why didn't you use the word piffle? Adjective piffle. All right.
Actually, there's a member of our committee who's not here right now who doesn't like that word, so I have forsworn using it anymore.
Okay. That's okay. Any other questions from the committee? Or any questions from the committee? Oh, all right. Thank you very much. All right. With that, that'll conclude the hearing for Senate Bill 131. We'll now move on to Senator James with Senate Bill 221.
Am I the last bill before we switch gears? Okay. All righty, right, and the crowd with me. Senator Mary Delaney James of Harford County, here presenting Senate Bill 221. Mr. Chairman and members, just as my colleague Senator West mentioned regarding his last bill, this bill has passed out of this committee unanimously, passed out of the Senate unanimously, and has not gotten a vote in the House. Right. So I hope a pride of place would be enough. But I usually skim over all this just because I know you all are very familiar with it. But it's been a couple of years since I did just express how the bill works. So let me just do that for a moment, and then hopefully we'll take a break. So I want to tell you that there is an awful trend that's been going on for the last 15 years or so, where the victims of child pornography have been getting younger and younger and younger. The images and videos about them have become more and more vicious and brutal. And I'll be honest for you all, almost incomprehensible to you. I don't think you know what I know about this, and I didn't know it until prosecutors very carefully and tenderly and cautiously told me about some of these cases, which I'm not going to put on the record here, but I will discuss if you want me to. And the other third trend, which is everywhere for both good and bad, is technological advances. So now we can create massive amounts of images and store them and send them out in the world. And a great deal of child pornography comes, internationally, but we have our awful homegrown ones as well. And so because of all this, state's attorneys have come to us to ask us to model our law, update our law to what the federal government has done and which a number of blue and red states have done, which is to address how you respond to the trends I just mentioned. The bill is pretty simple. It does just a couple of things. First of all, it does enhance penalties in two areas. When the victim is, I think, under 13. I'll be honest with you, that was a concession to the advocates. I actually wanted to make the penalties even higher as the children's ages went down because the ability to harm, the ability to extinguish a life ever increasingly gets worse as you go down in age. And I am talking about infants and toddlers and prepubescent, right? Something that was not going on in our childhood, but is now and gaining traction. It also enhances penalties if the magnitude of the image, the number of images exceeds a certain amount. Again, we used to have cases where, you'd find 50, 100, maybe a couple hundred images, and now prosecutors are, because of the capacity, are having regular cases of over 5,000 or 6,000, 10,000, 200,000. A terabyte, the prosecutors tell me, has about the capacity for 200,000 images or 500 hours of video. Prosecutors are routinely dealing with cases with 1 to 2 terabytes. Terabytes are cheap. You can buy 2 terabytes for $25, right? So there's no limit to the way they create these images. The problem is that now that the zone is flooded, these criminals have become so desensitized that they no longer see what we would immediately consider brutal treatment and are demanding even worse brutal treatment for the shock value because they become inured to the horrible circumstances they have. And finally, the last part of this bill is to acknowledge for prosecutors just that they can batch a number of these images in one count. Let's say you have a case with 20,000 images. I don't think anybody would expect a prosecutor to do 20,000 counts. That's how the law works now. They're asking us to be able to batch them in 100 per and be able to describe them generally. And by the way, this is only the initial pleading. It's not getting into the meat of the case. So I think one of the experts nationally said something that really changed my mind about how to look at this. He said, you've got to stop calling it child pornography. This is nothing more and actually so horrible that it should be called child pornographic sexual assault. We got to stop acting like it's not sexual assault, an egregious crime that is getting worse and worse. So I would ask for a favorable report. I hope that this will be the last time I present the bill, and I'm hoping we can get the House to agree that Maryland should follow the federal government and a number of blue and red states and modernize this area for the sake of justice. So I'd ask for a favorable report. Thank you, Mr. Chairman, and for your attention. I know you've had a long afternoon.
No, thank you very much, Senator. Questions from the committee? All right, seeing none, thank you very much.
Thank you.
All right. With that, that'll conclude the hearing for Senate Bill 221. We'll now move on to Senate Bill 1. Senator Augustine, welcome. You want to call up your panel? Let me make sure we get your panel up here, okay?
Say again?
Let's make sure we get your sponsor panel.
Yeah, absolutely, Chair Smith. That would be Noreen Shaw, Eric Lopez, Neil Franklin, who is virtual, and Shauna Kadar.
Okay. If you've heard your name, please come up to the podium.
Thank you. Go ahead.
We'll give you a second to make sure that everyone's
Yeah.
here.
They might well be in the,
The overflow.
yeah, there's significant overflow, but that's okay, we'll get there.
Just give it 1 second and we'll. You call one more time. Call him one more time.
Thank you. Sponsor panel is Noreen Shaw, Eric Lopez, who I don't see, Neil Franklin, who is on, and Shayna Kadar.
All right. All right. Well,
All
let's get underway, and then they can join you when they get.
Absolutely.
All right.
Absolutely. Thank you, Chair Smith, Vice Chair Waldstreicher, and members of the committee. Senator Malcolm Augustine here requesting a favorable report on Senate Bill 1, Public Safety Law Enforcement Officers Prohibition on Face Coverings. Just to start, Chair Smith, Senator Hester is asked to be added as a co-sponsor if the committee moves this bill forward, so just want to include that. We've already, of course, mentioned the sponsor panel. And I also will just say to the committee that a number of people asked to testify in person on this, but with respect to this committee, I ask that they instead provide written testimony that I would direct you to that really demonstrates strong support for this legislation from across our state. And colleagues, I will say to you, we all have a why, right, and a why we do things. And there was a hearing yesterday that changed how I thought about presenting this bill today. Yesterday, Senator Folden, he presented a bill up in budget and tax. And it was a property tax credit for surviving spouses of fallen public safety officers or a judicial officer. Now, Senator Folden, who has put his life on the line for us, thank you, and has a very, very different perspective on that because of it. And yesterday, his very, very heartfelt, testimony drove home our collective responsibility to look out for the families of law enforcement officers who have made the ultimate sacrifice for us. I mean, we just can't take that for granted. We just can't. Which kind of brings me to my why as it relates to this legislation. And literally everything I do, it's because of my family. It's because of my grandparents who had limited education but made sure that their children, my parents, had that leg up from education, migrated north for work to provide a better life for my brother and I. And I'm just really grateful for that sacrifice that they did for me. It's my why. It's why I'm here. It's what I see, that sacrifice and a desire for a better life. What I see when I go and I talk to my neighbors, that they are simply here looking for that higher quality, a better life, and all those sacrifices that were done to do that, for us to have that life here. It's really why I support this legislation. Distrust and fear, those just really aren't elements of a better life. They just really aren't. It's not what we seek to have when we're seeking a better life. And I believe it is why two of my police chiefs and colleagues I represent portions of 12 police agencies that I have that are in my jurisdiction. And two of the chiefs, they approached me this summer about sponsoring this bill. The chiefs did. They believed, as I do, that transparency builds trust within our community. It's what they believed. Now, mass law enforcement apprehending people is familiar in repressive totalitarian countries. It's done to intimidate and to terrorize. That practice undermines community trust and makes us all less safe. I get the calls from my constituents, and it's real. It's very, very real. Now, what SB 1 does is it codifies the best practice of law enforcement transparency, building trust with the community that they serve. The Senate Bill 1, which bans law enforcement from covering their faces while conducting normal operations in Maryland, with reasonable exceptions in the bill, including for undercover operations and health-related matters, that's in keeping with our values of human dignity and setting up our community as a place where everyone can pursue that better life for themselves and loved ones. State law can and does require that anyone operating in our state comply with general laws, with the understanding that for federal entities, doing so would not significantly interfere with the performance of their duties. For example, while on the job, federal employees must stop at red lights and cannot violate speeding laws unless doing so would interfere with their jobs. A federal law enforcement officer who uses excessive force can be sued under state law for battery. You know, wearing masks is just simply not necessary for law enforcement to function. Now, what we know is that law enforcement on all levels has long operated without wearing masks. We also know that if wearing of masks was critical to tactically important, that it would be mandated, but it's not mandated. It is absolutely not mandated. It is otherwise actually treated as a conditional thing that allows for the officers to do it at their discretion. I mean, so we know that based on that if it were in fact necessary tactically, that it would be something that would be required and not simply left up to the discretion of an officer. So these conditions, not wearing masks in normal operations, have not, by their very nature, led to any adverse conditions as it relates to officer safety, nor targeting. There is no evidence whatsoever to support that claim. Colleagues, I would direct you to the written testimony, and you will also hear from Major Franklin, who speaks to this matter directly. And obviously, you're going to hear from him as well. The wearing of masks undermines the public trust and therefore does put law enforcement and the public in harm's way. I want to respond to the letter of opposition from MCPA and MSA. The bill clearly lays out exceptions to the circumstances listed in their letter. We work to be thoughtful with this legislation, and I'm actually not exactly sure why so much of that letter refers to exceptions that are already within the bill. Now, I acknowledge that it is unclear whether courts will uphold SB 1 if enacted. There are constitutional scholars on both sides of the argument. I would suggest that our charge is to pass this transparency legislation as our collective intent that masking within the normal course of duty has no tactical benefit, but does pose a risk to our collective public safety by creating fear and anxiety, particularly in situations that are already tense and would benefit from de-escalation. The examples are chilling, and we are all fully aware of them. For me, this is about basic human dignity and our collective pursuit of a better life, and I ask for your favorable report on Senate Bill 1. Thank you.
Thank you very much, Senator. We're going to hear from your sponsor panel, then we'll open it up for questions.
Senators, thank you. My name is Noreen Shah, and I'm the Director of Immigration Policy at the National American Civil Liberties Union, and also a proud Maryland resident. In my role, I work with legislators across the country who, like you right now, are debating whether to ban law enforcement from wearing masks. California has already passed a full ban. Connecticut has passed a limited one. And at the federal level, more than 100 members of Congress have sponsored legislation to ban law enforcement masks. Why are we debating this now? Because in our nation's recent history, no law enforcement agency has used masks to routinely disguise their identity and hide from the public until now. And this is a crisis for professional policing. As the International Association of Chiefs of Police, one of the nation's largest police organizations, put it in a recent resolution, after hearing concerns about masking from 35,000 of its law enforcement members, masks, quote, create confusion, fear, and mistrust among community members and responding agencies, potentially increasing operational risks and eroding public confidence. In our nation, masks have a history. Masks are what the Ku Klux Klan wore as they attacked homes, maimed and killed and terrorized millions of Black Americans. We take pride in our nation as a democracy. We call ourselves a free country, and we associate masks with the opposite, with the tactics of an authoritarian regime, where people must watch what they say, lest they be disappeared by masked agents operating without accountability. Today, go on Instagram and you will see unreal images. People tackled to the ground by men wearing ski masks. People dragged on the floor of grocery stores. This is not the America we deserve, nor the America our Constitution or our laws allow. By banning law enforcement masks, the Maryland legislature is making a promise to the people of this state. Clear rules, clear responsibility, public trust. We know what police look like in a free society. We know they need to be open and lawful.
Excellent, thank you.
Good afternoon. My name is Shayna Cotter, and I'm here representing CASA as its Deputy Legal Director. CASA urges the committee to provide a favorable report on Senate Bill 1. Across this state, masked men with guns have infiltrated our communities. They are terrorizing our communities and calling it law enforcement. They are taking and abusing our fathers, mothers, neighbors, loved ones. CASA hears these stories every day. CASA operates a hotline where community members can report ICE activity. Last year, we received over 2,000 calls and confirmed over 567 ICE detentions right here in Maryland. But behind these numbers are real people and real families. They include a young man near the Eastern Shore who called to tell us about a group of 6 masked men who tackled his father to the ground before his eyes. They took him away. A woman who reported that her husband was on his lunch break, eating his lunch in his car, when masked men approached his car, demanded that he get out, and when he didn't immediately, they broke his car windows and forced him out, taking him away. A secret masked police force enacting this type of violence is anathema to the rule of law and to public safety. Masked enforcement does not make us safer. It heightens the risk of violent crime. Across the country, in communities like ours, we are hearing reports of masked criminals impersonating ICE to commit crimes, including robbery, sexual assault, and kidnapping. When law enforcement conceals its identity, it creates a blueprint for these types of abuses and for criminal impersonation. SB 1 will not solve every harm facing our immigrant communities, but it is a necessary step toward restoring trust, protecting families, and reaffirming that no one in Maryland is above the rule of law. CASA urges the committee to provide a favorable report on Senate Bill 1. Thank you.
Good afternoon. My name is Eric Lopez, and I am with the Amica Center for Immigrant Rights. And our organization is pleased to offer a favorable testimony in strong support of SB 1. We are a nonprofit organization that provides pro bono legal defense services to community members detained by ICE in Maryland and the DMV area. Law enforcement officers who wear masks break the public trust by creating a sense of intimidation and fear into engagements with community members, Mask wearing contributes to the risk of escalation because it leaves doubt as to the legitimacy of the law enforcement action and to whether it is law enforcement officer engaging in valid operations. Our organization has been providing legal services for over 25 years, but this past year has been very different. It's unlike anything we've ever confronted. It's unlike anything our clients have ever experienced. They are terrified of the sights of masked officers posted up in immigrant neighborhoods. They are terrified of what might come their way. There's no certainty as to whether the masked people pulling them over in their vehicle is law enforcement. Additionally, many of our clients have experienced persecution in the past at the hands of law enforcement and private actors, and being approached by masked individuals can evoke a similar type of fear. Through the course of our work, we regularly represent community members who have been victims of crimes and those who have relied on law enforcement to help in their most vulnerable moments. Trust and accountability in our law enforcement is foundational to creating a sense of safety for everyone in Maryland. This bill recognizes circumstances that may require the use of masks. As such, it is well tailored to not impede law enforcement from engaging in their duties. The individuals that we serve would greatly benefit from this bill. It would return to them some semblance of safety in their daily lives that is no longer there. Everyone should be free of fear and intimidation, especially from law enforcement. Clear law enforcement boundaries build trusts and strengthen communities and institutions. For these reasons, the Amica Center urges that this committee provide a favorable report on SB 1. Thank you.
Excellent. Thank you very much. All right, Mr. Franklin, you're up.
Thank you, Chairman Smith and members of the committee. My name is Neil Franklin. I'm a retired major of the Maryland State Police with 34 years of law enforcement service. My full bio is in my written testimony. I'm also here representing Law Enforcement Action Partnership, a national nonprofit focused on improving public safety. I will be speaking from a law enforcement ethics and policy perspective. I've also submitted my written testimony for you to refer to. The main issue here is government transparency, specifically law enforcement. Policing across this country has made significant strides in reform to include transparency. In 2021, you passed the Maryland Police Accountability Act. SB 1 actually enhances the Police Accountability Act, directly related to de-escalation, which begins at first contact with law enforcement, putting members of the public at ease. Most police agencies have specific policies requiring the visual identification of its members, name tags, prominently displayed, and the oral communication of one's name, agency, and identification number. SB 1 is directly in line with this existing policy. Law enforcement members are the only government officials who have the power to revoke a person's freedom of movement. There should never be any government secrecy when someone's constitutionally protected freedom is revoked or even suspended. Last year, I provided a formal declaration for California's No Secret Police Act, which passed, and it took effect on January 1st. In closing, this is about accountability to the public which we serve. Those who have the greatest responsibility must be held accountable. Please give SB 1 a favorable report. And just so you know, I do this on my time. I don't get paid. That's how important this is to me. Thank you.
Excellent. Thank you very much, Mr. Franklin. We'll now turn to the committee for questions. The first question is Senator Muse and then Senator Love.
Thank you, Mr. Chairman. I want to preface what I want to say with these remarks, and I know none of you have ever heard me say anything like this before, but I'm very disappointment is not even the word. I think we have a president who's a disgrace. He's hateful. People say he's racist. I say he's an equal opportunity hater because he hates everyone. I've never seen anything like this, and we're almost like a nation under siege. Yeah. And that's why I am with this, a nation under siege. Garcia is in my district. And as much as I've talked to them and family, there's only one reason that he's doing it is because he's petty. And no matter how small it is, he can't stand the fact of losing. How do you put a family through this over and over again just because you are fearful that you are going to lose? And so I don't know what to say, but this is a result of his policies. I do not. My question would be, what legitimate reason can anyone give for someone who is a police officer of federal, state, or whatever, wearing a mask? What is the reason for that? Nobody, and I talked to my friends on both sides, no one has given me any legitimate reason or rationale for that whatsoever. So my question is, do you or have you heard of any reason for this? That's my question. And not only is it unprecedented, it just seems to be illegal. But, you know, in terms of case law, just illegal. Something that we've not dealt with, just walking in people's houses, you don't have to identify yourself. It's something as little as how can you, and pardon my ignorance, how can you pull somebody over for a traffic stop when you're not even official in that state to handle local matters? I do not know. My heart goes out to all, we say we're immigrants. My grandfather came here from Portugal, and I can go on and on with that. That is a disguised way of saying we hate anyone who is not like me. And as I said, it's not, for me, it's not black or white, it's equal opportunity hater, right? What have you heard at all that would even make any kind of sense?
Thank you for the question, Senator. In the bill, we have outlined certain circumstances where it is appropriate for law enforcement to wear a mask. As I mentioned, we've been thoughtful on this.
Yes, you have. I read that.
Including in undercover situations. So we have been thoughtful in this bill for those instances. But what we don't abide and have not found any evidence of is that it is a best practice in the normal course of doing law enforcement. No one has shown that. In fact, it degrades the trust with the community and creates a more unsafe environment. That's the answer.
Thank you. Thank you, Mr. Chair.
Thank you, Mr. Chair. Senator, ICE has done deportation actions previously, prior to this administration, correct?
Yes.
And there's actually been a lot of those over previous presidents, correct?
That is correct.
And there was no systemic use of masks previously, correct?
That is correct.
So not having these masks did not affect their ability to conduct these activities, correct?
That is correct.
Thank you.
Thank you.
Mr. Chair, if I may, one more. Major, can you explain something to us? We've just learned that ICE is now telling its trainees and new hires that they do not need a judicial warrant to enter someone's home. So can you explain to us the impact of a masked person entering someone's home on the situation? What impact would that have on safety, on the de-escalation or escalation of the situation?
Thank you, Senator Love. In addition to this being constitutionally illegal without a warrant signed from a judge, this is just an accident waiting to happen. And it's not really an accident because it can be prevented. Going into someone's house masked, and we've already heard that, there have been incidents of masked impersonators who have been kidnapping people across the country and committing other crimes, pretending to be ICE agents and federal agents. But going into someone's home, which is their castle, their place of safety and refuge, it's only a matter of time before someone gets hurt, and before a law enforcement officer gets hurt, before a citizen gets hurt, protecting themselves and their family from this type of intrusion. It's very dangerous. It's not wise. It's nowhere near a good policing tactic. And I just want to say, I worked undercover. I worked on the Maryland State Police state team, their SWAT team. And every time we would conduct a dynamic entry using a SWAT team, and some of those members would be masked, but the first thing we would do would place a marked vehicle somewhere outside of the home to let people know that this is bona fide law enforcement coming into your home. And we would announce that we have a bona fide search warrant or a warrant signed by a judge. But what we are seeing from ICE and the advice being given and the direction being given by their higher-ups is completely wrong. It's dangerous, it's illegal, and it's a matter of time before someone gets seriously injured or maybe even killed.
Thank you. Thank you, Mr. Chair.
Thank you, Mr. Chairman. Thank you for bringing the bill forward. I appreciate the kind words, and I appreciate I do appreciate the impetus behind this piece of legislation. I just have a couple questions.
Of course.
So, just retiring after 30 years this year, I don't agree with, the face coverings in the manner in which, through some law enforcement actions, because, here in Maryland, we don't have this problem per se with our law enforcement that are under the purview of our state banner and our Constitution within the state of Maryland, because we can dictate that. However, I say that because we're also in very unprecedented times where doxing and AI has become a real issue. So I hear what my good friend from Montgomery County brought up about not being an issue before, but we're also in new times where doxing is a real issue. And so, and for people that have never been, it's not, the last thing any law enforcement officer wants to do is bring their work home, whether it's because of what you've seen, been a part of, or having to take certain actions and through the process of enforcing the laws. Having said that, they want to kind of insulate their family from those traumas, right? Having said that, the last thing any law enforcement officer ever wants to happen is that their family threatened because of what they do. So they're not even bringing it home per se, but they're bringing it home because others are taking their own actions to do nefarious activities. So I just want to ask you, what authority would the state have to dictate to federal law enforcement on what their policy, procedure, or would be for forcing them to comply with this?
Right. Thank you, Senator. And again, thank you for putting your life on the line for us. I appreciate you. As was stated earlier, as it relates to the doxing, Senator, I haven't found where that has occurred, nor have I found where that has occurred over the course of law enforcement through decades and decades and decades, when folks were not, that they weren't wearing the mask, and there were still similar actions, because we obviously invest great power in law enforcement, and I know that you take that very seriously, the responsibility that comes with that. And then there are those protections that come with that too, as we already well know. And so, Senator, I just would say to you that we have not seen those instances, and that we do have to be measured in looking at the benefit for society as it relates to the negative consequences of what we have seen with this masking, and that removing that versus something that just really hasn't occurred. The fear has occurred. The terror has occurred. It's real. It's happening every day. And I just feel like we have an obligation to do something about it.
Okay, thank you for your answer. So, I mean, I'll just say that there's a press release from October 30th from the DHS Assistant Secretary Tricia McLaughlin, in which it references that ICE agents have seen an increase, a 1,300% increase in assaults upon them. by people also trying to intervene in a law enforcement, official law enforcement matter that, by the way, has been carried out by every president, regardless of party, over my lifetime anyways. They've all had these provisions in place in federal law, and they've enforced them. So the masking is newer, right? But we're also, again, going back to the AI and the doxing makes a difference. And I bring that up because in that report, in that press release, they talk about where the federal grand jury issued an indictment charging 3 women with following an ICE officer home, then posting his home address on Instagram. And then there's another incident of an ICE officer's spouse in Texas being called at her home and being harassed. And I don't want to say all the explicitives that are in it, but it's a pretty long, lots of angry words, and then ended up saying, you know, basically, did you hear what happened to the Nazis after World War II? Because that's going to happen to your family. So I think that's the thing. I would like to have this conversation like we've always had. I have a great respect for you and what you do, and having these, it's just disappointing to me that we have such extreme divergence, if you will, especially on the fringes, to where we don't have the ability to have a real good dialogue. And so a lot of fear-mongering happens. There's a lot of inflammatory rhetoric that goes with some things. And I'm not saying that the fears that you expressed are not real. I'm not saying that at all. But I just want to say at the same time that the concerns that I see through law enforcement lens that they're experiencing are also real. So with that, I mean, I just, and I didn't see if there was a provision for cold weather, if it were to be.
Yes.
Was that in here? Did I miss that?
Yes.
Okay.
Yeah.
Yep.
Weather is included.
Okay, I didn't see it.
Yes,
I just
sir.
wanted to ask. Thank you. And then the last thing I have is you know, I'm looking at through, I know there's federal doxing laws, and we've had some discussions here about those same type of things. I mean, is that something that the good senator would be open to also maybe co-sponsoring that to kind of peel back some of that anger and hate that's going on to allow for people to have civil discussion without fear, and then those that are perpetuating this type of hate and anger, then there's also accountability in that. So
on both fronts, Senator, I'm happy to talk to you about
Sure.
it, you know, on the one hand. On the second one, on the instance that you referenced, if folks were being followed, I mean, they're being followed. Like, that's not with the mask or without a mask, they're being followed, right? So that's a different sort of situation, of course, where, you know, so I would just suggest that would be the case with what you shared. And yeah, so those are just kind of like my responses to your question.
I appreciate the response.
Thank you.
Thank you.
Yeah.
Thank you, Mr.
Thank you, Mr. Chair. Thank you, Senator, for bringing this. Look, I don't want to talk about the 30,000-foot view. I want to talk about the mechanics of this bill.
Okay.
And to understand why parts of the mechanics of this bill are included into this.
Okay.
Not exactly sure attacking the president and the administration is the right thing, good, bad, or indifferent. So, like I said, I want to get into the mechanics.
Yes, sir.
So, as I read this bill makes a uniform decision in a misdemeanor punishable by jail time. Can you point to evidence where an officer's wearing face covering in such a widespread problem that warrants criminal prosecution rather than internal discipline?
It happens every day in my neighborhood, Senator. It's every day in my neighborhood. So yes, if you come to my neighborhood and you see the terror that is occurring on a very regular basis, you can get an opportunity to see what is happening on the ground.
And therefore, that speaks to my 3,000 view that I understand why you were brought this bill here. But that doesn't answer the question.
Okay, I'm sorry. Restate the question that I missed it.
Why that the bill makes a uniform decision that a misdemeanor punishable by jail time.
Yes.
So can you tell me what evidence we have that has happened in Maryland that we're going to make this a criminal prosecution rather than an internal discipline.
I'm just going to have to reiterate what I just shared, Senator, in that, and perhaps the panelists who have spoken about the number of people who have experienced this and maybe we're just talking past each other. I find that to be compelling evidence of a need for us to act.
Right, and I get that. We may be talking past each other, and that's not the intention.
No, neither of us, of course.
That is your intention whatsoever.
Right.
But I am talking about, here is an officer. I'll have another. So SB 1 requires an officer to waive all civil immunity for a violation. I tend to believe that it creates a strong incentive for officers to hesitate, to be disengaging or dangerous situation, because they might want to avoid personal ruin.
It would only be, Senator, if they're wearing a mask, which there's no tactical benefit associated with it. Just don't wear the mask, and it doesn't have anything to do with you.
But why of the mechanics does it eliminate, waive the civil immunity of the violation? I'm not talking that you're correct. You don't wear the mask and you're not going to do that.
Right.
I'm talking about choices have consequences.
Always.
Choice was made to wear the mask.
Yes.
And the consequence of that is you waiving your civil immunity, making a criminal prosecution. Maryland has been doing an admirable job of getting rid of felonies. I am a second chance guy. I've supported these things. We're giving people second chances and giving them the opportunity. But when you waive somebody's civil immunity for a violation, and therefore they can be held personally responsible and then have civil personal financial ruin, I tend to believe that we're not trying to protect or correct a behavior. We're actually trying to use a bat. If we pass a bill that says we're not going to do this, I just don't understand why the officers can be held personal in giving up their civil immunity, and then which then can lead to financial ruin.
We are a state of law, and we have law, and that law has associated enforcement and penalties. We do it all the time. I listened to some of you all's testimony. There were other proposals in here suggesting changes to the penalties. This is no different. We're simply establishing that, number one, don't wear a mask. But if you do, then there are consequences in our state. You want to speak to it?
Personal financial ruin. We have a police accountability board that in 2024, we put $8.4 million into a police accountability board. In 2025, that number has gone down to $4.8 million. And actually in the budget books that came out yesterday, forecasting out, they're zeroing that out. Now that could be we're going to pass on the financial burdens of the state of Maryland for police accountability boards to the counties, or we're finding out that through corrective behavior for policies that are lying in the state of Maryland for its police officers, such as wearing body cameras and having a board that allows them to warrant those who believe that they have been wronged, but we don't eliminate. We are doing internal discipline to correct that behavior, not, as I said, I'm using the words, criminal persecution. I understand why we don't want to do it, wear the mask. What I don't see, and the disconnect is, why is it criminal prosecution? Really, because, and then I'll lead to this, and I apologize for going on a little bit of a.
It's okay.
So there was a bill way back. We never passed the law for banning Ku Klux Klan hoods, and I supported that, meaning we should ban that. It's wrong. Nobody should be masking up, whether you're protesting or you're on the other side of protesting. No one should. We should have full transparency. But we don't have criminal prosecution for somebody who we could take internal discipline to correct that. I'm just trying to figure out, I understand the why, I just don't understand why we have to have such a big stick. Because I tend to believe that is not going to give us good police officers who are going to second guess in their community policing and trying to.
So the answer to your question is that as the Senate sponsor of this, I've felt very strongly that we needed to have strong enforcement mechanisms because of the damage that this practice has on the fabric of our community and human dignity in our state. That's my rationale, Senator, and I appreciate and understand what you shared with me.
And I'll close with this, Mr. Chair, and I apologize.
I was only going to make to see if everyone qualified.
Understood. So you had started with your testimony, the fear, anxiety, and mistrust.
Yes, sir.
The fear, anxiety, and mistrust.
Absolutely.
That is being forced upon a community that didn't ask for that.
No, our entire society, Senator. Not a community, our entire community, our entire society.
I paraphrased it, I
Yes, sir.
misspoke, sir. And you had said basic human dignity.
Yes.
I'm not exactly sure that the penalties that are based in this bill eliminate fear, anxiety, mistrust, and basic human dignity.
If they make it such that we don't have these folks going around with masks, it will have been successful.
But I'm talking about those in the police community. I'm talking about the penalties for such violation.
But I know I'm repeating myself because we are sort of talking back and forth. Don't wear a mask. You don't have to worry about it. And that's the intention. And that's really where it sort of ends.
And I get all that.
Yeah.
But we listen to bills every single day.
Yep.
Senator Sidnor has a concern about a bill yesterday that is serious consequences, and he's 100% correct that we should not be pulling people over because of their skin color. We just shouldn't be. 100% correct. What I'm trying to get at is, I get that we're trying to correct behavior, but my issue has to do with the penalties.
I've heard it. Thank you, Senator.
Thank you for that consideration, sir.
It's so good to see you, Senator. And
see you,
whether
too.
we agree or not, I think you always do a fabulous job in thinking through what you're working on. But I do have a couple of questions, and I'm certainly going to get do my own research and get some Attorney General opinions. But I was wondering, to me, we should have a model policy. But because I do not have any expertise in law enforcement or the subspecialties, nor do I know whether the entity you're asking to do this would normally agree that we should have model policy and then a predetermination of the outcome. I think a model policy should be the best standards, and consensus around them. So I kind of agree with you. I kind of assume that we go in that direction, but I do not think it's effective I do not think we should be predetermining model policy outcomes. So I don't know if you'd be amenable. I'm sure we want to correct some bad behavior, but I just don't know about model policies, because to me, we need a model policy on face coverings, right? And as you already pointed out, somewhere in the bill, there's at least an exception for undercover. Since I don't know the depth and breadth of this, I don't know whether they would determine a model policy prohibiting in all circumstances, in every place, through all law enforcement, exists for every mission and those that may be outside. So I have a little trouble with the universality and predetermination.
Can I answer that? Because can I answer it? Because I can't keep up, I'm going to tell you. But so I do want to answer.
I was repeating myself.
That's okay. No. I mean, if you have a subsequent question, I did want to answer that question, though, Senator. And what I wanted to say is that the way the bill is written, it charges them with writing the policy, but then asks that it take these elements into that policy, which we do. That's us affirming our legislative intent, but does leave to those who are the ones who do these things for them to write it. So I just wanted to answer that in that way.
I read all of that
Yes,
part,
sir. Yes, ma'am.
but we started with a banning, and then we kind of almost implicitly contradict ourselves. So I don't like that inconsistency, or that even that element of doubt about where we're going.
Yes, ma'am.
Okay. And then I do not know the answer to this either, which is, but I've never seen this in law on page 2, P3. I've never seen a stated predetermination of the outcome of evidence. That to me would be something that a court and a separate part of our government would consider an intrusion into their authority. I just don't know if you can
Where are you,
put into
Senator?
law that. On page 2, it's Roman numeral 2(3). That generalized and undifferentiated fear and apprehension about law enforcement officers' safety is not sufficient to justify the use of face coverings. Now, maybe you just meant you don't want the commission to look at that, which also doesn't seem consistent with asking them to do their independent model policy creation. But I don't know if that language is in any way intended, inadvertently or not, to tell courts of law that may be adjudicating the new crime or civil penalty you have in here. I've never seen anybody say what is and is not sufficient evidence for anything. So I don't know where that language came from and whether you got some help or you perhaps didn't get help. So I'll throw that out, and I'm going to, follow up with other lawyers that have some expertise.
Thank you.
Okay. And then I'll move on. I think more generally, I think the two other things. One, I often cover parts of my face, not intentionally because I'm wearing a scarf, to cover my mouth or my jaws, my ears. So I feel like the way you have explicitly gone into great detail here might also undermine the independence and expertise of the commission to kind of look at how covering should and should not work, and inadvertent versus intentional, covering of your face and the circumstances under which, this should happen. I want a model policy to be driven by those experts, not by predeterminations and languages and bills that I don't know but don't believe you consulted with those experts exhaustively or extensively to draft this. So I don't, did you?
We worked with folks like Major Franklin. I would also just, again, say that the way that it is structured, and I do understand what you're saying, Senator, but the way that it is structured, it does allow for the creation of the model policy, but it does include, it is, as we do, I mean, we express our legislative intent, and then we allow for the experts to work within our legislative intent. So that's all that it's doing. It's just expressing our legislative intent.
Legislative intent is in either, it's in the preface of the bill and it's.
Oh, it's also throughout. It's throughout, as is the case.
Well, legislative intent, all right, anyway. And then the last thing, because this is so thorny, that I don't know how it works, but we have, I believe, immigration enforcement, I'm not an expert, is exclusively and solely the jurisdiction of the federal government, for logical reasons, you know. Military, foreign affairs, protecting our nation, foreign affairs, and protecting our borders. So there's good reason, and it's foundational, and, you know, and has been around constitutionally. So I don't know, and you just have to tell me, has law enforcement agencies in this state had the authority to make these decisions and mandate that a separate law enforcement entity mandates to that separate entity that they create a policy consistent with this, and either other states, other jurisdictions, or the federal government? And then the second one, have they done it when an entity like the federal government has sole exclusive jurisdiction in an area of law?
As was stated at the beginning of
I'm sorry, I know I was out.
No, it's okay. As was stated at the beginning of this, the state of California has passed such legislation that has occurred. That's one. Two.
Been appealed?
There is no question about it that the Federal Department of Justice has sued.
Right.
I mean, yes.
Okay.
And that is the case.
Okay.
And that's fine. I mean, that's our system, right?
Yeah.
But they did do that. It has been done. It was passed. And so that's, you know, that's my response.
Okay.
It's
That
very
makes
much
sense.
modeled
Yeah.
similarly.
Yeah.
This is modeled similarly to that.
Right.
And so that's my response.
I just know that litigation is extraordinarily expensive, and we have an extraordinary budget deficit, so I hope.
I would suggest to you
Yeah.
that this is having an extraordinary impact on the people of our state and is well worth whatever we may need to do
I'm not
for it.
talking about the balancing of interests or what is horrifically occurring. I'm thinking about being strategic and wise and knowing there's a state.
Yeah.
You may have modeled your statute after.
Yes.
They're far ahead of us. Sometimes, you know, strategically using your legal money, your legal defense money, is not always having litigation going on. And then lastly, a little bit with Senator from Western Maryland, and you can get back to me on this, but did he ask you, do we have other areas in our state or across the country who have that can be found guilty of a misdemeanor, which I guess would destroy their careers, and command they waive immunities? Do we have any legal precedent that we can compel and command, constitutionally or otherwise, an immunity that is, you know, been adjudicated and reaffirmed numerous times by the Supreme Court? And you know,
There, as
think about how to
I said in my testimony, there are there's not consensus on that. Okay, I will say that the folks in California did pass legislation with similar penalty provisions, and so that has occurred, Senator, and
Thank
you know, these are unprecedented times.
Senator,
But we can follow up.
Did you have any opportunity to read and study the entirety of what California did, the opposition, the support, the legal things, and or have experts? I don't know if you're an expert in this.
Yes, I met with the sponsors. I met with many people to just get and to also to tweak and to make improvements to our bill.
Would you share some of that information with me?
I sure will.
Thank you very much.
Yep.
Appreciate it. Thank you.
Senator West. Thank you, Mr. Chair. Senator Augustine, I'm going to let you get off the hot seat for a few minutes.
Okay.
And sit down, and I'd like to talk to Ms. Shaw if I could.
Sure.
And Ms. Shaw, I'm singling you out because based on your curricula vitae, it looks like you are the most experienced lawyer on the panel, and I know Senator Augustine is not a lawyer, so I'm going to ask some legal questions, and I didn't want to subject him to questions to which he probably is not as well equipped to answer as you are. So let me start by saying I am very sympathetic to the idea that policemen should not wear masks. I don't think I've ever encountered a policeman in my experience in Maryland who wears a mask, unless he's sick, or the pandemic was raging, or it's freezing cold outside. So intuitively, my feeling is wearing masks is not a good thing to do. And I'm happy to sympathetically take a look at a bill which prohibits the wearing of masks. But then I advert to Senator Muse's question, why would we have some people wearing masks in the first place? And the answer basically didn't come from anybody except from Senator Folden. And Senator Folden talked about the problem of doxing. Now, if you'd asked me about this 3 years ago, I would have said, what's doxing? I never heard of the word, but we have broken through so many norms in the past 3 years. Seems norms are no longer observed. We just break through them willy-nilly. Who would have thought a synagogue would be bombed in Mississippi 2 weeks ago? Who would have thought that a Maryland judge would be staked out at his house and assassinated, as happened in Washington County 2 years ago? So you're a national ACLU lawyer. Can you give us some information about whether doxing of law enforcement officers has occurred anywhere in this country? And if so, with what frequency?
Well, first I want to address thank you for the question, Senator, and thank you so much for everyone's questions. To Senator Folden's point about DHS announcing a huge percentage increase in the number of ICE officers who had been susceptible to doxing, there are numerous studies debunking that number. It is shameful that we have to question what a DHS press officer says. It is very hard to trust the words coming out of the mouths of many of the people in this administration. This is the same administration that right after the killing of Renee Good, who was shot in the face in her neighborhood after dropping her child off, called her immediately a domestic terrorist.
Excuse me, could we get the political speeches? I asked you for some
The
factual
speech is this, sir, that these numbers about the number of people who have been doxxed who are law enforcement officers are not trustworthy numbers, the numbers that are coming from the federal government. I wish we could trust those numbers.
So to the best of your knowledge,
there is no other law enforcement agency in this country that is routinely masking, sir.
Let's not talk over each other. Let a senator finish the question, and then we'll come back. But
So you're saying, to the best of your knowledge, there has been no instance of doxing of a police officer in the United States?
That is not what I said, Senator. What I said was there's no other law enforcement agency in this country that is routinely masking out of a fear of doxing. The other thing I'll mention, sir, is that this bill does not create a blanket prohibition on masking. It asks an expert commission to establish a policy, and it does presume that we do not want routine law enforcement masking in the state of Maryland, and I think that's something all of us can agree on.
Let me go back to my question. Are you aware of any instances in this country in the past 5 years in which a law enforcement officer was doxxed or members of his family were doxxed? Are you aware of any such instance?
I know from speaking with law enforcement officials around the country that there is serious concern about law enforcement officer safety, and I think doxing is a part of that.
Okay.
But I've also heard from Mr. Franklin, who's on this panel, and many other law enforcement agencies and officers that they're more afraid of the climate, that these masks are creating a climate of hostility and aggression between law enforcement and the people they are meant to protect and serve.
Okay, now let's turn to the bill itself, which I assume you've read. I'm on page 2 of the bill. It says the Maryland Police Training and Standards Commission is directed to develop a model policy prohibiting use of a face covering by a law enforcement officer in the course of duty, consistent with Section 3-535 of this article. That, because this is a Maryland statute, this would apply to Maryland police officers, absent other language in the statute. Would you agree with that?
The statute applies, the bill applies to all law enforcement operating in the state.
That's a separate provision. I'm just going so far. By the time I get to the middle of page 2, it directs the commission to develop a model policy prohibiting use of a face covering by a law enforcement officer. would you agree with me that that would mean a Maryland law enforcement officer? At this stage in the statute, there's nothing in that sentence, is there, that would apply to federal law enforcement officers?
It says by a law enforcement officer in the course of duty,
Yes,
consistent with
but
earlier
we pass
sections.
statutes all the time dealing with law enforcement officers, and we never construe them as applying to federal law enforcement. Because we're a state legislature passing state laws, our laws apply to state law enforcement officers, correct?
Sir, the police power under our Constitution, as our founders dictated it, applies to the states. It is reserved to the states, and the Supreme Court has made that
You're
very...
saying that whenever the Maryland General Assembly has passed a law applying to law enforcement officers, our law applies to federal law enforcement officers? That's what you're
Our
claiming?
laws apply to everybody who's operating in the state. If you had a law that said you cannot shoot people in this building, it would apply to everyone in this building, sir.
So
That is in the police power of the state.
So the senator the section you're talking to is correct. The lines, you know, the 11 through 12 is that it's defined in section 3-535 of the subtitle, which is state law enforcement for this part of the bill. So
Thank you.
I know you guys are kind of talking past each other, but yeah.
Thank you.
So I think we're all,
Now I'm going to get to the
but
next section.
Just wanted for the record clarify what.
Now I'm going to get, now that we've gotten past that, I want to get to the next section of the bill, which is at the bottom of page 2, and which says, a law enforcement agency with law enforcement officers operating in the state shall adopt a policy consistent with the model policy developed by the commission under paragraph 2. Would you agree with me that this section does apply to federal law enforcement officers because it refers to law enforcement officers operating in the state?
Yes.
Okay. So you agree with me, and ICE, I assume, ICE, by the way, is the acronym for the United States Immigration and Customs Enforcement Agency, correct?
Yes.
Okay. You would agree with me that this section of the statute requiring a law enforcement agency with law enforcement officers operating in the state to adopt a policy consistent with the model policy developed by the commission, that section of this law, if passed, would apply to ICE?
It applies to every law enforcement agency operating in the state. It would apply to any law enforcement agency operating in the state.
A simple yes would have done, but that's fine. Now, is it correct, therefore, that if we pass this bill, it would regulate the internal policies of a federal agency governing that federal agency's operations by requiring that federal agency to adopt a policy consistent with the model policy adopted by our Police Training and Standards Commission?
If you look at ICE policies, they already actually are consistent with requiring identification of officers who are operating.
I'm sorry, I didn't ask that.
All right. Sorry. Just
let me go back again.
So let me just create a little space here. Just I let it go. Keep going. Just
take a deep breath.
Yep.
My question was whether or not you agree that the paragraph at the bottom of page 2 would regulate the internal policy of a federal agency governing its operations by requiring that federal agency to adopt a policy consistent with the model policy adopted by the Maryland Police Training and Standards Commission. Isn't that what that paragraph says? Yes or no?
I'm not following, Senator.
Let me ask the question again. Is it not correct that the final paragraph on page 2 would regulate the internal policies of a federal agency, i.e. ICE, by requiring ICE to adopt a policy consistent with the model policy developed by Maryland's commission?
Senator, the context here matters. And federal law matters, sir.
I'm looking at the words.
Okay.
What about these words is ambiguous?
Sir, I didn't say that they were ambiguous. I said context matters. And I'll read to you 8 CFR 287.8, little c, 2, little 3. Immigration officers effectuating an arrest must identify themselves as soon as practical and safe to do so. There is no federal law that authorizes ICE to wear a mask, but federal law does require identification in many circumstances.
With apologies, that was not my question.
Okay.
Let me once again read the final paragraph on page 2, and I want to ask you a question about it.
Okay, sir.
The final paragraph says, a law enforcement agency with law enforcement officers operating in the state, and we agree that includes ICE, shall adopt a policy consistent with the model policy developed by the Commission under paragraph 2. And my question to you is it not correct that that therefore constitutes a directive to ICE to adopt a particular policy identical to the policy that we have adopted here in Maryland?
I would let a court decide that, sir. I'm not here to litigate what this policy requires, and at some point, if the bill becomes law, I'm sure a court will do so.
Okay, thank you for your answer. So you're familiar with the supremacy clause of the U.S. Constitution, are you not?
Yes.
Just, yeah, okay. Okay, no, I think I know where you're going. And so just, we do, the language is here, so I'm not, the answer is yes for your question. So I know, I'm just saying, just for the record, the language is what it is, so I mean, just be factually, so yes.
I'm glad the chair and I agree that the answer is yes.
The answer is, I know where you're going with this, but I'm just, I just want to make sure that.
I've got 2 more questions on this, and then we're done. So you are indicated you are familiar with the supremacy clause, which was interpreted critically for the first time in the famous case of McCullough versus Maryland, in which Chief Justice John Marshall Harlan wrote, "States have no power in any manner to control the operations of the federal government."
I'm sorry, sir.
Excuse me. Are you familiar with the statement in McCullough versus Maryland
Yes.
in 1819 by Chief Justice John Marshall Harlan? Excuse me, John Marshall, interpreting the supremacy clause as providing that the states have no power, quote, in any manner to control the operations of the federal government, close quotes. You're familiar with that?
It's been a while since I read that, sir, but I'll take your word for it.
All right. And finally, more recently than 1819, there was a more recent decision, Mayo versus United States, in which the Supreme Court held the activities of the federal government are free from regulation by any state. Now, the chair of the committee and I have agreed that that last paragraph on page 2 purports to regulate the operations of ICE and require it to adopt a certain policy. How do you square that fact with the language of the supremacy clause as interpreted by the U.S. Supreme Court?
Well, I can quote another Supreme Court decision to you, sir, which is SCOTUS saying, there is no greater example of police power.
Which decision? What was the site?
I'll give it to you in one moment. There is no greater example of police power which the founders proposed in the states than suppression of violent crime. And I do believe this bill is about violent crime. Impersonators in our state and in our country who are wearing masks to perpetrate crimes. The Democratic Women's Caucus in Congress wrote a letter recently saying that as women, we are told all of our lives to fear masked men in unmarked cars, to run from them if we see them. And now the FBI has a bulletin, a memo saying there are many crimes that are being committed by impersonators. And so this bill is not only about transparency and accountability, it is about crime in this state, and that is squarely within the police power of this state to deal with.
So when I asked you about the supremacy clause, McCullough versus Maryland, and another Supreme Court case saying that the states have no power to control the operations of the federal government, your response is that's irrelevant when we're talking about police power.
Well, we can quote Supreme Court decisions to each other. And by the way, the one that I quoted is U.S. v. Morrison, 529 U.S. 598 from the year 2000. And I can quote another one, Johnson v. Maryland, an employee of the United States does not secure a general immunity from state law while acting in the course of his employment. Sir, I know all this will be litigated. We know that the U.S. Department of Justice has brought a lawsuit against California's bill, which has become a law. Connecticut passed a measure that is limited to courthouses, but is also a mask ban that will be challenged. There are states around the country that are considering these same bills, and they will be challenged, and all of this will be litigated by better lawyers than me.
Do you understand that that the California law that's being challenged currently in the federal court in California contains language consistent with the language at the bottom of page 2, providing that a California law enforcement, that the ICE must adopt a policy consistent with a policy adopted by the state of California? Is that part of the California litigation?
I don't have the California bill right in front of me,
provision
but I can get back to you on that, Senator.
Okay, thank you. Now let's turn to the second part of the bill, which deals with what most people have talked about so far. Not the requirement that ICE adopt a policy, but rather the provision that says on page 4 of the bill that a law enforcement officer may not wear a face covering while in the performance of duty in the state. So what is the constitutional predicate for the state of Maryland passing a law that says that an ICE law enforcement officer cannot wear a face covering while in the performance of his duties in the state of Maryland?
Well, sir, it's similar to any general regulation that applies to everybody who's in the state. So if we had a general law that said you can't recklessly kill someone, that would apply also to law enforcement personnel. There are some limitations. There's a few different doctrine. The Supreme Court has not ruled on some of these doctrines in over 100 years, and so the exact contours of them is unclear. And as I mentioned, we expect that the Trump administration will continue to litigate this. They have begun in California.
Now, in the spirit of fairness, I want to help you out for a moment, and then I'm going to conclude. Todd Lyon, the acting director of ICE, recently stated that masking of ICE agents, quote, is not mandatory, close quotes, and that he would, quote, allow, close quotes, agents to keep masking if they chose to. Seems to me that differentiates this situation from other federal policies. If there were a policy requiring ICE agents to wear masks, I think this bill would be in a different posture and would be much more constitutionally suspect. The fact that ICE agents are permitted to wear masks if they want to, if they choose to, makes this a horse of a different color and makes this particular piece of legislation on page 4, not on page 2, but on page 4, less constitutionally suspect than it otherwise would be. Do you agree?
So, Congress, I would just add this one thing is that, good thing for us that Mr. Lyons isn't the actual arbiter of what is the law and what is lawful for ICE. It is Congress.
I was trying to help you out.
Yeah. I just want to be clear that Congress has passed laws limiting the use of masks. They have not passed a single law authorizing the use of masks. So that is why it is an even different situation than the one that you described.
All right. Thank you for your answers.
Thank you. For Mr. Franklin, good evening. When I've had an opportunity to see what has been happening on our streets, I remember watching a television series called The Watchmen. Are you familiar with that series?
I might, not really. I can't say.
So in The Watchmen, there was this white supremacist organization called the 7th Cavalry that had threatened the police force. So everyone in this particular police force, they all wore masks so that no one knew their identity, no one knew that they worked as police officers because this white supremacist organization took it upon themselves to want to kill police officers. And I mention that because I'm just out of curiosity, given your experience, is there really any valid reason for an officer outside of performing some of the types of services that you talked about, going undercover and the like, to really be walking around in masked?
There's no tactical advantage to wearing a mask outside of what we've already discussed. In the normal performance of their duties, it's actually a disadvantage, in my opinion, in my professional opinion, because it creates distrust in policing. Right off the bat, when you're approached by a law enforcement official who's wearing a mask, you're on edge. The citizen, the members of the public are on edge. And so if we're about de-escalation, if we're about solving an issue, we need to begin de-escalation right at the beginning. And that is the public knowing your identity. That is the public being comfortable knowing that you are an official member of the law enforcement community. I want to say that, unfortunately, I think the higher-ups, the administration, is putting our federal law enforcement agents in danger by using the tactics that they're using. As we talk about doxing, as we talk about some of the other issues. Again, when Obama was during his administration, when they were deporting, thousands of people, we never had this issue. We weren't masking. It was about the tactics. It was about treating people humanely. It was about interacting with the public appropriately, and to where you demonstrated that you value their humanity. But the tactics that we are currently using in federal law enforcement are, in my opinion, creating the problem for law enforcement. This work can be done using the proper tactics, and the public would not be upset at the level that they currently are. And so doxing, even though I don't think it's an issue, in the minds of those who are doing the work, I don't think they would see it as an issue if they were using more humane tactics in going about this work. So, and again, and let me just end with this. In the business that we're in policing, yes, you're going to have people who are mad at you. Judges have people who are mad at them. Prosecutors have people who disagree with them and who threaten them. But can you imagine our judges or prosecutors wearing masks in the performance of their duties? I think it would be a problem. So, yeah, it's the potential danger is part of the job, but I don't think it's anywhere near the level that we're hearing about.
Mr. Chair, we don't have anyone from State's Attorney's Office or anything that's going to be testifying on this at all. Yeah, for any State's Attorney's offices? No. Okay. Maybe for our attorney, you'll be the closest proxy to a State's Attorney that I believe I can get. Because I've had conversations with a State's Attorney with the concern of masked people coming up on people and them not knowing who they are, and just given the right to self-defense. If someone comes up on someone and they're masked and you have no idea who they are, given that we're so loosening the rights to wear and carry and use guns, I often wonder if a masked person came up on me and I happen to be wearing and carrying, if I shot them, would I have that ability to argue self-defense successfully if I was concerned about being maybe harmed or kidnapped? Do you have any thoughts about that?
Senator, is that for me?
That is for you.
Senator, it's such an important question, and I've been asked this question in the context of people saying, I want to know my rights, what should I do? I've been asked this question on live television. What do you tell women who are afraid that if somebody attacks them, they don't know if it's a law enforcement officer? And the ambiguity here is something none of us should have to deal with. I don't know the answer to your question, sir, about whether or not you'd have the right to self-defense. What I do know is that all around the country, people are being attacked by masked individuals who are impersonating law enforcement professionals. And I think every day, I'm so glad that I live in Montgomery County where I don't have to worry that my local police might be those masked individuals. I know I have that public confidence, that confidence myself in my law enforcement officers that are serving my community.
No, I mean, and the other thing that, concerns me is you see that when people have resisted, and I'm not even talking about shooting, but just resisting because they have no idea who's coming at them and assaulting them, then they get federal charges on resisting arrest and the like. And I just, you wonder what is in the minds of our federal officials to make them think that this is safe. And I'll say, just in listening to my colleagues as they've been asking questions, I believe the sense that I get from this panel is I don't think anybody likes the idea of masked officers. I think the question is, what are we going to do about it to protect Maryland citizens? And if we don't like what is being presented to us now, then what do we do? Because the fact of the matter is we cannot act today as if all this stuff that's happening that we see, this is not normal times. The federal government is not acting in constitutional manners right now with people. We not only have people who are being claimed to be immigrants that are here illegally, we have U.S. citizens who are being detained, and even upon showing their papers, the federal government isn't saying that these papers aren't good enough. A birth certificate from Maryland isn't good enough. So it leads you to wonder, I mean, how do we as legislators protect our citizens?
Absolutely, Senator. And just to add that it's not all federal law enforcement who believe that they should be masking. The FBI put out a bulletin in October warning that criminal actors were using a recent increase in ICE actions to take to their advantage to impersonate. The FBI urged law enforcement officers to, quote, identify themselves during operations and cooperate with individuals who request further verification. And the FBI cited multiple examples across states, frightening cases, including in New York, 3 men in black vests entering a restaurant claiming to be ICE, tying workers' hands, pulling a garbage bag over that person's head. I'm not going to read all of these that involve women because they are horrific, involving sexual assault. But the FBI is taking this seriously, and I know that the members of this panel are as well.
You would hope that the Department of Justice would take it seriously.
Yes, sir.
More seriously than what they are. My daughter had just come from a trip from Panama and gave me a really nice hat. It says Panama. Unfortunately, I was having a conversation with my wife and said, you know what, I don't even know if I want to put this hat on my head. Because right now, from what I'm seeing outside of what happened to Miss Good in Minnesota, it seems that the track record that I'm seeing is if you're not white, you're going to be targeted. And I've been told I'm ambiguous looking enough that I might be caught up in this system, which concerns me. Could you speak to that, Senator?
The reason, again, going back to the purpose for this piece of legislation is to uplift transparency in our state, to uplift the trust that has been built with law enforcement over time that's being broken down by these decisions. And I just want to circle us back to that, and that's the reason why that this legislative intent of this is to address exactly what you're talking about, Senator.
Because it seems like it makes us more unsafe than safe.
That is correct, and this is what we're trying to do. We're trying to make all of us as a community more safe.
Thank you very much.
Senator, please just follow up with this, because as Senator West was asking you some questions that I thought we already gone over, I just realized one of the reasons immigration has, and the Supreme Court has affirmed that they have exclusive and sole discretion or authority. And it's true in a couple other areas like commerce, because what happens, and I don't know how you would respond, but federal preemption usually happen because if different states come up with different solutions, it becomes unworkable, confusing, and so on. So I don't know how.
I did want to address that.
Yeah.
So
I don't know how you would deal with this, but let's say 3 other states compel ICE in a similar fashion as your bill mandates, that they develop policies that are different than the ones you're interested in. And then forgetting how you feel about it, how can it be an effective, enforceable, comprehensible, everybody understands when 50 states weigh in different ways.
Sure.
Yeah.
I do understand that. And I just want to say, as I started, that there are, as it relates to like the constitutionality, there are arguments on both sides of it from a constitutional standpoint. What I would also say, though, is that we do have the ability to establish general laws in our states, as do the other states. I mean, we do have states' rights. Okay.
Of course.
So that is a portion of this conversation as well. Now, there are, and there have been in the in some of the cases, there have been these tests with regard to the reasonableness of that. So it's not settled, Senator. I started with that it is not settled, but there have been those tests. And different circuits have acted in different ways as it relates to that as well. And so I appreciate what you're saying.
I'm just trying to.
But we do have, each of our states, we have very different laws that pertain to federal matters. That's our job. I mean, that's a part of what we do as it pertains to inside of our state.
Senator, whenever I ask these questions, it is always with an eye toward whether the bill can effectively and solve a problem that will not be struck down or not work or hasn't been thought through. It is never to challenge the goal or any support or to betray how I feel about this, because I only do this to see if we can improve the bill or if there's a better approach. And it may be that the approach you've taken or anybody else's approach I do not think is workable or will not be upheld. But so the last thing, and it's really my fault, so thank you for your patience because I stepped out of the room. If it's in your testimony, then that's fine. But for every case law that you are relying on, that you said, I know the case law that does not support this bill. I don't like to talk about what I do. I have some experience with this. But I don't know the case law that you say makes this unsettled. Now, could be law review articles. I'd love to see them too. I don't want to make more work for you. If it's in your testimony, that's it. I'll go get it. If it's not, would you have your staff send me all the references that you think support the ambiguity?
Yes, and I did not put it into the written testimony. Some of the cases that I would have here, we could surely get that to you.
Thank you, Senator.
Absolutely.
Thank you, Mr. Chair. I just have one real quick question, and it actually is for counsel, Senator.
You don't want to talk to me anymore?
No, I love talking to you.
Okay.
I've loved our colloquy. Do you mind coming up to the podium, ma'am? Thank you. So I'm just curious. I believe it was Senator West that asked you earlier if you had seen or heard or any reported instances of doxing, and your response to that was like.
Do I listen to myself speaking, sir? Not always, but I thank you for the question. I work at the federal level, at the national level, so what I'm taking in a lot of is what the administration statements are, which is why I pivoted to that. But so I want to recognize the absolute necessity and importance of considering law enforcement safety whenever any policy is enacted.
Sure, I appreciate that. So you're really good, counsel, at like really pivoting well. So I'm just curious because did you search? I'm curious. Did you search and try to find any instances of reported doxing before you prepared for this?
Well, I brushed up mostly, sir, on the Constitution and the Supremacy Clause because I figured that's where I would get the most questions. I've been preparing for this because I work in a lot of legislatures. I work with the ACLU all over the country. And so I can say that one of the things I did when we started thinking about the masking problem was talk to law enforcement officials themselves. A lot of them come to Capitol Hill, so I had the opportunity to speak with them. And what I heard from them was that the idea of law enforcement putting on a mask was actually antithetical to what they thought of as good policing, community policing. And so what they were bringing to me wasn't that concerned about doxing. Actually, I heard a lot of concern and even outrage from law enforcement leaders about the way they were being tainted by what ICE was doing.
Yeah, so look, I believe in transparency, especially for our law enforcement and being good stewards of protecting our communities. But my question goes back to, it's not the first time you've heard about doxing. So I would have thought that being, knowing that you're coming in this environment, that it's not the first time you've heard it.
Sorry, not to interrupt you, sir.
I'm sorry?
Not to interrupt you, but just to say that I've also advised on legislation at the federal level that would provide funds for ICE and other federal law enforcement agents who are concerned about their identity, their information being online and being used against them.
But that's not my question. My question is, did you research and look for any instances of doxing?
No, I did not last night
So-
do a Google search for doxing, no, sir.
Okay. I meant any time before this. I mean, you said you've testified
I have.
before
I
at
mean,
Capitol Hill.
generally I have, yes.
And at that time, you found nothing.
No, that's not what I said, sir.
I'm sorry?
That's not what I said. I never said that no law enforcement official has been doxed in the country. That would be
So your
pretty
answer would
absurd
be that
claim.
you're then aware of instances of. Because earlier when you were asked, you pivoted to. So I'm asking if that is the case. So you have heard of instances of law enforcement officers being
I've heard of the administration statistics. I don't know of reliable statistics on this.
What would be a reliable source? Like PBS? No, and the reason I'm bringing that up, the reason I'm asking, and I mean, I'm not being smug. I did a quick search. I'm just asking. So I did a quick search and there's plenty. I mean, I'm pulling up PBS, which shows that 3 federal agents were doxxed in Los Angeles in September. And they were live streamed, being followed back to their home from their work. I mean, that by virtue of.
Once again, Senator, I've said, and let's back on the bill, which is around the masking, right? And again, I answered you on that with regard to those instances that you said where people were being followed, and I acknowledge that, right? But I said, if they're being followed, that's because they were following the individual. Now, whether or not, and it's a hard job, right? There's no question about it that law enforcement has a hard job. There's no question about it that we have a hard job, right? That people, do some things that aren't good to us and do some things that aren't good to law enforcement. I'm not disagreeing with that. But what I will say is that, we took an oath, they've taken an oath as well. They have certain protections that are in place because we know of the challenge and the things that they face in that regard. And we also have this responsibility to care for our community as a whole, which is a part of this balance that I think that this piece of legislation brings. And this is the reason why I think this piece of legislation is very, very important, and that we do have to take into account that balance. It's not to dispute entirely what you're talking about, but we do have to have a balance, and that's our job. And I think that this piece of legislation sets the right balance to protect the public, make sure that we are building on trust in the public, and not creating an unnecessary situation that's detrimental to law enforcement, who I'm grateful for the fact that they're willing to take on that hard job.
Yeah, thank you for that, Senator. So what I was getting at, my point was I was trying to pick up on the details that she had said earlier that she didn't recognize.
I appreciate that.
My point being is after speaking with the good senator to my left here, there was some discussion about, has there been any consideration? Because doxing is the malicious practice that involves gathering private information, identifying information, releasing it online without a person's consent, usually in an attempt to harass, threaten, shame, or exact some type of revenge.
And Senator, what I said was I would be willing to talk to you about that in a separate piece of legislation, and that this one is focused where it is.
So Senator, look, I got you. I know what you're asking, and you actually, look, I don't think you're going to get an answer that's to your satisfaction on this, but I want you to continue. But
I just have one. I just wanted to get to this point, which was because I know the reason behind the bill, but there's additional things that I wanted to ask you about, which was, you know, one of the things that I notice as a lifelong law enforcement professional is I would like to make sure, as I'm sure the good major would like to see, is that I don't want to see people with blank ballistic vests being worn. I want to see them having proper identification on them. I want to see them having a name outward on them. I want to see them having their badge readily identifiable so that there is no confusion. At the same time, like this, so it kind of goes hand in hand with your discussion, not necessarily the way that, because it's around masking, but it's about proper identification. So that's all I was getting at, was that there's other ways that this is being utilized, and there is a protective measure that was necessary. So thank you for your time.
Thank you, Senator.
Okay, excellent. Further questions from the committee? That was a joke. There are no further questions for this panel. All right, Senator, thank you very much. I appreciate it. No, thank you very much, Senator, and thank you all very much, the panelists, for being here. Mr. Franklin, good to see you. All right, we will now move on to the next round of witnesses. Dana Bergman, Linda Green, is Viviana Westbrook here? Give folks some time to make their way up. And then is Christopher Cano here? Come on up, sir. All right. Who would like to start first? If you can, come up to the podium, if you can. Ma'am, would you like to start? Yeah.
Sure.
Sure.
Thank you, Chairman, Vice Chair, Committee. My name is Viviana Westbrook, and I'm an attorney who works throughout the various states as well as DC to champion welcoming policies for immigrants. Now, I'm here today in my personal capacity to testify in support of SB 1. In the last year, we have seen a horrific erosion of due process as ICE has run roughshod over constitutional protections. As someone who has been providing many Know Your Rights across the state, I understand my rights and expect law enforcement to identify themselves when asked. Because ICE agents have hidden behind masks and often withhold their identities, the public's trust has been broken. We need a law enforcement that is proactive in identifying themselves and who do not hide behind their masks to cover up their crimes against our communities. Since I've sat in on conversations in other states about masking, I know that there is a question about federal preemption that's already been talked about. And to these concerns, I say, we do not have anything explicit either by our Supreme Court or Congress that says states cannot regulate federal law enforcement when the activity that they are conducting is so clearly, willfully, violently harming our community, our state. California's law, was signed in November, or it was signed last year, and DHS challenged it in November. So we need to see where that's going to go, how it's going to play out. But honestly, it will be a long time for something to be definitively decided in the courts. So we need to proceed and take the opportunity to protect Maryland citizens. We all live here. We all call this home. And for doxing, if you're worried about the public being angry about the blatant disregard and violation of human, the violation of human rights and constitutional rights that is currently being perpetuated, then maybe you need to rethink your approach and how you treat our communities. ICE is attacking our homes, our house. Our silence will not protect us. My plea to all of you is please keep us safe. Thank you.
Thank you very much.
Thanks for having us. My name is Linda Green, and I'm a resident of Mount Rainier. I'm a retired physician and a member of Healthcare Workers for Palestine and the International Coalition for Human Rights in the Philippines. Both of these are situations that have led to a lot of power from the state against relatively vulnerable people. These things have informed my work in the American Public Health Association and more recently in my community. For the past several years, masking has become a politicized issue, even when it comes to protection from airborne illnesses. Last year, masking became an issue in legislative circles because residents seeking an end to the genocide in Gaza feared both medical disease and political persecution, doxing, and unfounded charges of anti-Semitism. Careers, educational tracks, and safety were all reasons that students and faculty masked during protests because they feared the power of the U.S. government, which was seeking to protect its interests by any means necessary. Dissent over government policy was viewed as anti-Semitic rather than a fight for justice and humanity. It is the credit of the Judiciary Committee last year that you listened to a lot of people speak on this issue. This year, the power of the U.S. government has taken an even more ominous direction as it uses military personnel and an expanded Homeland Security force to attack immigrants working in the country. Racist profiling, random detentions and deportations, and violent attacks on residents have led to protests once again. This time, federal enforcers have worn masks and refused to identify themselves. They do this to intimidate residents as well as to protect their identity when snatching residents off the streets, out of medical and educational facilities, and using gas and bullets to deter protesters armed with whistles. State power does not seem to be enough protection for them. The enforcers from ICE, Border Patrol, Park Police, Transit Police, Secret Police, and other agencies know that they are participating in fascism and seek to hide their identities. The secret police and Gestapo-like army needs to be resisted, and this bill is a small step towards that. Thank you very much.
Hello, I'm Christopher Cano, Director of Political Legislative Affairs for SEIU Local 500. Our members are over 20,000 strong in this state, from education and social servants to public safety adjacent roles. And central to the mission of our union is advocating for transparent, accountable, and community-centered public safety systems that earn the trust of all of our residents. This bill advances these principles by setting statewide standards on the use of face coverings by law enforcement. And these recent events, which we don't have to rehash here after we just sat through this hearing, really shows that our communities are demanding right now. The public is crying out for transparency and accountability. And I think that the most important thing that we can do as a state, as Marylanders, each and every one of you in those seats of power right now, is ask yourselves, what can I do? And advancing this legislation is a simple step towards doing that. You're not going to change the policies of this administration. You're not going to change the tactics that are currently being employed that people are objecting to. But what you can do is say that you did something. You can look your grandchildren in the eye and say, when the push came to shove, I actually stood up and I spoke out and I did something about it. And so this is what it is about. It is necessary for the foundation of public safety that we protect workers, families, and neighborhoods alike. And you have to ask yourself, if federal immigration operations have operated in previous administrations and deported far more people, why is it so public now? Why do we see these issues? Why the mask? And then you have to ask yourself, you know why the mask? Everyone here knows exactly why, because you can see it in the tattoos of the recent recruits. You can see it in the fact that we haven't seen a Proud Boys rally in a long time. But you know the fact that recently it was released that their leader is currently operating under ICE. So look, all in all, I had this long, flowery speech to give to y'all today, but it's not going to matter. As you can see, half the room is already tired from speeches and going back and forth. All I'm asking you is that on behalf of our members, do what's right in this moment.
Greetings, everyone. I'm Diana Bergman, a Carroll County resident, a first-generation Cuban immigrant. I'm a mother and a spouse of a veteran United States Army retiree. Carroll County Sheriff signed into 287G agreement. What I've seen in Carroll County last year in April, shortly after session ended, just 7 minutes away from my home, a young girl recorded an immigrated custom enforcement agent breaking the window to her mother's car and detained her mother in a violent and aggressive manner. As I witnessed this video, I heard the terrifying screams of a child begging a masked man in full tactical gear to not take her mother. This took place 7 minutes away from my home in the United States of America, in the same country my family has been making multiple sacrifices for the last 21 years. I've lived in multiple installations across the nation where federal police did not wear masks hiding their identity, nor did they patrol our neighborhoods with heavy tactical gear. So why do I feel so unsafe, terrified, and uncertain about Carroll County's law enforcement? Because when an individual intentionally is hiding their face and masking their identity, is perceived as a threat. When you're a woman, a mother, who watched a masked man shoot and kill Renee Nicole Good during the everyday tasks like dropping off their child at school, in seconds, a masked man took her life. Unmasked for good. Vote favorable for Senate Bill 1. Public safety, law enforcement officers prohibited in face covering. Thank you for your time.
Excellent. Thank you all very much for your testimony. Are there any questions from the committee for the panel? Nope. Seeing none, thank you all very much. Thank you. All right, we've got virtual, we've got one more virtual. Is Monica Brooks in the Zoom room? All right. And Charlotte Hoffman. Is Charlotte Hoffman here? All right, let's go to the Zoom room, and then we'll switch over to the favorable with amendments. Monica Brooks, is she in? Ms. Brooks, you're up. Welcome. All right, Ms. Brooks, you are up. All right, while we wait for Ms. Brooks, let's have Jane Horvath, who signed up favorable with amendments.
Oh, okay.
Welcome.
Thank you so much, Senator, and I really appreciate the opportunity to speak to the committee today. My name is Jane Horvath. I'm a resident of Prince George's County, and I volunteer with a pro-democracy group called Indivisible in the Route 1 corridor chapter. My testimony, which you have, focuses on the impersonation aspect of masking, and it documents cases, 3 cases in Maryland, of impersonating law enforcement with masks, and then around the country, things that have happened just in the last year and a half. And then there's other information in there about law enforcement policy organizations that support law enforcement, and their analysis of sort of how this masking trend is concerning relative to impersonation of law enforcement. So that's all in there. I have 2 suggestions in there for changes to the bill, thinking about the supremacy clause, basically, and I can take some questions on that if you want. I wanted to, most importantly, tell you that Route 1 corridor, we petitioned for unmasking legislation before we knew the senator was doing this. And we did farmers markets all the way up and down from the DC line up to Beltsville. And just a couple days a week, couple hours, we got, in 7 weeks, from the middle of August to the end of September, we got about 2,000 signatures. And then in an online petition, we had 1,000 more. And again, it was just limited to sort of a portion of Prince George's. So I think it speaks to, and when we were in the farmers markets, when word spread that we were there with these petitions, people came up. And I was working with 3 clipboards at one time because there were so many people wanting to sign this petition. So I just wanted to let you know there's a lot of enthusiasm out there for this. People feel a great need for this. And I urge you all to support.
Excellent. Thank you very much, Ms. Horvath. Questions from the committee? I'll just say thank you for your community-based activism. That in conjunction with the work we're doing here today, it'll get us through. So I appreciate your work. Thank you. All right, we have Ms. Brooks. You are up. Welcome. Please be safe.
I am pulled over. Thank you so much. Good evening. My name is Monica Brooks, and I'm president of Wacomico County NAACP, and I'm also the regional chair of the NAACP for all of the charters of the NAACP on the Eastern Shore, 9 counties. and I am in favor. We're giving a favorable report for Senate Bill 1. We are opposed to law enforcement being able to operate masked and refusing to give their names or badge numbers, detaining people in unmasked in unmarked vehicles. The idea that they have these masks on has become a very strong way of intimidation and a tool of intimidation. Today, these agents behave in a way that is replicating the same kind of fear and unacceptable behavior that occurred in the Deep South in Jim Crow. No civilian should be expected to submit to a masked stranger, unknown and unverified, who will remove them to an unknown location. That is not public safety, it's terror. Fear escalates situations and encourages panic and makes abuse of power more likely, which is we've seen. It's been evident. And as the previous person testified, there have been incidents of people who have been pretending to be law enforcement. So we don't know who is real and who is not. And so law enforcement authority depends on legitimacy and accountability. When officers hide their faces, refuse to identify themselves, and operate anonymously, they remove both of these. And if their work is lawful and professional, there's no need to conceal themselves. So I urge this body to support Senate Bill 1 and not allow these officers to continue in this way. Public safety requires transparency, and this is not what it looks like. Thank you.
All right, thank you very much, Ms. Brooks. Questions from the committee? All right, seeing none, thank you very much. All right, that concludes the testimony for the proponents of the bill. We'll now switch to the opposition panel, and we have Shari Rendell. Rendell.
Chairman Smith and distinguished members of the Judicial Proceedings Committee, thank you for allowing me to testify today. My name is Sherry Rendell. I am the Director of State and Local Engagement for the Federation for American Immigration Reform, which is a nonprofit, nonpartisan organization. We have over 3 million members and supporters. In Maryland, we have 12,300. If enacted, SB 1 would provide that prohibit law enforcement officers from wearing a mask, which would violate the Supremacy Clause by attempting to regulate federal agencies and by forcing them to adopt certain policies. Moreover, this legislation demonizes law enforcement officers who are simply trying to protect their identities and keep them and their families safe by stating that a generalized and undifferentiated fear and apprehension about safety is insufficient to justify wearing a mask. Well, I pulled a couple of articles recently that show there is justification for this. There was a Fox News article that was January 14th, just days after the Renee Good shooting, where an ICE officer did a legitimate traffic stop. And after he tried to do that, he was attacked by the person resisting arrest, and then somebody came out with a shovel, a snow shovel, and attacked him as well. There was a case in October where 2 vehicles were used as weapons. What we have seen is that Homeland Security, the Department of Homeland Security has seen a more than 1,300% increase in assaults, a 3,200% increase in vehicular attacks, and an 8,000% increase in death threats. This bill simply sows division and hatred of immigration officials. Ironically, while this bill will forbid immigration enforcement officials from wearing masks to protect themselves, ICE protesters regularly do wear masks. I thank you for the time to speak today and urge an unfavorable vote.
Excellent. Thank you very much. Questions from the committee? Senator James has a question.
Submitted written testimony?
I did. I submitted.
And then you just cited, the thing you just cited with the increasing, incidents of doxing and harassing, is that in your written testimony?
It is in my testimony, and I can send you a link from Department of Homeland Security if you would like that.
Yes, I would. You can send it to the committee?
committee? I would be happy to.
Because that was some data that I'd like to look at. Thank you.
I'd be happy to share.
All right, seeing no further questions from the committee, thank you very much.
Thank you.
All right, with that, that'll conclude the testimony and the hearing for Senate Bill 1. Senator Augustine, thank you very much. All right, we'll now move on to Senate Bill 45. I'm going to ask the Vice Chair to take the 245. I'll bring up Mr. Vice Chair, the sponsor panel. Wait for everyone to transition back in, but if the comptroller, yes, come on up. The comptroller would like to come up with the sponsor panel, and then County Council President.
Well, no one's here.
I know, yes, roll through. All right, we'll get started. Hey, members of the committee, Senator Will Smith here, Senator from District 20 here to introduce Senate Bill 245, legislation that will end the state's formal relationship with Immigration and Customs Enforcement, ICE, through the 287G program. Now, Maryland is one of the most diverse states in the nation. 17% of our population is comprised of immigrants, and as our comptroller will undoubtedly mention, that over 21% of our labor force is comprised of immigrants. So not only is our population diverse, but the set of immigrants in our community, in our state, are also very diverse. And Senator McKay is not here, but in an effort not to veer too much off of the four corners of the bill, which is to end these agreements, I do have to say that this is a particularly disorienting period of time in our politics. The social norms of decency, compassion, fact-based decision-making, notions of fellow feeling, and faith in our democratic institutions have seemed to just erode, and it's happening so quickly. Just as I was driving in today, I read an article this morning that mentioned about the new memoranda that said you can enter into a private residence without a judicial warrant, just an administrative warrant, which was crazy to me. I get in and I open up my laptop again and I read about a 5-year-old boy who was ripped away from his family in Minnesota and with his father. 5-year-old boy coming back from school. He's now in, I think, San Antonio, 48 hours after being ripped away from his family. And now you saw just tonight, the president has issued a directive for agencies that are grant-making agencies to do a review of states with so-called sanctuary policies to see how he might be able to restrict federal funds for states that stand up to this atrocity. And the manner in which all of this is happening, immigrants have been used as this pawn for this whole political dynamic. And ICE has been used as that tool to vilify immigrants, to stoke fear, to disrupt lives and communities, and to divide us. So one of those things that we've done in this committee, which was, I still have PTSD over this effort, but police reform, you all remember that, and how hard we worked to develop legislation that would restore a once fractured relationship between law enforcement and the communities that they serve. The 287G program undermines this trust in law enforcement, the trust that we've worked so hard to repair and to create, creating an atmosphere of suspicion and distrust with the community members who may choose to avoid law enforcement for fear of deportation and racial profiling. And since its inception in 1996, the program has ensnared individuals for minor infractions. And now there have been even more collateral collections or deportations than ever before in our nation's history. And that 5-year-old boy, Liam is his name, is just a key example of that type of atrocity that's happening before our eyes every day. And as I mentioned earlier today, according to one recent report from the ACLU that ACLU cites in their testimony, from September 1st to October 15th alone, this is in 2025, 2/3 of the 700 Marylanders arrested by Immigration and Customs Enforcement were never charged with a crime, let alone convicted. The manner in which the program has been administered has also bypassed due process for thousands of people across our nation. And I'm here today to say that we should no longer divert our precious and critical law enforcement resources to federal immigration enforcement. Instead, our law enforcement should be relentlessly focused on public safety. And that's what this bill intends to do. It's also important to note that if an individual has been arrested and is considered to be a threat to themselves or others, they will be detained until their trial date, regardless of their immigration status. It's also important to note that anyone suspected of a crime will be tracked, traced, and held accountable by every element of law enforcement in our state. Now, we took a committee site visit to see the two 287G programs. We take one in Harper County and one in Frederick County. And despite our political differences, and I think we have a departure opinion on almost everything, I do want to thank both of those individuals for opening up their facilities to this committee so that we could go in and understand how the program worked firsthand. So I do appreciate the hospitality that they extended to this committee, even though I don't agree with basically anything else that they do with regard to the 287G program, but I think it's important to note that. Now, the program, 287G, is obviously, it's a part of the Immigration and Nationality Act, which became law in 1996, as I mentioned. And currently, although we're learning now there may be a fourth iteration of the program, but the three programs that are most prominent throughout the country are the jail enforcement model, the warrant service officer model, and the task force model. In Maryland, we have two of those that are present, the jail enforcement model and the warrant service officer model. As was mentioned, before this administration took its oath of office almost a year ago this week, three jurisdictions had the jail enforcement model. And since this latest iteration of the Trump administration, 5 more jurisdictions have come online with the warrant service officer model. No jurisdictions, to my knowledge, are currently pending with additional agreements, except for Wacomico County withdrew their consideration after understanding from the Attorney General that they would be subjected to significant civil liability. So in their wisdom, they withdrew from that process. So what the bill does very simply is on pages 2, lines 7 through 19, it strikes and says that every state unit of local government, a county sheriff, or an agency, officer, or employee, or agent of the state, or unit of local government may not enter into an immigration enforcement agreement, and that any entity currently in an agreement must exercise its termination provision no later than July 1st of 2026. I'd also like to emphasize that there are other programs available to ensure that you balance that due process and if you're looking to do immigration enforcement when folks are incarcerated. I'm not promoting this program, but I'm just trying to educate the committee to make sure that we understand the full scope of things that are on the table and in play in the state of Maryland and across the nation. If and when a removable non-citizen has been found guilty of a crime, ICE, through its criminal alien program, already issues detainers and commences with the removal process. Again, not condoning this, just trying to explain what the options on the table are under the current environment. The core goal of this is to identify allegedly removable non-citizens who are incarcerated in jails and prisons and then initiate that. So that process is still available and operational throughout the nation. Under these other options, the 287G program is even more so unnecessary because at least on the back end, you've gone through due process. You've had a trial, you've been convicted, and then you've gone through the removal proceedings for a non-citizen who is removable. That to me, and we can talk about that program later on, but that to me seems to further necessitate the removal of the 287G program in the state of Maryland. So for all those reasons, I'm going to ask this committee, I respectfully request a favorable report and just keep the current events top of mind. I mean, the pace of which this is all happening is, the word unprecedented has been thrown around too many times, but it is something that we have an opportunity in this committee and in this state to take a strong moral stand and pass legislation that's going to impact the lives of our neighbors. And so with that, I respectfully request a favorable report. I'm going to let the panel testify, and then I'll stand by for questions from the committee. Madam Comptroller, would you like to stand, or do you want to stay?
Whatever you
want. Yeah.
Thank you. Good afternoon, Mr. Chair, Mr. Vice Chair, members of the committee. For the record, I'm Brooke Learman, the Comptroller of Maryland, and I'm here today in support of Senate Bill 245. As we all know, Maryland is home to a large and diverse immigrant population that plays an essential role in the social and economic life of our state. Immigrants represent nearly 17% of Maryland's population, and he was stealing my thunder on our stats, but yes, more than 21% of our labor force. These residents are deeply integrated into our communities, our workplaces, and our local economies. Policies and enforcement practices that create fear and uncertainty among immigrant communities can have consequences that extend beyond the individuals directly affected. When families are reluctant to go to work, attend school, engage in daily economic activity due to fear of immigration enforcement, those impacts are felt across our state, including by employers, by local governments, by our retailers, and by essential service providers. So I want to highlight the economic implications of these dynamics today. In April 2024, the Comptroller's Office released a report examining the role of international immigration in Maryland's economy. And that analysis found that immigrants make substantial contributions to the state's workforce, tax base, and overall economic growth. And, I want to get into some of the details, but just a few. For example, immigrants make up approximately 23% of Maryland's STEM workforce and 23% of registered nurses statewide. Immigrant communities also greatly contribute to our state's revenue through taxes and spending. The American Immigration Council data shows that 2023 immigrants paid $15.8 billion in federal, state, and local taxes and had total spending power of $39 billion. Also, we have seen new studies on the impact of immigration enforcement. Numerous studies have now demonstrated that when immigration enforcement is very salient, immigrants in the U.S. pull back on their spending because of fear from going out for public or in public or for leisure. If immigrant communities believe that local law enforcement is the same as immigration and customs enforcement officers, then consumer spending may decrease whenever police are present, even our local police. In fact, Orange County businesses lost nearly $59 million in economic output over the 8 weeks following immigration enforcement surge in Orange County. So it's just important to recognize that policies that promote stability and trust within immigrant communities also help protect and buoy Maryland's economy and increase our economic resilience. Ensuring that state and local law enforcement agencies are not placed in roles that undermine public trust, supports community safety, supports workforce participation, and our economic continuity. For these reasons, I respectfully urge the committee to issue a favorable report on SB 245. Thank you.
Good evening. My name is Natalie Fanny Gonzalez. I'm the president of the Montgomery County Council. I have such a great honor to be here with all of you today in support of Senate Bill 245. Thank you so much for your leadership to move this forward. I'm only going to say a couple of things. As you all know, Montgomery County does not have an agreement with the federal government on 287G. Why? Because we care about public safety. If you care about public safety, you need to ensure that every single person who lives in this state feels comfortable about calling the police when they see a crime. 287G does not help with that. So that's number one. Number two, I welcome you to please understand what's happening in this nation today. I am an immigrant. I'm the only immigrant on the Montgomery County Council, and I'm proud of it. But I'm telling you, the country that when I arrived to this nation back in 1996, time flies, and I compared that to what's happening today, it is hard for me to recognize this nation. My mom brought me here because it's a nation that respects the Constitution, respects human rights, respects civil liberties. Right now, we have an agency who's kidnapping our communities regardless of where they were born. We have kids who were born here, afraid. My two children who go to Montgomery County Public Schools asked me the other day, Mommy, do you know where my passport is? My kids are 12 and 13. I had them back to back, totally planned. 12 and 13 years old, asking me where their passport is because they're afraid. that they could be kidnapped by ICE. And now you may ask yourself, well, Natalie, you don't have 287G in Montgomery County, but let me just tell you, my residents go around the state to work, to shop, to entertain. I have people in Montgomery County who go constantly to Frederick County, to other places in the county, and I need them to feel safe. And I need them to know that they can call the police no matter where they are in Maryland, because they are a law enforcement agency that we can trust. So 287G doesn't do that. So if you don't want to do it for economic reasons, do it for public safety reasons. 287G does not move Maryland forward and does not protect the values that this great nation has always, say that they have across the world. So with that, thank you for having me today, and I look forward for you to say yes to this, I'm getting all confused. There you go. He got it on the record. Thank you.
Good job.
You don't need me. Good job. I'm like in the back. All right. You don't need me. All right.
Good evening. My name is Ama Frimpong. I'm CASA's legal director. Thank you, Chairman Smith, for your leadership in sponsoring this legislation. In 2025, CASA responded to 567 ICE detentions in Maryland. These ICE detentions, part of the estimated 4,000 detentions across our state last year, tell us that our immigrant community is being targeted with aggressive violence and cruel intensity. The federal administration's mass deportation agenda has unleashed fear and terror into our community. 287G feeds into that fear and terror. 287G serves a mass detention and deportation effort that is characterized by violence, lawlessness, and deprivation of basic individual rights, depriving a person of the right to plead their innocence before a criminal judge, and then depriving the person of the right to defend against deportation before an immigration judge in violation of court orders, statutes, regulations, and the Constitution, all while beating, torturing, and in some cases reporting on the news, killing our community members. 287G does not target serious or violent criminal offenders. It targets all who are, quote, suspected of being in violation of civil immigration laws, including a father who was handed over to ICE by Frederick County officers in February 2025 on the basis of a civil immigration violation. He had resided in this country for 22 years, had recently lost his child to cancer, and had no criminal history whatsoever. 287G does not enhance public safety. It actively undermines it. By turning local officers into ICE agents, 287G destroys trust between police and immigrants communities. When people are afraid of the police, they stop reporting crimes, and public safety is lessened for everyone. Maryland must disentangle itself from the violent and unlawful immigration operations of the federal government. Ending 287G is a necessary step that gets us closer to rebuilding trust within our community and aligning our values statewide. Thank you for your time.
Senators, thank you for the opportunity to speak with you again today. My name is Noreen Shah, and I'm the Director of Immigration Policy at the National ACLU. More than ever, participating in the 287G program is dangerous. It's dangerous to public safety. It's dangerous to our law enforcement agencies. Joining 287G right now means being embroiled in a reckless, dangerous enforcement spree spearheaded by Trump administration figures who openly flout the law, flout the Constitution, flout their own agency's policies. State and local agencies that join this are going to be asked to do things that they shouldn't be asked to do, things that could cost municipalities millions in damages lawsuits. Local agencies participating in 287G may want to rely on ICE to make judgment calls about who to detain, but they will be held responsible for the Fourth Amendment violations that result. ICE itself has disregarded evidence of individual citizenship and legal status repeatedly. In late December 2025, ICE arrested, detained, and refused to release a young woman in Maryland, a mother, despite her attorney submitting her birth certificate and her hospital records. The risk of ICE error and lawsuits is one reason why Maine and Delaware this year joined New Jersey, Connecticut, Illinois, Washington, Oregon, and California, a lot of states, in prohibiting 287G participation or collusion more generally. The Trump administration is misusing 287G in dangerous anti-democratic ways. I've researched this all over the country. They're using 287G to consolidate their power and their reach into our communities, to build a national policing force that is a threat to dissent. We see this vividly in Minneapolis. It's not just about immigrants, it's about all of us who protest, who refuse to toe the line. We cannot trust ICE and Border Patrol when they say they will limit what they do in Maryland. Well, they will limit what they do through 287G. We know that it's too dangerous to trust a wolf in a sheep's den. Thank you.
Mr. Vice Chair, members of the committee, my name is Stephanie Wolf. I'm the Director of Immigration Services at the Maryland Office of the Public Defender. We urge this committee to issue a favorable report on Senate Bill 245 and end 287G agreements in Maryland. These agreements, which obligate local officials to do work on behalf of ICE, undermine due process and make innocence irrelevant. They require local jail officials to screen, sometimes interrogate, process, detain, and transfer to ICE custody any person that ICE suspects of being deportable under civil immigration law. There are no exceptions for mistaken identity, dismissed charges, acquittals, minor traffic offenses, or any other arrest of a person who just isn't a threat to public safety. In fact, 287G actually targets these least culpable groups of people because it only targets people who are being released from the local jail. That is not the state prison where you are released from after serving a sentence on a serious violent crime. That's why the majority of people impacted by 287G in Maryland do not have convictions, and almost none have convictions for serious violent crimes. Over 7 years of this program in Maryland, for every one detainer placed on someone with a serious violent conviction, 115 detainers have been placed on someone with no conviction at all. And the national data shows the same pattern. Nor do 287G agreements protect our communities by reducing ICE enforcement outside the jail. In fact, the opposite of that is true. They allow ICE to use our legal system as a force multiplier, freeing up their agents, their detention space, and their resources to make more arrests on our streets. Data from around the country, which is illustrated in my written testimony, shows clearly that states with more 287G agreements have more total ICE arrests per capita and more community ICE arrests. We urge a favorable report.
Thank you all for your testimony. Thank you, Mr. Chairman. We thank Senator Karen Lewis-Young for her activism. A special thank you to my county council president for her presence today. We'll now move to questions, and we'll start with Senator West.
Mr. Chair. Mr. Chair, I promise you this will be a much shorter colloquy than the one
I don't know how much that really means right
earlier
now,
this
but,
afternoon. So I want to go over with you exactly what happens. You and I were together out there in Frederick County. We visited the sheriff's office that day.
Yeah.
And I finally got the soup to nuts about what goes on. So let's hypothesize two individuals in Frederick County, one named John, the other named Paul. ICE goes after John. So ICE, in some way, identifies John. And it is correct, is it not, that the 287G agreement doesn't involve the Frederick County Sheriff's Office in any way in identifying John?
No, so we have a detention center model, so that's correct.
Right. That's
not always the case, but we passed legislation to curtail that activity. Yeah.
So ICE goes out to apprehend John with officers. None of the Frederick County officers are involved in that group of people that goes to arrest John, right?
Nor could they be under our current law, yes.
Exactly. So John gets arrested by ICE, and ICE does not bring John to the Frederick County Detention Center. ICE handles the possession of John's body totally independent of anything involving the Frederick County Sheriff's Office, correct?
That's correct.
And then ICE, because there is no place to hold John, ICE typically puts him in an airplane and flies him someplace else where there is a place to hold him. Typically these days, I think the state of choice is Louisiana.
Well, typically go to a detention center in Baltimore and then from there out. But yes,
out to Louisiana.
Right. Yeah.
And again, the Frederick County Sheriff's Office isn't involved in that decision or the transporting of John in any way, correct?
That's correct.
And then from the Louisiana Detention Center, presumably ICE does whatever it does, and John ends up being deported to another country, again, without any involvement of the Frederick County Sheriff's Office.
That's correct.
So ICE's operations in Frederick County are totally extraneous and independent of the operations of the Sheriff's Office when we're talking about John.
When we're talking about field enforcement, that's correct in that regard.
Now let's turn to Paul. So the Sheriff's Office gets a call, a 911 call of a rape, and they go out to investigate the rape, and they interview the rape victim, and the rape victim says, Paul did it. And the Sheriff's Office does what it does to identify Paul and find out where he's located. And ICE isn't involved in that either, is it? That's entirely the work of the Sheriff's Office.
That's correct.
So they're operating totally independently of ICE.
At this stage, correct, yep.
Okay. So the Sheriff's Office locates Paul, and they go out and send officers to arrest Paul for the rape. And they get to where he's located, and they maybe break down the door and grab him and physically take possession of his body, handcuff him, and put him in a police car. Again, ICE has no involvement in that, correct?
That's correct.
So then the Sheriff's Office takes Paul to their detention facility in Frederick County, where he is fingerprinted, mugshot, and then ultimately comes before a commissioner who decides that there's probable cause to hold him, and he is therefore held by the Sheriff's Office of Frederick County, again, without any involvement of ICE, correct?
Potentially. So there's going to be an in-doc process, and there's going to be a line of questioning. The line of questioning will include references to citizenship and place of birth.
Well, my understanding is it's only after he's held by probable cause that there is a screening process which occurs to find out background information and prepare for the ultimate trial.
Now, once you are arrested and brought into that facility, that detention center, you are going to get fingerprinted. You're going to have an in-doc questioning, and that line of question will include questions about your citizenship and about your place of birth.
Okay, and during that screening process, for the first time, if the Frederick County Sheriff's Office has signed one of these 287G agreements, for the first time, they're going to do something differently than they would normally do because of the 287G agreement. They will ask questions about that person's nationality and find out whether or not, and through using not only questions, but also going to do background research on documents, find out whether that person is here illegally or legally, correct?
That's right. So they'll run that name, and they have a computer terminal in the detention center. A federal immigration officer or the person doing the intake for the detention center, correctional officer, has a CAC card, a common access card. Will use that to access a database and check to see if there are any detainers for that individual that are active.
Okay. So if this bill is all about requiring counties to terminate their 287G agreements or not enter into future 287G agreements, I think we've established that as far as John is concerned, there never was any coordination or involvement of the Sheriff's Office of Frederick County with ICE. They operate completely independently as far as John is concerned.
That's correct. There should be coordination because we should have local jurisdictions alerted to enforcement activities in your jurisdiction, but unfortunately, that is not the case.
It's not the case. And the agreements that the Sheriff's Office in Frederick County signed do not require or provide for any such coordination.
I'm sorry, say that one more time.
The 287G agreements themselves don't provide for coordination in the case of an apprehension of John, to use our hypothetical?
Because we only have two agreements legally available in Maryland, that's correct.
Right. So, and with respect to Paul, there's no coordination, no involvement of ICE in what the sheriff's office in Frederick County is doing until after Paul has been apprehended, taken to the detention center, and now is being screened at the detention center.
That's right.
At that stage, Paul has been arrested for committing a crime, correct?
Correct.
So the only people...
An alleged crime, right? I mean,
alleged crime.
An allegation.
Alleged crime.
Yeah.
So the only people who are being screened pursuant to these 287G agreements are people who have been arrested for alleged crimes. Is that accurate?
That's correct.
So there was testimony earlier that most of the people that ICE is apprehending are not criminals. They're ordinary citizens. That's not the case with these 287G agreements. The only people that these 287G agreements apply to are people who have been arrested by local law enforcement authorities for having allegedly committed crimes, correct?
Allegedly committed crimes, and obviously there's an element of due process that we're kind of blowing past in terms of someone's conviction. But yes, it's an allegation, not a conviction, and there has been no trial or fact finding at that point.
Great. And then after the screening occurs, the 287G agreements provide that if the screening shows that the person who has been arrested for a crime turns out to be here illegally, ICE is informed about that discovery, right?
That's correct.
So I just think it was important to go through this because there's been a lot of discussion about ICE and how we don't want to be involved with ICE. I think the popular impression is that we're involved out on the streets. Our law enforcement people are on the streets with ICE, engaged in the kind of melee that we've seen on television coming out of Minnesota. That just is not the case. The only thing that 287G agreement requires is when someone has been arrested for a crime here in Maryland, in the counties that have signed these agreements, that person who the county authorities believe is a criminal is checked for his immigration status. And if it turns out that that person is here illegally, ICE is informed.
Yes, so that's correct, but I think you glossed over a couple of other elements that are very important to consider.
Tell me what they are.
One is that it is, in my opinion, I mean, look, we preside over a committee that we create penalties all the time. We create criminal penalties all the time. If you look nationally, I was reading that there are more people today under lifetime supervision nationally than there were incarcerated 50 years ago. It's incredible. And we create new crimes here every day, from very serious to very sundry, right? So like one thing that you're glossing over is that, and as Ms. Wolf spoke about in her testimony, is that a number of folks who are arrested for low-level offenses, allegations, low-level allegations, and then are then placed into a deportation pipeline and removed from their communities, removed from their families for something that they haven't even been convicted of, and in many times, something that's a very minor offense. So that's one thing. Two is that there is, I think we should all be very much interested and concerned about the lack of due process, because you want to, if someone's convicted of a serious crime, I think that's a different conversation that we all need to have, right? If someone's incarcerated for a serious crime, that's a different conversation altogether, and your threshold for that is, you know, either here or here, and that's different. So that's one thing, due process is two. And then third is, again, as Ms. Wolf spoke to in her testimony, is the force multiplying. If we are in the business of doing ICE's job for them, then that frees up other resources to do that field enforcement that we find to be so egregious in many senses. And so there are three things that I think are really valid to consider, understanding the dynamics of how our program works in the jail enforcement officer model, or the jail enforcement model, or the officer service warrant model in Maryland. And that's why I think we need to disentangle ourselves from these agreements, because you're ensnaring a lot of folks for low-level allegations. You're bypassing due process, and you are acting as a force multiplier for an agency that we don't want operational here in the state.
Great. Thank you for that information. I appreciate it. It's relevant. The point I was trying to make is I'm afraid that people out there watching television are of the impression that Maryland's law enforcement officers are out there in the streets with ICE, forcibly arresting people, apprehending people, engaging in violent acts in order to deport people, when that is just not the case. These 287G agreements, in fact, all they do is require that after someone has been arrested and brought into a detention facility, that arrestee is screened, and if it turns out that person is an illegal immigrant, ICE is informed. That's it. That's what these 287 agreements do, correct?
That's right. Would you like to respond? You come up to the podium.
Yes, of course. Thank you so much. I would like to add a couple of points, and I believe my colleague, Ms. Wolf, would as well. First, I wanted to state in the example of John, I believe the name was.
John. Right.
Although on paper, that collaboration on the street should not be happening, what we have seen is that it indeed is. We have received several reports from Frederick County in which Frederick County law enforcement officers, sheriff's officers did indeed collaborate with ICE on the street, call ICE on the street, hold someone in their van for ICE to come and pick them up. So it begs the question, right, is it because of these 287G agreements within the county that blurs the lines, right, as to like what collaboration should and should not look like? Second, with Paul, I believe was
Paul,
the name, right?
The alleged rapist.
Paul, right?
Yep.
I think really want to harp on the point Chair Smith made, right? Someone being arrested and being charged with a crime does not make them a criminal. I believe Ms. Wolf can share statistics, right, about what percentage of cases that are charged and like actually end up in convictions. And when we talk about Black and brown community members, we know that our community members are over-policed, over-arrested, overcharged, right? So we cannot automatically equate that with criminal status when they have not gone through the criminal legal system to actually be found guilty or not guilty, which 287G oftentimes prevents from actually happening. People do not get a chance to go before a judge because they are swiftly transferred to ICE before they can actually go through the criminal legal system. And the final point that I wanted to make, you know, the scenario with Paul, right, and really, you know, talking about rape, that is an egregious offense where you would want a victim, a survivor, to feel comfortable calling the police for support. Our community members are afraid to call the police because if they're not documented or if they don't have lawful permanent status, how can they trust that if they call Frederick County law enforcement officers, they won't actually just deport, you know, turn them over to ICE? So that is exactly what this bill is meant to try to curb, making sure that people, survivors, victims feel comfortable calling those who are meant to serve and protect us because they're not afraid.
Great. Thank you so much for your supplemental talk there. And you made some allegations about the Frederick County Sheriff's Office. I think there's a witness from the Sheriff's Office who will be testifying later, and I'm sure he'll be in a position to either confirm or disagree with you as to whether the Frederick County Sheriff's personnel are actively on the streets working along with ICE. Thank you.
Ms. Wolf,
Thank you. I think we're going to do one question, one answer, if that's okay, Mr. Chairman. Senator Folden, you're next, but before we do that, unless your question is for the Comptroller, Madam Comptroller, you are welcome to remain, but we know your time is valuable.
Thank you.
Senator Folden, is your question for the Comptroller? All right, I'm going to take that as a no. Okay.
It's not a question.
All right, thank you, Madam Comptroller. Senator Folden.
Thank you, Mr. Chair. Thank you for bringing the bill forward, Senator Smith. I guess I can start with you, sir. So, is the function of ICE, has it changed from, you know, in my lifetime, they've all exercised and done through the Department of Homeland Security immigration enforcement through regardless of who the president is. There's been, can we agree upon that anyways?
What, the general mission of ICE has not changed?
Yeah, that they've executed, deported illegal immigrants for a long time.
Since 1996, I mean, look, the mission has not changed. The tactics certainly have.
Sure. Okay. We can agree with that. So I just want to point out a couple things. And when we're looking at, there was a comment made about law enforcement officers need to be performing other duties and things of that nature. But in fact, we have no law enforcement officers in the state that are enforcing immigration laws.
Depends on what you mean by that. I mean, if they have a 287G agreement, then they are, in effect, yes, enforcing.
We have no law enforcement officers.
Yeah. Correctional officers.
We have correctional officers who have no law enforcement authority. They are in through the processing part of that. So I just want to be, so I'm just going to kind of, as I can,
I hear what you're saying.
I'm going to stick to as much fact finding as I can. That's all I'm going to do is just kind of lay that out. So we have 0 law enforcement officers exercising the ICE program and through the 287G program. We have corrections officers within a jail model of the immigration process.
That's correct. Freeing up resources for ICE to do other things, but yes, correctional officer is that's an important distinction.
Okay, so we can agree there's no draw on police services regarding this program.
Unless in an informal and otherwise unallowable way that's happening on the street, as the example from counsel from the public defender and then also from Casa. So,
okay.
Look, like through the agreements on paper, no.
Okay.
In actuality,
yeah,
you've heard a counter narrative to that.
Understood.
Yeah.
So I believe Senator Augustine made the comment that we're a nation of laws. I found that, I think that's a wonderful place to start. And when I bring that up, it's because we already have laws on the books for legal immigration. Do we not? There's
Fundamentally
a process
flawed built immigration policy.
But those are policies that we should be and could be working on at the federal level.
Amen to that.
Reform. Okay, agreed. We can agree on something.
There you go.
Progress. I guess when the comptroller came up, and I'm not saying anything that she needed to respond to, but I'm kind of disappointed that when she got up to speak about it, she spoke about the economic impacts on there's no mass roundups in Maryland occurring. We're not having the masked officers like we just had, like we were talking about in the last bill. We're not having, our process in cooperation with ICE right now is some agencies in the state are using 287G.
8 jurisdictions are using 287G, confined to the correctional officer model, but
correct.
I think it's false to say that there isn't significant immigration enforcement in the state of Maryland. I think that's
yeah, I'm not saying that there's not immigration enforcement as far as, I don't know what Homeland Security is doing as far as overall. I'm just saying that our local sheriff's offices are not out enforcing immigration laws through the contract or the agreement that they have.
Under the agreement, it's not permissible. Again, you have a counter narrative to that.
We have no deputized federal agents.
That would be correct.
Thank you.
Yeah, we can agree on that one. There we go.
Thank you. All right. So I just found it, I'm kind of disappointed that we're talking about the economic impact, but no one has brought up about the very real impact of those Marylanders that have lost their lives at the hands of some of these really egregious events. So, those are the concerns that I have, and I'm not going to go down the list of names, but there's several names of people that have been lost. Most recently, there was just an arrest this past weekend of 4 illegal immigrants in Prince George's County that murdered a young man, 14 years old, on November 3rd. So and they're MS-13 gang members. So there should be some concerns with some of the people that law enforcement are coming encounter with. And I want to be clear, they're not coming into any encounter with anyone that is not under arrest, pending due process or pending whatever outcomes, but they're not under arrest for another criminal offense.
No, yes, so let me, a lot to address, but one thing is immigrants commit crimes at almost a fraction of the rate that native-born folks here.
How do we know that?
We have several. I will get you those reports. I got them in my binder actually.
I appreciate it.
So that's one thing. 2 is that regardless of your immigration status, if you committed murder, every element of law enforcement is going to be going after you to hold you accountable and to subject you to due process. And this agreement, getting disentangling ourselves from these agreements has no impact whatever on law enforcement's ability to focus in on violent crime and to solve crime.
Perfect. It's almost like, I wish I could say we practice this, because that takes me like right to my next question. So that's a great segue. So does Montgomery County currently work or cooperate with ICE? Actually, let me say, does Montgomery County currently exercise 287G program?
Montgomery County does not have a formalized 287G program. We have the county council president here. There's a policy in place. But
they have a policy. And so does Montgomery County currently, through that policy, work with federal immigration enforcement?
I have the answer to that, but I'll let our county council president answer that, but I have an answer to it. But go ahead.
Very quickly. So actually, we just introduced my bill. It's called the Trust Act, and it will put into law the practice that we have in Montgomery County. We do not have a 287G agreement, but when we have immigrants who have committed a violent crime, we do have that limited cooperation with ICE and let them know. So just to answer your question.
Thank you for answering that. And actually, what is the policy as far as how do they know that they're illegal immigrants?
Because they have, if the person has been charged with a crime, that's the trigger. And if it's a violent crime, we call ICE.
Well, that's, I mean, the 287G program does the same thing. It's just you're saying a violent crime.
Yeah.
They've been charged with a crime. My question is how do they know that they're illegal and to contact ICE?
Well, when you get, well, do you want to answer that?
Through the policy, I don't know.
When you get arrested, obviously you have to show, if they ask you if you have a social security number, you provide that. And they can easily check that.
But if they don't have a social security number, you're saying that would be a trigger for them to be deemed illegal?
If it's a violent crime, that's how we do it in Montgomery County. We do have cooperation with ICE. And that's going to be on the bill that is moving forward.
I understand that. I'm just trying to ask, what policy do you have in place that allows you to have the knowledge? Like, there's got to be a proper, like, processing or vetting process at intake that's going to make you aware of their immigration status. And so I was unaware that any type of questioning regarding an immigrant's or a person's immigration status was being asked in Montgomery County. Is that not the case?
So I think at jail booking, they often do ask where were you born and the country of your citizenship. People have the right to.
Right there, I just want to stop you real quick. They often do because it should be a standardized process regardless of your immigration status. So it has to be every time.
I assume they ask it every time. The information does not always get populated.
Yeah, so you understand my concern because I want standardized processes in place. And it shouldn't matter your skin color, your race, or your sex or anything. At intake, if you're on a criminal intake, the question should be the same. Agreed?
Sure.
Regardless of your. Sure. And so I guess what I'm asking is how does Montgomery County, through their vetting process, learn the immigration status of someone being legal or illegal to then go and contact ICE?
The trigger in Montgomery County, which is this happens all around the state, is when you are fingerprinted and booked into the jail, your fingerprints are sent to the FBI's database, NCIC, which is connected to DHS. So DHS gets that information and they place a detainer, which Montgomery County honors under the circumstances that the county council
So in that
described.
circumstance, that's absolutely correct. But we have illegal immigrants that are undocumented, that have not had their fingerprints taken, that commit a crime. How does Montgomery County know to contact ICE when they're not put into the system for fingerprint analysis?
Unless there was some other way of that hit happening, it could happen by other NCIC information, like a name and a birth date potentially. But if it does not, like if there's no DHS record to match to, then Montgomery County would not affirmatively contact ICE under their policy.
So this is the unique thing about this program, right? Is that there's a data, like Montgomery County doesn't have access to the ICE database. The agencies that enter into a 287G program that do have corrections officers trained to be able to enter that or to look into that database are able to search for, it's a very private, secure database. How's that? It's not one that anybody can get into. Again, my question is, and because I do have one that was in Maryland, and I don't know where, Walter Martinez arrested for murdering someone with a detainer was being ignored and not honored by local authorities. So I was just curious, like, I don't think he was Montgomery County. I'm not positive though. But I'm just curious, how does Montgomery County, if they ask the same questions, they have no cooperative agreement with 287G, how do they know to contact ICE if they're not showing up in the NICS system for fingerprinting.
So two things to say there. One is Montgomery County, I think what you're asking is, what if there is no record in DHS's database of this person to match to? Is that what you're asking?
No, I'm saying there's no fingerprint in the FBI database, not the DHS one.
Well, but, so the FBI database links to DHS.
Okay,
So
but
you
it's
get
not gonna-
fingerprinted
but
at the jail and DHS has your fingerprints, they will know.
But if they don't, are there people that are going to be in the DHS database that are wanted for certain offenses that there may not be a fingerprint analysis ready for?
No.
There's no one that has any crime, any outstanding, for people that come in the country illegally.
So there could be people who are undocumented in the United States where DHS doesn't have their fingerprints. And
Yes.
they've never encountered any immigration authorities before.
Yes.
But those are not people for whom there will be an existing warrant because obviously they haven't been encountered before.
So in that person, there would be no contact, but there would be, so they would stay in your detention center, but you would still contact ICE if they said they weren't here legally?
No, so if Montgomery County gets a person who's never encountered ICE before, DHS doesn't have their fingerprints, there's no record, they've never submitted an immigration application, they didn't have a border encounter, there's just no record of them. Montgomery County fingerprints them. Their fingerprints go into the same database, but there's nothing to match to. So DHS doesn't know that they want to place a detainer on that person.
Okay.
They weren't looking for that person. They're not wanted for any offense, and there's no detainer placed because DHS was not looking for them. Montgomery County doesn't affirmatively reach out to say, hey, will you please arrest our resident?
So I guess that's where my concern is that the police have no way to vet someone if they're in the state of Maryland currently to determine if they're illegal. So I'm going back to my question again, which is how does Montgomery County do this? Because Montgomery County is cooperating with ICE, to my understanding, and turning over some more serious offenders. Is that correct? Violent offenders.
They are turning over anyone that DHS says we want this person if they are convicted of a violent, well, the current policy is a little different, but the policy that the Trust Act would create a policy that if they're convicted of a violent crime and DHS has asked to detain them, Montgomery County will notify ICE and allow that arrest, facilitate that arrest.
Okay, so, but right now, Montgomery County doesn't even require the conviction of the serious criminal offense. They just require that the arrest occur, and then they're willing, in that situation, to hand off the person to ICE.
The Montgomery County's current policy is very complicated. It's a certain small list of offenses that are triggered based on the charge only, and a much longer list.
But the answer is that in that situation, that person doesn't get due process. They get removed by ICE.
No, because if they're charged with a serious violent crime, they're very likely going to be held pending their trial.
Well, actually, they would, if they're illegally in the country, though, they wouldn't be allowed to be held in Maryland because this body passed the dignity not detention measure a couple years ago.
No, held for their criminal trial in Maryland. So if you're charged with a rape, to take Senator West's example, and you come into the Montgomery County Detention Center, you get fingerprinted, those fingerprints go to ICE, and you are most likely going to be held pending your trial by the state judge.
But most likely isn't, so I'm on a fact-gathering conquest here, right? I don't want most likely. I just want to know what's in the policy that Montgomery County uses for every arrest that they make, where they in turn hand off an illegal immigrant that's a violent offender to ICE. So they're cooperating with ICE in some circumstances. Are there circumstances within that they are not adjudicated in a court of law?
Yes, and that is what the Trust Act seeks to change.
So the answer to my question about that not all have had complete due process is accurate.
That's correct.
Okay.
Under
Thank
the
you.
current policy.
Okay, Senator, can I ask you just one closing question real quick? Thank you. So I really do appreciate you opening up the opportunity for many to come and see the jail model that we had, and those that attended, I really do appreciate you coming. I'll say now, as I said when everybody came there, I think everybody was going to be quite underwhelmed because it wasn't like a bunch of cages, there wasn't a bunch of anything that was inhumane, there wasn't anything that was a separate area of holding for these individuals. They in fact actually came through the same process that every other arrestee that is processed in Frederick County comes through the same processing central booking station. Isn't that what we observed?
No, we did. But what we didn't observe was the back-end consequences of the policy and where folks are being separated from community and family through this process.
Yeah,
But
no,
of course we didn't see that.
I get it.
And that's really what the.
Yeah, and I appreciate
wasn't
that.
worried, I wasn't worried about that front part piece as much
Yeah.
as the actual consequences of the.
And I
underlying
appreciate
policy. Yeah.
that, and I appreciate you answering my questions. I appreciate you, Council President, thank you for your candor, because it's important to see that there are still, I guess, ways that they're relative to, and I guess my last question would be is, if Maryland abolishes the 287G program, would that prohibit Montgomery County's current status and how they function in policy with the federal immigration officials?
The bill only eradicates the ability to have a formalized MOU, not a policy.
Thank you. I appreciate it, Senator. I appreciate your time. Thank you, ma'am.
Thank you, Senator. Here's the list of order of senators. Senator McKay, then Senator Love, then Senator Sidnor. Senator McKay.
Thanks.
Sure. Thank you, Senator, for bringing this bill. I got one of my questions was going to be about the process in the jail model or the detention center model. But now understanding what Montgomery County is doing with the proposed trust act or what they're doing, so in the jail model or the correction model, every person who gets processed through there equally gets asked the exact same question about their immigration status. You're telling me that Montgomery County picks and chooses?
No, it's a uniform intake system. But there's discretion. There's a discretion for who they will hold for an administrative detainer based on their charge and conviction. So it'll be conviction after they pass their bill, but based on their charge. So their policy varies in that sense, but the intake is the same as universal for everybody.
Okay, because that's not what I heard in the testimony.
I think we sorted that out, but it is.
Okay.
Yeah.
All right. Thank you.
Yeah.
Thank you. I just want to just speak to, so given that immigration enforcement is a federal responsibility, just trying to understand, the sheriffs are a duly elected body. Can you give me some examples or precedent where we are telling duly elected body what they're going to do?
So the
when
sheriff,
it comes to cooperations with federal agencies.
we have a charter system of government in Maryland, and yes, the sheriffs are a constitutional officer with common law powers, but it is very clear that the legislature has the ability to curtail the powers of that constitutional officer through legislation. The last time that was litigated, or the last case, was in 1982, which is Sopper versus Montgomery County, just to reiterate that fundamental principle of charter system government and the ability for the legislature to curtail the activity and the power of a constitutional officer in Maryland.
So we actually have 3 forms of county government in the state of Maryland, correct? Right. So we have charter, we have commissioner, and
the charter thing is not the most important part. It's the constitutional officer and the ability for us to curtail that power. Sorry.
Right.
Yeah.
And we also have code home rule.
Yeah.
So while this wasn't challenged in the state Supreme Court, I don't believe, I could be wrong, it certainly didn't go to the federal Supreme Court by any stretch of the imagination. But back in 2008, the Allegheny County Commissioners and the duly elected sheriff of Allegheny County, they didn't get along. They were just 4 old men who couldn't get along.
Never happened before in the history of our state.
Not that has ever happened. Yeah. But ultimately, they took away, the county took away the road patrol away from the sheriff, because that was not, in their minds, the constituted mandate of what a sheriff was supposed to do from time immemorial, coming over from Great Britain, all that kind of stuff. Ultimately, it was cited that to put that road patrol back in, because you couldn't tell the duly elected sheriff what you can and can't do other than the purse strings. So I don't know. Obviously, I'm not a legal scholar by any stretch of the imagination, but I don't know exactly where in precedent we've shown that, in this case, a sheriff or the comptroller, other than financially holding back dollars, that we can tell them that you can't cooperate with the federal government.
That's because so the commissioner or the county executive or the head of whatever the local entity is doesn't have that power because the sheriff is a constitutional officer. Understand that. And that dynamic is in play. And we get bills every year, county executives wanting to have the ability to curtail the activity of their sheriff because their activities subject them to civil liability and this, that, and the other, and personal differences. So that happens. We get bills like that all the time. But that is not that's not the state legislature. So we, as the state legislature, have the ability to curtail those responsibilities and those activities through legislation, through acts of our legislature. So that's different than a local body of government. So we have that, and that's what we're doing right now. So that's the answer to the question.
Okay, and then I guess my last question, can you point out any circumstances where there would be violent crime, repeat offenders, or gang activity that cooperation would still be allowed under this bill?
Well, I mentioned that, I talked about the criminal alien program, which is, I know, that program is a program that allows for cooperations operational in every federal prison and I think 300 local jails across the nation. But that program allows for folks that are incarcerated, for DHS to get that information and to issue those detainers for folks that are incarcerated. So to my mind, at least that person has been afforded due process, has had a trial, has been convicted, and is currently incarcerated. So for someone like that, the CAP program, as it's called colloquially, would allow for that level of cooperation.
And my final, if I may, sir, is if those who do not want the 287G program being administered in the state of Maryland, I think there's a misunderstanding of the process. Therefore, that's my own opinion there. But that being the case, and if Montgomery County is doing it right through the Trust Act, maybe we could get some form of that legislation, and maybe we craft this bill where we are affirming the Trust Act, and that might be an opportunity to address some people's concern of that we're putting violent offenders back out, because there is, and I'm not sure that was answered through the questions of Senator Folden, that there is a clear way in which Montgomery County is able to find out if somebody actually is.
Oh, yeah. Well, there are two things. One, I mean, like I say, if you're focused on violent crime, again, this will have no impact whatever on that, because you're going to go through the criminal justice system, and every element of law enforcement is going to be looking to uphold public safety today or in the day after we pass this bill. Second is 8 jurisdictions, to my knowledge, I think have these policies that are similar to what Montgomery County has, and that this bill would not preclude them from engaging in that way after the bill is passed. But there will be another level of local accountability, which there isn't now. So, their local councils and their local sheriffs will be subject to public scrutiny in elections. And, that is very, very important for public policy at the local level to decide what type of jurisdiction you want to live in.
So of the 3 policies, or the 3 different models of the 287G, which in Maryland we're only doing the 2, you're saying the one, not to single out Frederick County, but that's the one that I visited.
Yeah.
You're saying that does this only apply to that model?
Well,
that the other 8 jurisdictions that have entered into it, they will be able to do there?
No, it applies to all of the formalized MOUs, the formalized 287G agreements. But it still leaves open the prospect that a local jurisdiction could develop a policy which is different than a formalized agreement, which is what 287G is.
I reserve the right to not be a legal scholar and not exactly understand that, but I tend to believe that there are more of us that don't understand all of the legal needs. And I also tend to believe that both sides of this conversation, probably most of them are on my side, that we don't really understand the totality of said legislation and what actually is happening.
Let me break it down a little bit differently. Basically, this bill will say, listen, you cannot have a formalized agreement with ICE. You cannot use their resources. You cannot collaborate with them in a formal capacity. And that way, you cannot be deputized to enforce federal immigration law for correctional officers.
But to be clear, anybody who's doing the 287G program in Maryland now is not deputizing any of their sheriff officers.
Correctional officers, because
you're talking about correctional officers. We're not talking about road patrol. We're not talking about courts and giving sworn law enforcement, correct?
Sworn Leos, yeah. So look, that's correct.
And that's clarity that I think needs to be, that's clearly different.
Again, that's what's on paper, and that's right. But as you heard, a counter narrative of like what's actually happening is a little bit is much more complicated than that.
Well, what would be wonderful if I could get some of the data.
Yeah.
One of the best things that I learned from Senator Sidnor was in the years that he's been here, he's listened to stories, and every story is important, without a doubt, and it has part of our decision making.
Yeah, that's right.
But data, actual, not accusations, but actual data is how we should in JPR make recommendations to the General Assembly. And I'll stop.
I respect that. Couldn't agree more.
Thank you, Senator McKay. Senator Love is next.
Thank you, Mr. Chair. I'd like to pull us back a minute and talk about detainers. So as we've been discussing, somebody comes in to the facility and an officer will check the ICE database to see if there's a detainer on that person. Is that correct?
That's right. They'll run everybody through this.
Okay. So who fills out a detainer? Is it a law enforcement officer?
No, it could be certainly, but it's mainly an employee. Like it's not. You don't have to be a sworn law enforcement officer. It's an administrative warrant issued by a government employee.
Okay, so you actually just touched on my second question, which is it's not a judicial warrant.
No.
It's okay. So there hasn't been any judicial oversight or review or anything.
None whatever.
Okay, and then ICE detainers are not determinations that someone is in this country illegally. Is that correct? They're actually just that ICE has initiated an inquiry into this person.
That is also correct.
Okay,
right.
So the fact that an ICE detainer has been issued on someone is not a determination that they're here illegally. So under these 287 agreements, law enforcement is turning over somebody who hasn't been determined to be here illegally.
That's
contrary to a lot of the things that we've been hearing.
That's correct. I mean, it's more opaque than that, and I, defer to an immigration attorney to tell you like how many the mixed status and wherever you are in terms of the, so it's way more opaque than that. So, but the answer is yes.
Okay.
If you want to chime in, but it's.
Thank you.
Yeah.
Thank you. So you said there's been a discussion also about what Montgomery County does and what the 287G agreement does. And then there's also been statements in the public by certain law enforcement officials that say if you take away the 287G agreements, we're still going to do it anyway. Can you address that for us? Will they be able to still do it? Will they still be able to have access to the ICE database? And if so, should we be addressing the behavior rather than the agreements?
So I get that. So the answer legally is once we pass this bill, no, there will be no formal cooperation. But obviously the flow of information and immigration information, as you've heard through like the NICS system, is still something that I think is very much in play in that regard. But the formalized agreements will be eradicated, and so those portals and like you went through when you saw that whole operation goes away. Does it preclude local jurisdictions from developing a policy that they would cooperate to the extent that, like, say, Montgomery County has? It does not.
Okay, thank you.
All right, Senator Sidnor, then second by for Senator Folden.
Thank you very much. Is it Noreen?
Yes.
May I ask a few questions? As Senator McKay had mentioned, someone I'd like to try to talk a little bit about data. And in looking at the written testimony that the ACLU had shared on the second page, it says recent studies and investigations document how 287G program fosters unconstitutional practices. Since 2012, street enforcement models were phased out, and all current 287G programs nationwide are exclusively jail-based. However, data shows that it incentivizes racially disparate pretextual stops in order to funnel Black and Latino residents into the deportation pipeline. It talks about then Arizona, Maricopa County in Arizona, but there's also an example in here that mentions Frederick County, Maryland. Would you mind talking a little bit about that in the data?
Yes, Senator. Thank you so much for the question. And one thing I want to mention is that what we've seen over the last 9 months with the current administration is an explosion in this program, the 287G program. We've never really seen anything like it. The administration has signed up all kinds of agencies to the program, and they've resurrected the task force model that was mentioned that was phased out. So it is true that when we talk about the program, we're concerned about the way this administration is using this program in wild ways, breaking the law in many cases. And so the data that we have, that when we look back at that data, when we talk about specific cases of racial profiling, that's actually kind of underestimating the extent of the problem that we have now, which is that ICE is not limiting itself to the behavior that it set out in a given MOU. It is asking law enforcement agencies to participate in ways that go beyond the MOU. And that should not surprise us, because we see that ICE right now is a reckless agency. It is acting outside the constraints of the law. What we know overall is that even when we were just talking about the jail enforcement and the warrant service officer versions of this program, the data shows nationally that low-level arrests of individuals increase, meaning people stop individuals on a pretext and say there's a minor traffic violation, a minor offense of some kind. They can book them into local custody, and racial profiling is what is happening. And so in the Frederick County example, racial profiling was what was happening in Frederick County. When we're talking about the jail enforcement model of the program, the racial profiling looks a little bit different. In particular, I want to explain it. You've got people who are stopped for some kind of traffic offense on the road. They're booked into local custody, and there's a process that is initiated. People are using race and ethnicity to decide who to stop. That's the fear that we have of racial profiling. It's not that those officers who are out there on the highway are 287G designated officers acting under the task force model in this state. But what we do know from Frederick County over and over again, and actually submitted a complaint to the Department of Homeland Security Office of Civil Rights and Civil Liberties a couple of years ago about this, is that people are experiencing disparate rates of stops who are Black and brown. And if you talk to people who are in the community in Frederick County, they are experiencing racial profiling, and they are afraid. And I think a lot of the technical details come back to, are people afraid to call 911 when they are victims of crime, when they need emergency help? And 287G makes them more afraid to use the resources that they need to protect their communities. It makes the work of local prosecutors harder. It makes the work of local police harder, because people are so afraid.
And you were in mentioning, and I'll say this, but I want to get back to the question about data. You were mentioning racial profiling with traffic stops. We just had a bill about that the other day, a decent hearing. But this was the issue in the Nome versus the Vasquez-Perdomo case, correct? Where the court essentially said, well, my read of it was that they could essentially racially profile folk and in these types of incidents? I think it was California.
Yes, sir, in California. That was a case decided on the shadow docket. The ACLU is involved as one of the one of the organizations litigating the case. And the Supreme Court failed to rein in the racial profiling that was happening. But as a decision on the shadow docket, that means that it's not a majority opinion. Racial profiling is still unlawful in this country. It's still unconstitutional.
So back to the question about data. You said that it's national. I'm curious, is your organization, are you able to break it down to kind of look at share what's happening in Maryland?
There is data that we can provide specific to Maryland and specific to the counties that have 287G, and we'll follow up after to provide that to you, sir.
You mentioned there was a $25,000 award for one of these stops that happened in Frederick County in the Medrano versus Jenkins case. I'm assuming this was taxpayer money that had to.
Absolutely. What we've seen, sir, over and over again is that when local municipalities are held liable, when they are sued, they are the ones that are footing the bill. I'll mention another one, $92.5 million class action settlement in New York for people held unlawfully on the basis of ICE detainers. ICE detainers, which are, according to one federal judge, inaccurate, incomplete, and error-filled. And when our local agencies rely on those and they rely on the judgment of ICE, they're putting themselves at risk of costly lawsuits.
So later on in the testimony, in the written testimony, you say in Maryland, neither Montgomery County nor Prince George's County have entered into 287G agreements, despite each having a higher immigrant population than Frederick County. Remarkably, both counties have achieved more significant reductions in crime rates in recent years than Frederick County has under Sheriff Jenkins' oversight of the 287G program. And I think this goes to your testimony earlier. You don't have a formal program, yet you're still able to address crime in a decent manner, right?
Absolutely, Senator. It's not just, you have to take our word for it at the ACLU. You can take the word of it from many law enforcement leaders. In fact, the Task Force on 21st Century Policing a few years ago made a report saying whenever possible, state and local law enforcement should not be involved in immigration enforcement because it does not help us with crime. It decreases public safety by making people too afraid to talk to law enforcement. I also just want to address some of the equating of people who are undocumented immigrants in this country with people who are committing crime. And there are numerous studies that show that people who are immigrants commit crime at far lower levels. There are also, unfortunately, a lot of studies that show us that people who are engaged in drug trafficking, the vast majority of them are people who are U.S. citizens. And what we know is happening overall in this country is that federal law enforcement and state and local law enforcement that we would hope are focused on serious crimes and human trafficking and sex trafficking are being redeployed to go after immigrants and civil immigration enforcement, redeployed to go after grandmothers and even kids, instead of focusing on human trafficking, sex trafficking, and serious crimes that are affecting our communities.
And I know this just happened recently, but this incident, maybe I'll ask you, maybe, Senator, maybe you know, the incident you had mentioned about the 5-year-old. Do you know, was that in any way related to this particular program, or do you think it was just enforcement in general?
It was general. I mean, look, they went. So there's a Washington Post article about it, so you can kind of Google it for the details. But to my knowledge, and I don't know the full scope of the case because I haven't read the article, but he was coming back home from school with his dad. They apprehended his father. He was there, and they then went to. He was outside of his home coming back from school, and then they went to his father ran, apprehended the father. Then the ICE agent knocked on the door, and his brother came back in and said, "Hey, look, we'd like to keep the child here," and their policy necessitated that they take him. So they took him and his father to keep them together. They're now in, I think, San Antonio. But to answer the question, I don't know. Where was that? This was in Minnesota. Yeah, but I don't know the answer to the question of whether it involved the 287G program. I don't know.
All right, look, thank you.
Thank you, Senator. Senator Folden.
Mr. Chairman, I just wanted to ask you real quick, and then I want to ask the ACLU attorney a question. So I just want to clarify something that my colleague from Montgomery County said when there was like that every person that comes through the program, through the 287G program, that they were lodging detainers. I just want to be clear, that's not factually correct.
No, I don't think she said that. I think they said that they're looking for those detainers. Everyone gets checked to see if there are detainers.
Okay, so they're checking the database.
Yeah.
Because I know that there was like, in the 18 years Frederick County's been doing it, there's been 6,450 arrestees, and of that, there's been 2,153 detainers.
Yeah.
Levied. Okay, I'm sorry. If I misunderstood, I apologize.
No, good.
And then, if I may, do you mind coming to the podium, ma'am? So, obviously, as a career law enforcement officer, it's disappointing for me to hear anybody say, or especially since I policed most of my career in Frederick County in different agencies, to hear people kind of impugning, law enforcement in Frederick County. That's kind of hurtful. Just disappointing to hear that's what your thoughts are. And you made a comment about breaking the law, that agents are breaking the law in many cases. What laws are they breaking?
I was referring to federal law enforcement, ICE agents.
Okay, what laws are they breaking? They're
Quite
enforcing
a few,
federal
sir.
law. So
Yeah,
what laws are they breaking
Constitution, we've filed about 200 legal actions in the past 9 months about, many of them about this, so.
How many legal actions in the preceding 4 years did you file?
Well, we filed quite a lot of lawsuits against the Biden administration as well.
And under the previous administrations
We
before?
file a lot of lawsuits, sir.
That's my point. You guys file a lot of lawsuits. It's not unique to this administration. You guys file a lot of lawsuits. Of those lawsuits, through all these years, how many of them, when you're saying they're breaking the law in many cases, that's a very baiting statement. Like, that could get people pretty upset. That's, my kids would say that I'm rage baiting. They'd be getting on me about, you got to stop that, Dad. So my question is what law? It's one thing to say that. It's another thing to substantiate your claim. What laws are they breaking? Because to my knowledge, I'm not seeing anything coming through the federal courts that they're violating, that they're breaking laws currently. Or give me a case, an incident in the past 12 years where they've been doing it.
I see. Sorry, sir. Just to clarify, you're looking for a situation in which a federal court ruled in our favor on whether ICE was violating current law.
You said currently that ICE is breaking many laws.
Yes.
You said breaking law in many cases, I should say. What laws are they breaking?
The Fourth Amendment is one. Warrantless arrests, which are limited under the Immigration and Nationality Act, is another, because they are conducting warrantless arrests without regard to people's flight risk.
Okay, so
We've filed lawsuits in Colorado, Illinois, Washington, D.C., of course, also Los Angeles.
Maryland?
No, we haven't filed that lawsuit in Maryland, but we have
under
in
the
D.C.
287G program? None?
That's a different set of circumstances, sir. I'm talking about federal law enforcement.
Understood. But my point is federal
Have
law
we filed a
enforcement
lawsuit against the 287G program?
Federal law enforcement is not rampant in Maryland right now because of the cooperation we have with the 287G program is my point. So when we have this type of cooperative agreement, we're not seeing the laws being broken that you're talking about, and it doesn't violate the Fourth Amendment because these subjects are already under arrest for another criminal offense. So it is not an unlawful forfeiture or seizure of their person. Is that correct?
Let me take those in turn.
Okay.
Okay, so first was your Fourth Amendment. If local law enforcement was going to release somebody, let's say that they booked me into local custody, and then they decided to release me on the local charges. They decided not to pursue the case. And then they decided to keep me because they want to hold me for ICE. They no longer have Fourth Amendment probable cause based on the local criminal charges. They're doing Fourth Amendment probable cause based on an ICE detainer.
Based on your comment right there, in the policy in Montgomery County that is being used right now, if there's a serious violent crime and Montgomery County notifies ICE, and they in turn put a detainer on that person, and Montgomery County does not continue with the case to adjudicate the case, so it has not been finalized, there is no conviction, is that an unreasonable, is that a Fourth Amendment violation of their person?
Can you?
They're more serious. They're going to be held pre-trial anyway.
I think one of my colleagues would like to answer that question.
Well, I'm asking you, you're the ACLU attorney. I'm asking you specifically because you brought up that they were breaking laws, I'm asking you what laws they're breaking.
Yes, ICE is breaking a lot of laws, sir. ICE is breaking laws.
What laws are they breaking? I just gave you an example.
I named
Montgomery
the
County.
Constitution and the Immigration and Nationality Act, which are laws that bind them.
Okay.
We've filed numerous lawsuits based on them.
Not in Maryland.
I believe my colleagues here from the ACLU of Maryland can speak to lawsuits related to immigration enforcement in the state.
My question is,
lawsuit with regard to warrantless arrests in Washington,
again, back to my
DC.
question.
Sure.
Back to my question is, you said they were breaking a lot of laws. You said that they're not breaking, that there's no lawsuits pending in Maryland for immigration lawsuits against
I didn't say that, and I would defer to my colleagues from the ACLU of Maryland. But one thing can I say, sir, in response is, you look at Texas, you look at Florida, they have numerous 287G agreements, numerous, the most in any state, and they have more arrests than
Why
in
don't
any
we
state.
why don't we do this? If, to the extent that you want to provide additional information to the senator, that could be much appreciated after the hearing.
I'm specifically asking about Maryland, so I appreciate your answers. You understand that I'm also, you're making the point that it's a violation of Fourth Amendment. I'm making a point that even without a 287G program, by your opinion, that it would still be an unlawful seizure of the person since their due process had not been concluded, even on a violent offender.
No, sir, I think you misunderstand me. If, in my example of me being booked into local custody, if I continued to be held, I'm no longer being held based on if I was no longer being held based on the criminal charges brought by, the state, and instead I'm being held on an ICE detainer, but I have shown papers saying I am a U.S. citizen, and local law enforcement say, well, ICE told us to detain you, then I have a Fourth Amendment case to me.
Yeah, I mean, that's obvious. They have paperwork that they're a U.S. citizen.
Unfortunately, we have a lot of circumstances in which ICE is saying we're going to issue a detainer, and it's a U.S. citizen who's being
I would love
held.
to see that. If you could share that information with me, that'd be fabulous.
I will, sir. Thank you.
But I think the point's been made. Thank you. I appreciate it. Thank you, Mr. Chairman. Thank you.
Thank you, Senator. Any further questions for this panel? Thank you, Mr. Chairman. Mr. Chairman, do you have a specific second panel, or shall I?
No, you can go wash through. Just one thing to clean up, though, for we got to go move on from the next panel. But just, for the Montgomery County policy, because it's more serious offenses, and these are hypos, and so it's, there's a little bit of mushiness here. But if you were going to be held pretrial for that, and so if there's a detainer issued while you're being held pretrial, there's no Fourth Amendment violation there in that circumstance. But obviously, there's a lot of different variables that go into that. Yeah.
Great. Okay. So here's who I have in order. Robert Van Rens, Diana Bergman, Eric Lopez, Taj Smith. And whomever would like to go first.
Using the term immigrants is kind of offensive and discriminatory. Human beings are not illegals.
Let's start with who are you, ma'am?
Greetings. My name is Diana Bergman. I'm a Carroll County resident. Soy orgullosa de ser cubana y madre. I'm a spouse of a veteran of the U.S. Army retiree. Carroll County Sheriff signed into the 287G agreement. How I feel living in Carroll County is sad, disappointed, heartbroken, unsafe. Just 7 minutes from my home, a young girl recorded ICE agents breaking the windows to her mother's car and detaining her mother in a violent and aggressive manner, just hearing the terrifying scream of a child begging not to take her mother. I attended an educational event hosted by Turnaround in honor of Human Trafficking Awareness Month. Turnaround has been helping survivors for 45 years throughout Maryland, yet their efforts to help victims in human trafficking is being impacted by the fear of being caused by immigration custom enforcement actions. Since the increase of immigration custom enforcement activity, Carroll County Public Schools enrollment has been declining, when previously our enrollment numbers were flat. We were one of the few school districts in Maryland without declining enrollment in 2024-2025 school year. I see this as the beginning sign of mistrust within our community. Parents Immigrants who are parents like myself, we no longer trust sending our children to school. December 10th, while attending a Carroll County school board, I witnessed the attempt to pass policy JIHA, immigration enforcement. Myself and several community members of the community were able to testify and push back on this policy. Unfortunately, on January 14, the school board was successful in passing policy JIH, immigration enforcement. The policy allows immigrant custom enforcements to enter the lobby of public school buildings and dictate that no one should interfere with ICE when they're entering a building without a judicial warrant to obtain an individual. And this can very well include children. It also gives the appearance that the school board is telling the sheriff and ICE agent that they could do as they please. My time is ended. I vote in favor of this policy. There's a lot more to say that I didn't get a chance to say, but the community is afraid and it's impacting even services when we need to help vulnerable people. Thank you
so much.
Good evening, Chair and members of the committee. My name is Taj Smith, and I'm here representing the Washington County NAACP. I stand before you today in support of SB 245. While a local officer can't hold someone just for being undocumented, a 287G officer can detain someone based on the belief that they are unlawfully present. This leads to racial profiling in policing. If I looked Irish or Russian, for example, I would be less likely to end up in a county detention center. NAACP President and CEO Derek Johnson recently stated that our democracy is undergoing a stress test. Racial profiling is a direct violation of our Constitution. Due process and equal protection must apply to every person who sets foot on this land. When we target people because they don't look like a citizen, we aren't enforcing the law, we are violating it. Washington County entered into a 287G agreement, and these agreements are not catching violent criminals. Instead, they put people who look like immigrants in harm's way. Data from Frederick and Cecil County show pattern that the vast majority of those detained are held for minor traffic offenses and have no criminal convictions. This isn't public safety, it's a tactic designed to target Black and brown communities. We live in a rural county where racism is a daily reality. I'm a natural-born citizen, but because I'm Black, I have what could be considered a Muslim name, and I may look Hispanic, I, like many others, are targets of these agreements. One of our county commissioners contributed to the extremist agenda of Project 2025 and is believed to be pushing for an ICE detention center in Hagerstown. Extremism holds positions of power in Washington County, including in our law enforcement. Our communities are living in fear. We urge you to have a favorable report for this bill. Thank you for your time.
Good evening. My name is Eric Lopez. I'm with the Amica Center for Immigrant Rights, and we urge a favorable report on SB 245. Our organization has extensive experience representing, defending community members who have been detained by ICE due to local 287G programs in Maryland. This pipeline to ICE detention and deportation is harmful to immigrant and mixed status families, to our communities, and to our state. Civil detention is becoming almost indistinguishable from criminal detention, where people are subjected to cruel conditions and trauma. But one critical distinction that, unlike the criminal system, there's no guarantee of appointed counsel to defend those who cannot afford a private counsel in the immigration system. Most people are forced to navigate the system alone without legal representation against highly trained and hostile government attorneys and adversarial adjudicators. At its core, this bill is about upholding Maryland's values: fairness, dignity, and justice for all. Senate Bill 245 affirms that our state should not be in the business of tearing families apart, undermining the public trust, or funneling state and local resources into federal deportation agenda. This program has well-documented history of racial profiling, discrimination, and wrongful detentions. It diverts local law enforcement from their primary duty of protecting public safety, forcing them to act as immigration agents rather than community protectors. I'd like to share the story of one of our clients that we represented, who was turned over to ICE because of a 287G agreement. Susan was the victim of domestic violence at the hands of their U.S. citizen spouse. She was arrested in a 287G jurisdiction when their partner made fraudulent allegations against them. She was turned over to ICE and spent many months in detention before moving forward with immigration relief based on their status as a victim of domestic violence. Don't let Maryland law enforcement supply the ICE detention and deportation pipeline. Amicus Center urges this committee to issue a favorable report on SB 245. Thank you.
Honorable Chair, Vice Chair, members of the committee, good evening. My name is Robert Van Rens, and I'm the Executive Director of the Golden Mile Alliance. The Alliance works on behalf of 321 storefront businesses and around 400 other enterprises based on the west side of Frederick. Our mission is economic and community development, and that takes place in the busiest and most productive commercial district in Frederick County. The Golden Mile is one of the economic engines that help run the fastest growing county in Maryland, and the immigrant community that makes up a large part of the Golden Mile area is integral to that growth. The Golden Mile does not exist without them, and we celebrate their invaluable contribution to the city and to our county. The Golden Mile, which encompasses most of Frederick's new City Council District 2 and a portion of District 1, is the most densely populated district in the county. We are the most diverse community in both the city of Frederick and Frederick County, with 40% of the Golden Mile's residents speaking a language other than English at home. Nearly 30% of the population were born outside the U.S., and among the places of origin represented are Latin America, Southeast Asia, West Africa, West Asia, North America, and the Caribbean. Our eateries offer 25 distinct national cuisines, and over 20 languages are spoken in our schools. The Golden Mile is a snapshot of the modern American immigrant experience. 287G is an obstacle to success for many of the Golden Mile businesses. The residents that support the local markets, the small restaurants, and the beauty salons and other shops that are so much a part of the local community are afraid to leave their homes any more than they absolutely must. They are afraid to stop for gas. They're afraid to shop for groceries. They're afraid of any interaction that might bring them into contact with local law enforcement, because 287G means that if they're pulled over or stopped while on foot, they may be taken into custody, and then they'll be sent to the Frederick County Adult Detention Center, and they are certain that that means they'll be turned over to immigration authorities. They are convinced that, regardless of their status, whether legal resident or U.S. citizen, we urge a positive return on SB 245. Thank you.
Excellent. Thank you very much. Questions from the committee? All right. Seeing none, thank you all very much. All right, so we're going to hear from, did Taj Smith come up? Yes. Okay. Mary Fauch? Mary Fauch? Charlotte Hoffman? Cesar Diaz? Linda Green, Tatiana Santos. Some folks. All right, whoever would like to start first, just come up to the podium if you're able to do so. If it's more comfortable, if you need to, we have the, you can sit at the table. We can operate the mic if you need to sit down. But
oh, okay. Well, thank you. I'm a resident of Linda Green, and I'm a resident of Prince George's County, where we do not have 287G. But I think that some of the attitudes and encouragement that's happened because this program has expanded in the state has metastasized into Prince George's County. And one of the things I'd like to point out is that though we don't have the ICE folks deliberately working with the police, we do have the transit police. And I would encourage all of you to speak to the WMATA operatives about not having people who get a ticket for fare evasion being picked up by ICE in subway stops and bus stations. In Mount Rainier, we have a turnaround bus section, and we've had several opportunities to watch this situation in action. So it's really a widespread problem. In my county, we've done a lot to try to help and support immigrants. But nevertheless, even in Montgomery County, we've seen that one of the teachers there has had her kindergarten class decrease from 18 to 12 already this year. As a physician, I've talked to many of my colleagues, and we've watched many people not keep their doctor's appointments. As a pro bono doc, I get quite a few questions because they're not willing to go. And even though we patrol our food distribution area and try to watch out and warn people, in my school, the elementary school in my neighborhood as well, they've still picked up people walking their kids home from school. So we don't really have, the attitude in the state must really call all of this into question. And one way to do that is to at least abandon this 287G project. Finally, I had a couple of friends at Hood College last year, and when I spoke on this subject, I described their problems, but I won't repeat all that this year. Thank you very much.
Good afternoon, Chair and members of the committee. My name is Mary Fouché. I'm a physician and a public health specialist from the Eastern Shore. I support SB 245 because 287G does not make communities safer. It makes them silent, and silence kills. We understand that many of the testimonies that you heard today are discussing ICE activities. And we know that law enforcement are not doing what ICE agents are doing. And our purpose to bring this up is to make it clear that residents are living in fear. And by supporting this type of agreements, you are saying that fear is okay. On the Eastern Shore, we live among these families these policies are targeting. We worship together. Our children play together. Juan, Philomen, Sonia, Juarez, they build Maryland's wealth with their bare hands, building houses that they will never live in, building universities that their kids will not be able to attend, contributing to social security, and they will not receive 1 penny. Why? Because many of them, they are in this country under legal programs, and we are ending them, and we are calling them criminals. In Wicomico County, we came together and fought against 287G. Over 200 Haitians from the chicken plant carpooled after their late shift, parked our hearing room to testify about living in fear. Even 2 Republicans on the county council opposed the plan and complained about being already short on staff within the Shell system. I want to also highlight that 1 teenager died in Salisbury because of fear and terror when ICE took his mother. Among us, there are fathers, there are mothers, and I think some of us can try to relate. Maryland should not be in the deportation business. Our job is to protect everyone, improve immigration laws, improve foreign policies to ensure the stability and economic growth in the region. Let's work together and let's treat humans fairly. Thank you.
Thank you very much.
Good evening, Honorable Chair Smith and members of the committee. My name is Tatiana Santos, and I'm a resident of Frederick, Maryland, an Indivisible Maryland Coalition member, and a cat mom. I'm speaking today in support of SB 245. 2 months ago, I was stopped by a local police officer for what the officer told me was expired tags. My tags had just been renewed, so the fact that they were expired was disputable. After 15 minutes of exchange where the officer asked me to provide my license, my registration, and ultimately my insurance card, it was determined that there must have been a glitch in the MVA system. I was given a warning. When I got home and read my warning document, I noticed under the race section, it listed Hispanic in bold letters. It became clear that I wasn't stopped for expired tags, but rather for driving while Hispanic. That experience left me wondering what would have happened if I had had an accent or didn't have the right documents on me. And now I wonder if I can trust police officers in future interactions. My situation isn't unique. In my community advocacy work, I recently interviewed a family whose loved one was stopped by the police for having an expired license. Uriel wasn't able to present the documentation the officers needed. He was taken into custody for driving with an expired license and then deported. His family, which includes a 6-month-old baby, is now falling on hard times. They also have a fear of leaving their home and of any interaction with local police officers. I support SB 245 because immigration enforcement agreements like 287G create fear in immigrant communities and undermine public safety for everyone. When people fear contact with law enforcement, they are less likely to report crimes, seek help, or cooperate as witnesses, even when they are victims. I respectfully urge the committee to issue a favorable report on SB 245.
Chair Smith and members of the committee. My name is Cesar Diaz. I am the president of the Frederick City Council, and I am here in support of Senate Bill 245. This legislation is necessary to protect due process, preserve public safety, and prevent local governments from being drawn into federal enforcement practices that have repeatedly produced constitutional violations, legal liability, and widespread community harm without any corresponding public safety benefit. Frederick County provides one of the clearest examples of why statewide action is required. It has operated under a 287G agreement since 2008, making it one of the longest-running programs in the country. Over that time, data shows that 80% of the 2,000 or more individuals subjected to 287G detainers were only charged with misdemeanor offenses. Beyond the courtroom, 287G creates pervasive fear in the community. I represent City District 2 in Frederick, the city's most diverse and economically productive corridor. My residents live with the constant belief that any interaction with local law enforcement could result in detention and transfer to immigration authorities. Residents in my district are afraid to report crimes, afraid to serve as witnesses, afraid to call for help. Parents fear sending their children to school. Adults fear going to work. Local businesses suffer when residents are afraid to leave their homes, weakening the economic stability of the entire community I was elected to represent. Frederick City finds itself entangled in 287G because our police department uses the county detention center. 60% of the people deported through 287G come from arrests by city police. And again, due process is lost. For those reasons, I urge the committee to issue a favorable report on SB 245. Thank you.
Thank you very much for your presence, Mr. President. Questions from the committee? Senator Sidnor's got a question.
Thank you. The gentleman, yes. Sorry, I missed your name.
Cesar Diaz.
And you serve on your county council, your city council?
City council, sir.
Do you have any idea, because you mentioned students being afraid to go to school, do you have any data to show?
I don't have the numbers with me. I can get those for you, but we have reports from multiple schools around the city that attendance is down.
And one of the reasons that I ask, I mean, outside of the fact that the children aren't being educated, at some point, if they miss additional days or a certain amount of days in school, then their parents are in legal jeopardy of being prosecuted by the state's attorney for the chronic absenteeism.
Correct. Kids are also missing services that they get through the schools. If they get a free lunch program or things of that nature, they're no longer using those services.
Okay, thank you.
Thank you.
Additional questions from the committee? All right, thank you all very much. Thank you. All right. That's virtual. So to Joanna Silver, Ms. Westbrook, did you come up? Viviana, Christopher Kano, and then we'll switch to our, say what? Oh yeah, sorry. Is Christian Benford here? And then we'll, Angel Gonzalez. And then we'll switch to favorable with amendments and then unfavorable. This is the last favorable panel. Ms. Silver, go ahead.
Thank you. My name is Joanna Silver. I am here testifying in my personal capacity, but I've worked for over 20 years as a federal public defender here in the District of Maryland, representing people involved in both the federal criminal and immigration legal systems. From that experience, I can say that ICE's current practices are cruel, disregard due process, and undermine rather than enhance public safety. For example, a couple of years ago, I represented an individual charged with the crime of illegal reentry. And while that case was pending, an immigration judge granted him protection from future deportation under the Convention Against Torture. He served his criminal sentence and was doing well under supervision in the community. After Trump took office, ICE arrested him and deported him to a third country. Within weeks, that country sent him back to his home country, the very country an immigration judge had ruled he could not safely return to. Now, while we expected a sharp increase in illegal reentry prosecutions under Trump, particularly for people with serious criminal histories, that increase never came. In fact, we saw illegal reentry prosecutions decrease when ICE was sending all of its officers in the region to occupy D.C. last summer. ICE is so focused on deportation over public safety that we now routinely see them deporting people who are released pre-trial by the judge in their federal criminal case, preventing their prosecution from moving forward. So to be clear, one federal agency, the Department of Homeland Security, is undermining another, the Department of Justice, with deportation prioritized over accountability for alleged criminal conduct. ICE's practices do not make our communities safer because that is not ICE's goal. I urge this committee to issue a favorable report on SB 245. Thank you.
Good evening again. Again, I'm Viviana Westbrook, and I am the state and local advocacy attorney at Catholic Legal Immigration Network. And I'm here today to testify in support of SB 245. Now, previously, before clinic, I worked with immigrant survivors of gender-based violence, which I still do on a pro bono basis. And so I have seen firsthand the negative impacts of 287G agreements. 287G destroys community trust. By deputizing local law enforcement with immigration enforcement powers, immigrant communities see them as an extension of ICE. And this in turn leads to a chilling effect, where immigrants and refugees who become victims of crime are too afraid to report it. Now, ensuring that everyone in our community feels safe to come forward and to engage in the criminal system is so important. This is a public safety issue. 287G agreements lead to local residents losing, trust in the very law enforcement agencies that are supposed to protect them. Now, normally with survivors of domestic violence, what happens is that they will defend themselves when they're attacked. And when that happens, they might leave scratches on the abuser. And abusers always know how to take advantage of these situations. And they will say, oh, they attacked me, I'm putting charges on them. And all of a sudden, you have a victim who has been abused for so long, and all of a sudden they find themselves being put in the jail, and that triggers 287G. And so even though later on the criminal charges will be dismissed, hopefully if they have an attorney, but The fact is that the repercussions still exist. They're still put in the deportation pipeline, and they're greatly harmed. So I really hope that this year we will end 287G, since it is complicit with all the violence and chaos and fear that ICE has been sowing. Thank you.
Good evening, Chair and committee members. My name is Sam Denby, and Angel will be speaking in Spanish. I will be translating into English. Thank you.
Buenas tardes, señores. Mi nombre es Angel, soy miembro de casa y hoy les hablo como hermana que está pasando por una situación de angustia y dolor.
Good evening, Senators. My name is Angel. I am a CASA member, and today I'm here speaking to you as a sister who is experiencing deep anguish and pain.
La semana pasada, mi hermano fue detenido por ICE. Él no es una amenaza, él es un padre trabajador responsable y el sostén de nuestra familia. Él es un pilar de nuestra iglesia por traer alegría a los miembros tocando el piano. También es conocido por ayudar a personas sin hogar, preparándoles y repartiendo comida.
Last week, my brother was taken by ICE. My brother does not pose any threat. He is a hard-working, responsible father and a provider for our whole family. He is a pillar of our community and our church, where he is known for bringing joy to church members with his beautiful piano playing. He is also loved and respected for his tireless work, cooking and delivering meals to unhoused people in our community.
Mi hermano pasaba por Frederick todos los días entregando delivery para su trabajo. Y debido a los acuerdos 287G, no podía confiar en la policía, porque los veía como agentes de ICE. Tenía miedo de que lo agarraran y dejarnos solos.
My brother goes through Frederick every day for his job, and because of that county's 287G agreements, he lived with the constant fear that he couldn't trust the police, not because he wanted to fear them, but because he saw them as ICE agents who could tear him from his family and his home and leave us all alone.
Lamentablemente, las cosas pasaron como él no quería. Fue detenido por una revisión rutinaria y fue transferido a custodia de ICE, donde sigue hoy en día.
Unfortunately, my brother's worst fears came true. He was detained during a routine traffic inspection, and then he was detained and transferred to ICE custody, where he remains to this day.
Mi hermano era como un padre para mí. Después de graduarme del colegio el año pasado, él me animó a seguir estudiando para que algún día pudiera cumplir mi sueño de ser enfermera. Ahora que mi hermano ya no está, ese sueño me parece muy lejano.
My brother is like a father to me. After I graduated from high school last year, he encouraged me to continue my studies so that one day I could fulfill my dream of becoming a nurse. Now with my brother gone, this dream feels very far away.
Todos los domingos, que era su día libre, pasaba el día entero con nuestra familia, cocinando y manejando bicicleta. Su hijo menor cumple 11 años el mes que viene y no deja de preguntarme todos los días si su papá estará en casa el día de su cumpleaños.
Every Sunday, on my brother's day off, he would spend the whole day with our family, cooking meals and riding around on our bikes together. Next month, his youngest son turns 11, and every day he keeps asking me if his dad will be home in time to celebrate his birthday.
ICE no está deteniendo a supuestos delincuentes, está deteniendo a personas trabajadoras como mi hermano. ICE ha separado a mi familia y a muchas otras. ¿Por qué estamos ayudando a ICE a separar familias? ¿Es Frederick o Maryland una extensión de ICE?
ICE is not targeting so-called dangerous criminals. They are targeting hardworking people like my brother. ICE has separated my family and so many others. Why are we helping ICE separate families? Is Frederick an extension of ICE? Is Maryland an extension of ICE?
No más colaboraciones con ICE.
No more partnerships with ICE.
Como hermana que quiere mucho a su hermano, hago un llamamiento al Senado para que sean valientes y estén a la altura de las circunstancias y defiendan a nuestras familias. Exijo que todos los senadores aquí presentes apoyen este proyecto de ley que dice que no vamos a colaborar con esta agencia que está destrozando familias como la mía.
As a sister who loves her brother very much, I'm calling on the Senate and state legislators to be brave, to rise to the occasion, and to stand up for our families. I demand that every senator here support this bill today that says that we are not going to collaborate with this agency that is tearing families like mine apart. Thank you.
Dear Honorable Chair Smith, Vice Chair Walchecker, and members of the committee, my name is Christian Benford, and I'm a resident of Frederick, Maryland. I am writing in support of SB 245, Public Safety Immigration Enforcement Agreements Prohibition. I'm a Latino man and was raised by a Salvadoran tradesman and survivor of war. He was an incredibly hardworking man. Growing up, I was incredibly aware of how uncomfortable him and I felt when we interacted with people in public. Cashiers speaking to me instead of him because they assumed he didn't speak English. Someone interrogating him about his place of origin because he would answer New Jersey. Or law enforcement profiling him to ask about his citizenship status. When I was 8 years old, I got to watch him receive his citizenship. That didn't stop any of those interactions. Those based in fear and the negative perception of immigrants in this country. It is why I have committed myself to supporting our immigrant communities through mutual aid efforts, know your rights canvassing, and of course, speaking against methods of law enforcement that discriminately target individuals, such as the discriminatory 287G program. I support SB 245 because immigration enforcement agreements like 287G create fear in immigrant communities and undermine public safety for everyone. When people fear contact with law enforcement, they are less likely to report crimes, seek help, or cooperate as witnesses even when they are victims. In Maryland, a majority of those arrested had no criminal convictions and no criminal charges. The only violation was unauthorized presence, a civil misdemeanor. 287G is effective at targeting those posing no public safety threat. Nationally, in 2024, according to the Track Data Project, 3/4 of those deported through 287G had no criminal convictions. In Maryland, for every individual deported through 287G with a serious level 1 conviction, 115 had no criminal conviction at all. For these reasons, I ask this committee to let people exist while black or brown, to let them exist without speaking the wrong language at the wrong time. And I urge you all to issue a favorable report of SB 245. Thank you for your time and consideration.
Thank you all very much. Questions from the committee? I want to thank the panel, especially Ms. Diaz. I want to just make sure that you know that that we're acknowledging your presence and appreciate you here. I always say this, it's really hard to come up here and to testify, and you're taking time away from your family or your work responsibilities or school, and you came down here to take time out of your schedule because you have faith in an institution and in our small D democratic experiment enough that you can affect change, and that system has let you down. And so I just want to say thank you for having continued faith in your participation, your meaningful participation here, and your faith that we have the ability to continue to change things for the better. So thank you. All right. With that, if there are no questions, we'll move on to the next panel. Yeah. Yes, we do. Yeah, I'm going to go to the online panel now. Thank you. No, thank you. I appreciate it. Thanks. So we're now going to switch over to Mr. Franklin. Are you in the Zoom room? All right, come on in. And is Monica Brooks in the Zoom room? Okay, Mr. Franklin, we're going to go with you first. Welcome back.
Thank you, Chairman Smith. So I'm again here representing the Law Enforcement Action Partnership, this time in support of SB 245. The bulk of my career was in criminal investigation, and I want to speak to investigating and solving crimes of violence, which leads to effective crime prevention. We must ensure that crimes are reported by everyone, victims and witnesses of crime. This includes the immigrant community. Once reported, we can investigate and hold the offenders accountable, removing them from the community. Removing repeat offenders from the community is one of the most effective forms of crime prevention, and that's our ultimate goal. As such, we need trust for the reporting of crime and for witness cooperation, and eventually their court testimony. When people fear the police, not trusting the police, often they do not report crimes. The same goes for being witnesses of crime. Aggressive immigration enforcement can and has silenced victims and witnesses tied to the immigrant community, which ultimately leads to violent offenders remaining on the streets who continue to prey upon community members, and that includes immigrants and others. Aggressive immigration enforcement has led to racial profiling, people being stopped because of their appearance and interrogated without reasonable suspicion of a crime being committed. In 2011, I volunteered my services to the University of Maryland Law School for a federal immigration case. It involved 4 members of the immigrant community who had no criminal records. Their only crime was being in a disabled vehicle. A transportation authority police officer came across their misfortune, illegally arrested them, and along with 2 other officers transported them to the ICE office in Baltimore. 10 hours of police service was now absent from vital police services. Please give SB 245 a favorable report. Thank you.
All right, thank you very much. Questions from the committee? All right, seeing none, thank you very much, Mr. Franklin. All right, is Ms. Brooks in the Zoom room? Is Ms. Brooks in there? Yeah.
Yes, Ms. Brooks is here.
Hey, how are you?
I'm doing well, thank you. How about yourself?
Just peachy. I've been sitting in the same spot for the last 8 hours. Go ahead.
Yes, let me pull up my testimony. Okay. Chair, Vice Chair, and members of the committee, my name is Monica Brooks, and I'm President of Wacomico County NAACP, also serving as Regional Chair of NAACP branches of the Eastern Shore, and I'm here in support of Senate Bill 245. ICE has always existed. What has changed is how it's operated, and what this legislation asks Maryland communities to tolerate. ICE agents historically receive less training in de-escalation, cultural competency, and civil rights protections than local law enforcement. That training has been shortened even further, while enforcement has become more aggressive. Releasing under-trained enforcement into civilian communities is reckless. In any other context, we would call that irresponsible. On the Eastern Shore, this risk is magnified. Rural communities like ours are rapidly diversifying. We have almost 100 languages that are being spoken now in this region, often in areas where there is limited cultural familiarity. When limited training leads to fear and authority, the result is dehumanization, racial profiling, and violence. We have seen the human cost. Most recently on the Eastern Shore, a mother was taken by ICE while her 15-year-old son was dying of cancer. She was not allowed to even see him before he passed. That is not enforcement, and that is a complete disregard for human life. For Black Marylanders, citizens, and immigrants alike, this enforcement does not feel targeted, it feels indiscriminate. Agents operate without presenting warrants, families are pulled apart in public, American citizens are questioned simply for being Black or for speaking out. This is not anti-law enforcement. This is about standards and accountability. And when you deploy forces without sufficient training, oversight, or humanity, you create predictable harm, fear, injury, and sometimes death. And we don't think that is a healthy relationship to have with our local law enforcement. So Maryland cannot claim to value public safety while allowing unchecked federal enforcement to terrorize families. Thank you for your time.
Excellent. Thank you very much. Questions for Ms. Brooks? All right. Seeing no questions,
thank you
all. Thank you. Have a good one. All right. No one else is here in the Zoom room, is that right? We're now going to move on to, Susan Karen? Is she in there? Yeah. Okay. Ms. Karen, you're up. Welcome. You can. Welcome.
Welcome. Chair Smith and members of the committee.
Welcome.
Thank you. Chair Smith and members of the committee, my name is Susan Karen, and I chair Peace Action Montgomery. We represent nearly 1,500 members. I'm here today in support of SB 245, and I want to be very clear. I believe this bill is necessary, but I also know that this bill is hypocritical. Both the state of Maryland and the Montgomery County Council have funded the Maryland Israel Development Center, which has brought in Israeli surveillance and weapon companies to set up shop here. Just 4 months ago, the MIDC, using Maryland tax dollars you gave them with the tax dollars from Montgomery County, to bring in Eris Labs to North Bethesda. So what does Eris Labs do? It scrapes social media to build detailed profiles of people, to identify targets and map their daily lives, where they get coffee, the neighborhood where they ride their bikes with their family, where their children go to school. The company's leadership has roots in Palantir and has openly stated its intention to market this technology to ICE. Let's be honest about what this means. The harm of this technology will be vast and far-reaching. These tools are designed to be spread across agencies, across borders, across communities. This technology is a Pandora's box, and once opened, it will not close easily. I beg you to fix this now before the damage becomes even harder to undo. I'm putting this on the record so that future generations know the full story of Maryland's unique role at this moment, and also so that no one in this room can ever say they didn't know. Thank you very much.
All right, thank you for that. Questions from the committee? All right, appreciate it. Thank you very much. With that, that'll end the testimony for the proponents of the bill. We're now going to move on to the opposition panel. Is Ms. Yousefi here? Shrai here? Okay, Sheriff Gaylor or Representative? And actually, any of the, oh, yeah, there. Hey, Shrai, come on up. And Sheriff, come on up. Michael from Frederick, you can come on. Yeah, come on up. Yeah, come on up. And then, yeah, Mr. DeWeese, come on up. Yeah, there you are.
I said good afternoon. It's actually.
It's good evening. I know, yeah.
When I got here today. You want to try?
All right. Yeah, whoever would like to start first.
Good evening, Chair, Vice Chair, members of the committee. It is wonderful to be here, and thank you for allowing us this opportunity to testify. My name is Shrai Yousefi, and I come before you today to stand in strong opposition to SB 245, which would end local law enforcement's ability to coordinate with ICE agents in the removal of criminal, illegal aliens from our communities. Public safety is the bedrock of a thriving and prosperous society, and without it, businesses cannot function, families cannot thrive, and communities do suffer. My opposition to SB 245 is from this understanding and from a personal perspective of being a resident of Harford County, where Rachel Morin was brutally raped and murdered by an illegal alien, and where the rapist and murderer, also an illegal alien, of Kayla Hamilton attended school. Furthermore, as a wife and daughter both to legal immigrants and a mother to a young son, this discussion at hand is very deeply personal to me. If SB 245 were to pass into law, it would threaten our communities and put families in harm's way because it would allow illegal criminal aliens to return to the streets instead of being removed as they should. Harford County does not currently experience ICE raids as our sheriff and local law enforcement departments and agencies perform their duties exceptionally well and are able to effectively coordinate the removal of illegal criminal aliens from our community.
SB 245 will change that and will result in the very measures you claim it is stopping. Therefore, I present strong opposition to 245 and urge an unfavorable report from this committee as you consider this policy. Thank you for your attention to this and for bringing it before the committee.
Hey, Mr. Chairman, members, senators, I would like to say it's good to be back before you again this year. I wish we weren't here discussing this, but we are. I just want to address a few of the misnomers that I've heard during the testimony. First and foremost, the fact that this is not a law enforcement program. It is strictly corrections-based. The law was passed in Maryland several years ago that law enforcement can have no role in the immigration process. This is strictly a corrections-based program, so when we hear people talk about law enforcement assisting in these operations, the fear that goes to the law enforcement, that is someone either misinformed or trying to sell a narrative that just isn't true. This happens at the corrections side when someone is processed into a detention center of a participating agency, such as the Harford County Sheriff's Office. They're processed into that jail for some offense that they stand accused of or to serve a sentence. And at that point in time, after seeing a commissioner, after the establishment of probable cause and either a no bond or a bond due process on that part of the process, they're booked into the jail. At that point, every single person is screened. And that's the fact where it comes around that this is discriminatory in some manner. That is also a misnomer. Every single person is screened who is booked into the detention center. I think it was said earlier, the programs have been around since 1996. Actually, a Democrat, Bill Clinton, initiated this program. The jail model was part of it, and we have participated in Harford County for the last 8 years or so when President Obama added us in. And I would like to address the fact that I heard many of the previous speakers talk about what we're seeing around the country, immigration enforcement officials doing this and doing that. This bill in no way can or does negate, nor can this state negate the federal government from performing their lawful law enforcement duties. Those activities are still going to occur. Everything that we heard in the previous discussions sitting out in the lobby will still occur. ICE will still be doing their lawfully responsible duties, and I think they'll be doing it in more earnest effort here in Harford County. I think this will see more civil immigration enforcement, more deportations. Instead of, ICE has been very clear, Tom Homan has been very clear, he prefers to work in jurisdictions where there are cooperative agreements on identifying people who have committed violations of the law and then making decisions on removing those officials. Other than that, I'm here to answer some questions you have, and I thank you for the time this evening.
And just for the record, you're Sheriff Gaylor from...
I apologize, Sheriff Jeff Gaylor from Harford County.
Good evening, I'm Sheriff Jim Deweese from Carroll County. I oversee both law enforcement and corrections for my county. I'm a third-term sheriff. I'm a retired captain with the Maryland State Police, where I served 25 years as a decorated state trooper. The Carroll County Detention Center went into an agreement with ICE in May of 2025 to implement the ICE Warrant Officer Program. This is not the full 287G program that Frederick, Harford, and Cecil counties have, and only allows us to notify individuals that have been arrested and incarcerated in our detention center to be advised of a detainer or warrant and have it served by my deputies. 287G is corrections-based and is the safest, most efficient way to work with ICE. The law enforcement side of my office has nothing to do with 287G, immigration enforcement, or anything like it because I don't allow it. It's in my policy and it's state law. Since implementing the program, law enforcement in Carroll County have arrested 17 individuals for crimes committed in our county, where it was learned through detention center staff that ICE had an active detainer for the incarcerated individual. Again, detention center staff learned about the active detainer through NCIC after the individuals were arrested for crimes committed in our community. Let me give you a few examples of these crimes. First and second degree assault, resisting arrest, indecent exposure to a minor, credit card theft, drug distribution, and the list goes on and on. Please raise your hand if you're okay with me releasing any of these criminals into your community, knowing that they are here illegally without documentation. I'd lose my job as sheriff rather quickly in my county, and rightfully so if I did. As sheriff, I've worked with ICE to safely transfer individuals that they want for deportation. as did the sheriff before me and the sheriff before him. You can pass this law and abolish our 287G agreement, but no politician or legislative body will tell me that I can't communicate with another law enforcement agency when it comes to a matter of public safety in my community. I urge you to vote unfavorably on this bill.
Good evening. I'm Lieutenant Colonel Michael Carnice. I'm the Corrections Bureau Chief for the Frederick County Sheriff's Office. The 287G program in Frederick County is only conducted in the detention center by trained correctional officers. Only people that have been arrested on a jailable offense are screened through the 287G program. There are no police officers on the streets, in the schools, or in the hospitals anywhere in Frederick County that are conducting any 287G operations or are 287G trained. The Frederick County Sheriff's Office is opposed to Senate Bill 245. I've been a designated immigration officer for the 287G program for 18 years. There are a lot of misconceptions and misunderstandings about the program. Thank you for the opportunity to explain how the program works and to answer any questions you may have.
Excellent. All right. Thank you all very much for the panel. Questions from the committee. Senator Sidnor and then Senator James and then Senator Love.
I have a question for Sheriff Gaylor.
Sorry.
And good evening. I had an opportunity to speak with one of your sheriffs the other day about your video, so since you're here, again, I thought the video was humorous last year, a little bit off on some things, but it served its purpose last year.
Thanks, sir. I started in Eden, and he mentioned to me that you guys chatted.
We had a good conversation.
Yes, sir.
In terms, you had mentioned that earlier some of the testimony was off. I had read testimony from ACLU's written testimony talking about the deportation pipeline. So, and I think within their testimony, while it states clearly that we operate under this jail model here in the state of Maryland, they talk about how one gets from the streets into the prisons. So law enforcement is able to go and have whatever stops they have. Someone is then detained. Now they're in the jail system. Once they're in the jail system, now you can use the 287G program on that person, right?
Well, at that point, I wouldn't say use it upon them. Now they are screened to see if they are arrested and the probable cause from the commissioner's office, and then they are booked into the jail. Then every single person is screened to see, in addition to whether another jurisdiction wants them for something, if they're in the country legally, and then that's reported to ICE.
And so that connection is there.
Yes,
and while I don't have the screen up, in talking with your sheriff, there were certain racial disparities that were that is in the GOCAP numbers. So I think one can see how the ACLU reaches this conclusion that it's some pipeline or funnel of the Black and Latino folk up in Harford County. But the question I wanted to ask, I had pulled the interview that you all had, I'm assuming it was yesterday, from Fox 45. And there were a few quotes from you and Frederick County Sheriff Jenkins that caught my attention. I think both of you, if I were to kind of drill down, stated that if this passed, you're going to look at all options and possibly fight this in court. So that got me to thinking, because you all are constitutional officers, essentially. I mean, your office is in the Constitution.
Correct.
So I read it because I was curious, like, what if they're saying that they're going to sue and look at that, what are your duties? And so under Article 4, Section 44, it reads, there shall be elected in each county and in Baltimore City one person resident in the county or city above the age of 25 years and for at least 5 years preceding his election, a citizen of the state to the office of sheriff. He shall hold office for 4 years until his successor is duly elected and qualified, give such bond, exercise such powers, and perform such duties as now are or may hereafter be fixed by law. In case of vacancy by death, resignation, refusal to serve, and goes on. What jumped out to me is that it really doesn't say what a sheriff can or can't do, right?
Correct.
All right. And that's because the powers of sheriff in the state of Maryland are essentially common law powers.
Yes.
Correct? And my chair, when he was testifying, he briefly noted this case called, was it Soper or Super versus Montgomery County? Are you familiar with that case?
I am not.
All right, so that case, it says, it holds that the sheriffs are constitutional officers whose powers and duties are not expressly enumerated in the Constitution. Rather, those powers and duties are prescribed by the common law as modified by the acts of the legislature. Accordingly, sheriffs retain their common law powers and duties until deprived of them by the legislature.
Oh, there is no doubt about it that the legislature has the ability to regulate the office of sheriff in so many. I've taken a strong position against the independent investigations, not so much that it was the way it was done, but the way it was, not the law to pass, but the way it was implemented. And that resulted in a court battle. So I don't know where we're going with the questioning, but yeah, I don't disagree with your point whatsoever, Senator. That, you know, I wouldn't be here testifying if I thought, I don't think any of us would be if we had absolute ability to just do the things that our citizens elect us in office that they want done.
The line of questions is again kind of based off of the fact that you all said you're going to possibly challenge this, and it seemed, and you didn't say this, so I'm not putting words in your mouth, but your colleague, Sheriff Jenkins, said that I would challenge their authority to take that away from me, talking about us, I'm guessing.
I do believe, yeah, and I don't want to put words or his thoughts, but I would say I do believe that that is the justice system, the court system with the different branches of government that our Constitution has given us the ability to take a matter to court where there's some disagreement. I think we see that every single day in this country.
And one of my colleagues was kind of had asked about when some things had happened, and I was looking. It was curious. In 1902, there was a case, Beasley versus Rideout, where the legislature passed a law taking the control and supervision of the Anne Arundel County Jail and prisoners therein from the sheriff, and it was held not in contempt, a conflict with this section. Did you know, and this I found really fascinating, because again, this is our now Supreme Court looking at the Article 4, Section 44. Did you know that under Cross versus Board of Supervisions of Elections, that a sheriff doesn't even have to be a citizen of the United States?
Did not know that.
Yeah, it surprised me.
Well, I know you have to be a resident of the county you live in for 5 years. I think that's what the requirement is in the Maryland Constitution.
Right. Yep. This was litigated back in 1966 with someone who happened not to be a citizen at the time that ran to be the sheriff. It surprised me.
It surprises me as well.
Yeah.
First I've heard of it, but thank you for, I'll leave a little more educated tonight. So I would like, if I could just, Senator, just for a second to backtrack. On our last, we were required under ICE proceedings, part of the 287G program is to have community meetings. I think they're every 3 years now.
We have to do them every year in Frederick.
So I think ours are every 3 years, and they release the data, and it's up on our website. But when you talk about people of color, brown, black, and relating that to some of the traffic stop data that you're looking at, back in our last report, Germany was the #1 country of people that our 287G program was screening as being here illegal, either entering the country illegally or overstaying a visa. So it
You have
wasn't.
that data?
It was Germany. It's on our website.
It's
Yes,
on the
sir.
site?
I can get it to you. Mr. Roby will get it to you.
Oh, no. If it's, I'll check it out. I appreciate you sharing that.
Yes, sir.
Thank you very much.
Yes, sir.
Maybe you guys can make a video together in time.
I'm up.
Yeah, that'd be good. All right.
Okay.
All right. Senator James.
Yes, sir. Yes, yes, ma'am.
Oh, thank you. And this is for any and all of you. And I'm not going to get into the weeds. I have a good relationship with my sheriff, and we'll talk more about some thoughts I have about some amendments. But I just need a clarification about something that I wasn't aware of. You share a 287 agreement, excuse me, you had. And I read an excellent report, which I'm going to share with all of you, written by a very credible, nonpartisan group called Immigration Policy Institute. I think everybody will agree once you find out about them. All they do is just try to accurately report things. And in 2012, they did a very, very good overview of 287s. And so that's why I'm going to share it with you. What I learned from this report just really generally is that jail model targeted, targeted programs seem to be the most effective at eliminating, violent and serious crime, and when properly administered, with great outreach to the affected community, really the whole community, about what you're trying to do and what you're not trying to do. There's hard data that the communities, the minority communities embraced it and were not afraid. And some of that data can show where the children all of a sudden disappeared when they didn't understand it, or other people were not coming out. And once the programs were understood and targeted, there was a lot, kids are going back to school. So that's just, you have to read it and see. But here's what I need to know. What I learned from this report was the federal government historically kind of had hands off on how its local jurisdiction was going to administer their program. But they found, I guess, around 2012 or 2011, a GAO, what is that, the Government Accounting Office, found that it was really lacking, not so much locally intentionally, but there just wasn't good data collection or good articulated goals. So Secretary Napolitan at the time and others came out and said, here's how we want to improve the program. And there was a lot of buy-in. But again, no mandate on how to do this, but prioritizing and asking that in going forward, there'll be a lot of data collection, it'll be more targeted and so on. So what I just heard recently, and this would be unfortunate, is that the federal government is now asking, demanding perhaps, anybody that has a 287 or is interested to sign a new one that is very different and dictates in a way that has not existed before, and I don't think in any way acknowledges true data on what is effective and what is not. I think those agreements now are demanding that universal is the approach, not targeted. Could you, any of you, answer whether that is true?
I think I'll defer, but I do want to say.
I'm sorry about that long one, but I think the audience needs to understand.
To the beginning, I will say, when we first explored, after I was elected sheriff, we explored this program, and we met with LASSOS, which is the organization in Harford County that works with the immigrant community. And they were very, and have been over the years, very supportive of the program, in that many of the people who are victimized by criminal illegal aliens, they prey within their own communities in large part, not in complete, but we've enjoyed a good working environment, relationship with LASSOS over the last 7-8 years that we've had the program. I can tell you, I don't know anything about a new agreement. Perhaps the Colonel can explain that, but I will say that the agreement does call for and commits us to strict audits, which are done by ICE on a biannual basis, where everything from language lines to the setup to the process, to the housing. And again, I'm going to defer to the rest of this, but we're subject to these audits. They have very strict rules, which are generally more strict than what we have for our own inmate population within the jail.
Sheriff, so you have not yet been asked to sign some new 287 that would be more mandatory on how you would prioritize or focus your resources?
I have not been asked, and I have not even heard rumor of it up until
good. Well,
right this
my
second.
information may be wrong, or you're going to tell me differently, Sheriff.
I have not heard of any of that.
Good.
Generally, what happens is whoever is the sitting president will have the Secretary of Homeland Security put out their priorities, and they're always different. We enforce the immigration law the way the immigration law was written, but we take our directives, our priorities from the Director of Homeland Security because that's where our authority is.
I'm not trying to make you a legal expert, but
please don't.
What I know, but what I got from this report, so I'm going to send it to you also. I'll see if you agree that the report is accurate. Okay. What this report showed was that the federal government certainly has these agreements, but they're a bit hands-off about which model the local jurisdiction would adopt, and they were hands-off on whether you want a universal approach or a prioritized approach with very violent drug-related crimes and then going down, and you had the option, because they don't tell you what to do, if you want to focus your resources on the worst criminals and violence, that is something you have the power to do.
I've never heard of that.
Okay. So you don't think you have that power, is that right?
Well, you can choose. It's up to the local jurisdiction whether you want to do a warrant service, whether you want to do the jail enforcement model, which program you want to do. But as far as what priorities, you're working under the authority of Homeland Security, so they would set those priorities. I would advise not to go against that.
I want you to read that. Have you gotten priorities that have changed from? I'm sorry. When did you start the program?
2008.
Oh, you're good.
We've gone through about 6 different sets of
So
priorities.
I don't know, because you're in this report, Frederick is.
I'm sure we are.
No, I mean, it's fine that they're very neutral. They just talked about it. Okay. But this, and I think they interviewed people there. I guess what I'm getting at is that what I read in this report is the federal government may have priorities, but there is nothing, at least until the current administration, there's been nothing where the federal government contacts local jurisdictions and said, we disagree with your priorities, we're going to override your priorities, or we're going to mandate how you do these priorities.
They have mandated the priorities in the past.
Okay.
However, the current administration has not given us any mandates.
And not to make work for you, but later on, please have your staff send me anything you can about the prior mandated priority, because what I'm talking about here in 2012 was the time when I think it was getting into mandated priorities, and what the federal government was doing is saying, please prioritize.
Okay, under the last
violent crime.
Under the last president, and I'm getting old, so my memory's not as good as it used to be, but I know it was recent entries to the country within 30 days was a priority. Someone that was considered a threat to significant threat to the security of the country. It was very restricted.
Yes, well, that is kind of fits the potential violent crime. Could you share any of those? I know you might not have them, but if you have any or could get access any of those prior priority lists that were, obviously made public.
I doubt if I kept them. There was priority list. There was a Morton memo, who was a director of Homeland Security. There was an Napolitano memo that I remember.
All right.
There was the Mayorkas. I think I said that right.
Right.
He had a priorities.
Maybe I can find them. Thank you.
I'm sure you can, but as far as the MOA, our most recent MOA was signed in 2020, and I have not heard anything about an updated version or a revised or anything like that.
Well, I'm going to share this with you all, this report. If you have the time, any of you could respond to me whether this report seems accurate to you, and maybe that, and then I'm going to share the suggested amendment that might, be a place where we can find some consensus and less passions on both sides. But in any event, thank you for answering my question.
You have to be careful with that, because there's a lot of instances that I've seen where people have been arrested on low-level crimes, driving without a license, driving while suspended, and then when you run this person's criminal history and they have a attempted murder conviction in another county.
Then that fits the model of somebody with a high risk of a violent crime. I totally agree with you. That's what we're talking about. And that's what that Napolitano, I can't say her name, memo did, and the priority of GAO said that's it, and data suggested whether it was the most effective way at actually getting violent and dangerous criminals out of the communities, including the minority communities. All right, thank you.
Thank you, Mr. Chair. Thank you, Mr. Chair. Sheriff Deweese, is it? Thank you. In your testimony, you testified about some people that you all had brought in that were subjected to the 287G agreement with ICE, and you enumerated a number of crimes.
Yes, ma'am. I can give you that documentation if you'd like.
No, that's not what I'm looking for. I believe, I'm not challenging that.
Okay.
That's just grounding you in where I am in my question.
Mm-hmm.
So then you challenged us, I don't want to put words in your mouth, but you basically challenged us to, say we wanted those people to go free. And it sounded to me like you were saying if we were to pass this bill, you would have to have let those people go if they were in your facility. Is that correct? If those people were not subject to a 287G agreement, would you have had to let them go free? Those people that were in on violent crimes?
No, not at all. No, and I wouldn't.
So you wouldn't?
Right.
So any statement that is to the effect of if we don't pass this, then these violent criminals are going to go free is not correct.
No, I think I said you can pass this legislation and you can abolish 287G for me, which it's likely you will, and it really doesn't matter. I'm still going to operate under the same premise where I'll communicate with ICE similarly to the way I do it now. And in my testimony also explained that the model that I have is vastly different from the 3 jurisdictions that have the jail model. I simply have a warrant service model, actually, that mimics what Montgomery County does. So I will continue to do that model and create the policies that look like that particular system and continue to do this.
I understand that, but that's actually not the piece of your testimony that I was referring to. It was the implication that had you not had the 287G agreement, these violent criminals would have gone free. But I think we've answered that.
Sure, thank you. Yeah.
If I may, I can give you an example.
The question's been answered. Thank you.
All right, Senator Sidnor.
Who do you want, Senator?
It could be any 3 of you, because it's a question. It's a general question for a sheriff. And I was looking at the Harford County MOA under the liability and responsibility portion of it, and I was just curious. Under the law, it says, I guess, LEA personnel will be treated as federal employees only for purposes of the Federal Torts Claim Act and workers' compensation claims when performing a function on behalf of ICE as authorized by this MOA. Just out of curiosity, do you know how many Federal Tort Claims Act or workers' compensation claims have been?
I believe it's zero. Over our 7 or 8 years. And this is just so everyone understands, this is an ancillary assignment. It's not a full-time assignment for any of our correctional staff.
Right.
I believe we have 6 deputies, correctional deputies, who are currently trained and certified by ICE to perform the 287 function. So when someone's booked into the jail, they do the screening as part of their duty day. It's not a full-time assignment, but I believe it's zero.
Correct.
Zero for all? Thank you. Thank you.
Sure.
All right, additional questions from the committee? All right, thank you all very much.
Thank you.
Oh, I'm sorry, my apologies. Senator McKay has a question.
I'm wondering if the detention administrator from Frederick could elaborate of sharing some of that additional information. Might help me understand.
The example I was going to give was we had an individual that was charged with sexually assaulting a 14-year-old child. He came in, we screened him through our 287G program, and he was on a F visa. He was a student visa. We didn't take any action because at the time he was in the country legally. He had legal status. We monitored his case. He was convicted of raping that 14-year-old child and got sentenced to 30 years in prison with all but 18 months suspended. So he stayed in our jail. He actually worked in the kitchen. He got out he completed his sentence in 12 to 13 months with his work time and good time. And without the 287G program, a convicted sex offender would have walked right back out into the community.
So you had said Frederick County, and you've been the administrator for, what, 18 years now?
I've been part of the 287G program for 18 years. Yes, sir.
Okay, so you've seen this program implemented, to be perfectly honest, from administrations to administrations, meaning the President of the United States.
Yes, sir.
And that kind of stuff. Can you share of anything that has changed from one administration to another that has compromised what you are to do in this agreement? And I know that's been updated from year to year as it expires, that kind of stuff. But has any administration, to your knowledge, required you to violate any, I don't want to say due process, is there anything that the directive of the administration has been direct conflict as you working in the jail as the administrator or any of the correctional officers?
No, not to my knowledge, if I'm understanding the question correctly.
Okay, thank you.
Thank you, Mr. Chair. If you, sir, could please remain at the podium. I'm confused.
Okay.
You said this gentleman was here on an F1.
Yes, ma'am.
So he was here legally.
Correct.
Okay, and so ICE wasn't involved.
Correct.
And you prosecuted the case.
Right.
Convicted him.
The state or the court prosecuted.
Right. Convicted him for rape.
Correct.
And then you said if it weren't for the 287G program, he would have gone free.
Correct.
Can you explain to me that, because that doesn't make any sense.
As a F1 visa, he was convicted of a felony. Therefore, it violated his immigration status, which made him amenable to removal.
So he wasn't convicted. He was convicted of violating his F1 visa?
No, he was convicted of rape.
Okay.
The subsequent conviction of him being convicted of rape violated his immigration status. When you're here on an F1 visa, you can't get arrested, or I'm sorry, you can't be convicted of crimes. So he violated immigration status. Therefore, a detainer was lodged on him, and he was turned over to ICE.
But what I'm trying to get at is he was convicted of rape.
Correct.
So how can you say when he was convicted of rape, which would have sent him to prison?
No.
But for the...
He was sentenced to 30 years. The judge suspended all of his time but 18 months to be served at the Frederick County Detention Center.
But that has nothing to do with ICE.
That has everything to do with the proof of 287G. Because without that program, he would have been released because no one would have ever known he violated his immigration status.
But he still would have gone to prison.
No, he didn't go to prison, ma'am. He got sentenced to 30 years, but the judge suspended all of that time except for 18 months, which he was ordered to send at, he was ordered to serve at the local detention center, our detention center. That happens.
How did you know he was on an F1 visa?
We ran him. We screen everyone that comes in.
Then why didn't you call ICE when he was in your custody in the jail?
We didn't call ICE as soon as we screened him.
But once you found out that obviously he violated, he was convicted of a felony.
Correct.
So he violates the terms of his F1.
Correct.
So you could have called ICE at that time.
We actually screened him. We notified ICE, got authorization to put the detainer on him, and the detainer was lodged and he was processed.
But you don't need the 287G program to call ICE because I mean, as was testified here today, you know.
I'm sorry, I didn't hear that.
You don't need the 287G program to contact ICE in that situation because as was testified here today, you know, some of you might pursue that policy anyway, absent the agreements. So you're still going to be able to call ICE. You could have called ICE at that point.
You couldn't have called ICE because without the training, without the program, you would have never known he was here on an F1 visa, and you would never known he violated it.
Montgomery County does it every day, though.
I'm sorry?
Montgomery County does it every day, and Sheriff Jenkins went on record saying that he is going to continue doing that through policy after we eradicate the agreements, the MOUs. So it is possible without the agreement.
I would say no, it's not, because no one would have ever known he's in the jail.
You were aware that he had an F1 visa. You were aware that he was in your jail.
Mm-hmm. But no, when he first came in, no action was taken because he had not violated his status as far as an F1 visa because he had no conviction.
But he was convicted in your jail because he was sentenced
Later,
all but
yes.
suspended, and you knew he had an F1 visa at that time. So
Correct.
once he rolled in there after his sentence, you could have called ICE.
But if we wouldn't have the program, we would have never known he was here on an F1 visa.
All right. I mean, I disagree with you because it's happening functionally in other jurisdictions.
I would disagree with that with all due respect, sir.
Okay.
So,
That's fair.
Senator, I wouldn't know that he was there on an F1 visa. I wouldn't know it only because I'm not investigating, I'm not doing an investigation on someone's immigration status. I'm only serving detainers when someone that we know through a system has a detainer. We would be racially profiling if we chose to just call immigration and say this person doesn't sound or look like he belongs in this country. So they had to know that he had an F1 visa because they have 287G. I wouldn't know it. I only know that there's a detainer when we serve it because ICE has a detainer for him.
We can take this off. I mean, you knew he had an F1. You had an F1 when he was in your custody. You said so.
Correct.
But so you knew he was convicted of a felony.
Nobody else has access to those databases to check, to fingerprint, to verify.
We can take this offline, but
yes, sir.
We'll all right. Is anyone any other further questions? Okay. All right. Thank you all very much. Thank you. It's been long. So, Madam County Executive, look, I didn't know you were here to testify to this on the last page. You would have been up in this panel, but come on up, please. My apologies for that. That's on me.
That's okay. I won't hold it against you.
Please don't. And then we have one other person. We had Deweese is Shirai Rendell again.
Good evening. It's been a long day. This is like one of my council meetings back home. I'm Julie Giordano. I'm the county executive in Wacomico County. And I do want to just clarify one thing. Wacomico County, no, that's okay. Wacomico County is now pending for 287G. So I just wanted to let you know. Public safety is not a partisan issue. It is not a campaign slogan, and it is not an abstract talking point debated in distant political circles. It is deeply personal. And public safety is the foundation upon which freedom, opportunity, and prosperity are built. Without it, nothing else matters. And that is why I strongly and unequivocally oppose Senate Bill 245. This legislation prohibiting the state of Maryland and local governments from entering into immigration enforcement agreements with federal authorities means criminals who are in our jail could be released back into your neighborhood. And it also means that violent offenders and repeat criminals could be returned to your streets. This bill does not make Maryland safer. This bill does not make Wacomico County safer. It makes our citizens and communities more vulnerable. 287G and other immigration enforcement agreements are the only guardrails I have against ICE, and you're taking them away. Dangerous offenders can be handled safely and securely without putting my public at risk, rather than being forced into our neighborhoods, workplaces, and schools. These agreements allow correctional officers to do their job in a controlled environment where criminals are already in custody and where arrests can be made without endangering innocent families or community members. Do not take this away. Mr. Chair, I respectfully disagree with this legislation, but I do respect your position. However, I want this committee to fully understand the real-world consequences of what is being proposed. This bill does not eliminate ICE. It does not stop immigration enforcement. What it does is that it strips counties and correctional officers and elected officials the ability to cooperate and coordinate with federal authorities in a responsible, structured, and transparent way. When that partnership is taken away, ICE is not prevented from operating. They're simply pushed out of secure detention facilities and into my community. If this bill passes, there will be more home arrests, more workplace raids, more neighborhood enforcement actions, and more uncertainty for law-abiding residents. It shifts enforcement from controlled jail settings into public spaces, creating fear, instability, and unnecessary risk for everyone involved. And I cannot imagine anyone in this room being wanting to be responsible for that. Without these agreements, I fear we are inviting chaos into our communities. We are removing the very safeguards that allow our correctional officers to protect public safety while maintaining order and accountability. This legislation hurts Marylanders. It will only hurt our counties, and it will make my community less safe, and I plead for an unfavorable report. Thank you. Let me stay up here.
Good evening, Chairman Smith and other distinguished members of the committee. Again, my name is Sherry Rendell. I am the Director of State and Local Engagement for the Federation for American Immigration Reform. And the previous person just gave you a lot of my initial remarks, but one of the things I did want to talk about is advocates for eliminating 287G program claim that cooperation with ICE builds distrust in the community and discourages illegal aliens from reporting crimes. However, in a 2021 study by the National Crime Victimization Survey, it showed that there were more likely, illegal aliens were more likely than American citizens to report crime, or at least as likely. This was a study that was conducted from 2017 through 2019, which was the first Trump administration. Among some of the findings were 62% of all serious crimes against all immigrant citizens and non-citizens were reported to the police. This compared with just 53% of serious crimes against native-born Americans, which is statistically a significant difference. 57% of serious crimes against non-citizen immigrants and against Hispanic non-citizens were reported to the police, which is statistically equal to the 53% reporting rate for native-born Americans. Moreover, if illegal aliens cooperate with law enforcement, they may be eligible for an STU or VAWA non-immigrant visa, which in turn allows them to apply for permanent legal status in the United States. The bottom line, the 287G program in Maryland is only initiated once an individual is in custody, and it prevents correctional officers from releasing criminals back onto the streets and makes it much safer for the community. I know that there was, I urge the committee to vote an unfavorable on this bill. And if you would give me 30 seconds?
No, if you're going to respond to something, just succinctly testimony. If there's a question from the member, I'll thank you very much. Is there Senator Henson?
Thank you. For the county executive.
Yes, ma'am.
Yes. We heard testimony from someone about what sounds like a large Haitian population that's in Wacomico County. She mentioned that 200 plus Haitian immigrants are there and they work in the poultry industry in Wacomico County. And she testified about people feeling like they had really raised their voices about not wanting 287G agreements. And they felt that they had brought an effective end to the county's pursuit of that program. And I heard in your testimony that you are pursuing that program and that it is pending.
Yes, ma'am.
Did I understand that right?
Yes, ma'am.
Okay. A lot of what you shared, though, I do agree with some of what you said. I think if we have a federal administration that is determined to meet their numbers and kind of get their pound of flesh, and if they're going to do that one way or another, whether it's taking people who are trying to cooperate, who are here on expired visas but have committed no crimes, like a gentleman in my county, Anne Arundel County, on Christmas Eve. He was in his community in his vehicle. ICE was there in the community. They said they were doing targeted enforcement. He had simply overstayed his visa. ICE came to question him. They busted out the window in his car, and when they did that, he went to accelerate and take off in the vehicle, and ICE then opened fire on his vehicle, similar to something we saw tragically in the loss of life in Minnesota, happened right here in Anne Arundel County, Maryland. He did not lose his life, but he was taken into custody and someone else was injured as well. But what my question for you is, if you are pursuing the 287G agreements, and we understand that the Haitian population is a significant portion of the labor force for the poultry industry, which is a significant portion of the economy for your county, how do you plan to restore that confidence and build bridges with that community to make sure that you can still rely on them for a labor force?
Yeah, no, thank you so much for that question. Right now, we are looking at the warrant service officer model, and so it will only be people who decide that they want to frequent our correctional facility. So if our Haitian population is here legally and they are working every day, they have nothing to worry about.
What I heard, though, is that they saw what they perceived as the county's withdrawing from pursuing that program as a sign of good faith, and they thought that that meant that they were safe. And what I hear you saying is you, in fact, haven't withdrawn from that. You are still pursuing it. So I get the reality, but I think the perception is if you're pursuing it, that they are not safe and they don't feel welcome. So if that's their perception, how do you plan to restore that so that you can keep them there so that everyone can coexist in what sounds like a mutually beneficial relationship?
Right. I think there was some misconception on that. So we never withdrew from any agreement. There was never agreement put into place to withdraw from. It was something that we discussed, and we had it at a county council meeting. So there, people were able to come and say how they felt about it. There were a lot of people from our community that were against it, but I will tell you, I had probably 3 times the amount that are in favor of it. So as the county executive who oversees the entire county, I have to take all of those things into consideration. Our Haitian population is welcome. I very much appreciate them. I have meetings with them. I've met with them numerous times, but I have to promote legal immigration here, ma'am. So as long as they are here legally, whether it's work visa or if they're American citizen, we welcome them. We absolutely do. But I cannot promote illegal immigration, and I absolutely cannot promote additional crimes being committed in my community.
I think that's the goal of every member, certainly of this committee, and I think we heard models like Montgomery County that has set up a model where they certainly are promoting people being here legally, and then also promoting people being law-abiding while being here under a documented status as well. So I do think there are models out there where you can have both of those goals served at the same time. I know when I leave here, I plan to get something delicious, and it might be chicken. So hopefully, and
hopefully it's Purdue.
The outsized role that you play as the Wacomico County executive in making sure that that resource that's a part of our state is available for all of us. Hopefully there's a way to make sure that the population that's needed to make sure we all can benefit from that. Hopefully there's a way to restore that confidence and build that bridge so that we don't lose that mutually beneficial relationship. But I appreciate your testimony and you hanging in there with us because it has been a long day.
It has, yeah, and thank you very much. I will say, just in response to that, so as I said, our Haitian population is a big, it's definitely an integral part of Wacomico County, and they have a large presence, and we work with them all the time. I know my sheriff was here earlier. He was, he had to leave, unfortunately. He has a good working relationship with them as well. But I will tell you, my goal and our sheriff's goal is to keep our community safe. And again, what I am saying to this committee is I am very concerned. I think there's a lot of misconception. I think the people in this audience think that you are getting rid of ICE, and you're not. You're not getting rid of ICE in Maryland. And what you're doing, unfortunately, is taking away guardrails that I have right now with 287G and what these other counties have with 287G. And I'm sure these sheriffs in the back would say that. The very thing that's going to keep them under wraps, you're taking away. And I'm asking you not to do that, or at least to think about it, and make some amendments to this. Because what's going to happen is, and Tom Honan has said it, they're coming. If they don't allow us in the jails, they are coming in our community. So, ma'am, in all honesty, I'm trying to protect my Haitian community. And when people come into Wacomico County, they are welcome, but we expect you to behave. You cannot come in here illegally and then also commit crimes in my community. You absolutely cannot.
All right. Further questions from the committee? Sorry, Senator Sidnor.
Thank you. There was, and this is for the county executive?
Yes, sir.
Good evening. There was a story that had recently come out about a Salisbury man who, I guess, lost his wife was arrested, and then he lost his son. I'm assuming you're...
I'm very familiar with the case, sir, yes.
Would you mind sharing with the committee what this was about?
Sure, absolutely. There was There was a woman in our community. She was she was not with this person, her husband. Actually, the child who she was dropping off to school, the child's father, is actually the one that called immigration on her. She did have a felony charge that was pled down to a misdemeanor, and she was also not following a court-ordered child support agreement. So ICE was called by actually the child's father, and ICE came and detained her, yes.
Thank you.
Sure.
All right. Seeing no further questions, thank you both
Yep, thank
very
you,
much.
sir.
Thank you.
Good to
Madam
see you.
Secretary. Good to see you, likewise. All right, with that, that will conclude the testimony for Senate Bill 245 and the hearings for the day.